Good morning. I declare open this hearing of the Senate Community Affairs Legislation Committee's inquiry into the National Disability Insurance Scheme Amendment Securing the NDIS for Future Generations Bill 2026. I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing via video conference and in person. I am Senator Ellie Whittaker, Chair of the committee, and will shortly have with me Senator Steele John in the room and Senators Tyrrell and Antic joining us online. These are public proceedings being audio streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to be requested to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. I remind committee members and witnesses who are appearing via teleconference and who are not speaking to mute their microphones. I now welcome representatives from VertiView Group. Thank you for appearing before the committee today. I understand that information on parliamentary privilege and the protection of and obligation of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
My name is Damien Bell. I'm the Group CEO of the VertiView Group.
Thank you very much. I will now invite you to make a short opening statement, and at the conclusion of any remarks, I will invite members of the committee to ask questions. Over to you.
Thank you. Thank you, Chair and members of the committee, for the opportunity to appear today. VertiView is a not-for-profit group of 6 entities spanning disability services, integrated mental health, in-home aged care, positive behaviour support and support coordination services. We support more than 8,000 people across Queensland, New South Wales, Victoria and Tasmania, with a workforce of around 2,400 people. I acknowledge that the committee has heard directly from a range of individuals, families and industry representatives affected by these reforms. Their concerns are genuinely held, and I do not in any way diminish them. My remarks today are offered from a sector and provider perspective, with a focus on the sustainability of the scheme, the sector that delivers it, and the fact that an unviable or at worst failed scheme is not in the interests of the people we are dedicated to supporting. We support the government's reform agenda, and on balance, with a view to the sustainability of the scheme, this bill as amended following these Senate committee hearings. Public support for a scheme costing more than $50 billion a year rests on community confidence that the funding is reaching the people the scheme was designed for. Bringing cost growth down is necessary to secure the sustainability of the scheme. Our view is that these sustainability measures will require providers, especially not-for-profit providers, to change the way they operate. We will need to innovate based on the funding available, and we will need to scale in order to achieve efficiencies and ongoing viability. At VertiView Group, we have proven that scale is key to financial viability. Smaller providers carry the same payroll, IT, compliance and quality obligations as larger ones, yet often without the revenue base to properly fund them. VertiView has moved from a deficit position to a modest surplus by bringing providers together under a single structure and shared back office services. We also see the need to redesign services to meet the funding envelope, rather than continue with historical service delivery models that require the higher levels of support of ratios of 1-to-1 or others, and funding. For example, this could include reinvigorating community hubs and social community participation to make budgets go further. We also need to continue to work with government in real time to manage the risks and unintended consequences that are not only present now, but naturally arise in a significant change program such as this. Providers with clinical governance capability and visibility across thousands of participants can help government identify these risks early and manage them better. Through scale, service redesign, innovation and risk management, I believe these reforms can succeed and secure the sustainability of the NDIS into the future. I'm pleased to take the committee's questions.
Thank you, Mr Bell. I'm going to pass the call first to Senator Tyrrell. You're still muted, Senator Tyrrell. Apologies.
I'm the one who should apologise.
Thank you go.
President. Yeah. Mr Bell, thanks for coming in this morning. Appreciate it. Can you please speak to the way in which VertiView has achieved viability in the NDIS market by bringing providers together in a group structure, and how has this benefited participants and improved the quality of supports that you've provided?
Thank you for the question, Senator. We have provided the sustainability of the range of entities that have joined the group, and we describe organisations that come to the group as joining VertiView Group. We don't like mergers and acquisitions necessarily. By joining the group, we're able to centralise the shared services functions. That's all of those back office things like HR, IT, finance, and also clinical governance. And so when we're able to centralise and share that cost burden across 6 entities, we're able to lower that cost to serve in some industries, particularly the disability sector, quite markedly, to be able to have a viable proposition, not just economically, but to be able to invest in quality of services and engage in departments that others probably don't have the financial capability to do, such as quality and safeguarding.
Perfect. What kind of market design do you think would best deliver a robust scheme that deliver high quality supports for the participants?
Market design's a great point and it's a great question. It's something that coming into the industry almost a year and a half ago, I was looking for. I was looking for an industry that was $50 billion spend, and how is it structured and how does it work? And I was quite surprised, to be honest and fair, that there didn't appear to be a structured market design, nor does there appear to be a target design for the future state of the industry. In my own personal experiences and views, I would see that the industry would be benefited from consolidation at the larger end of providers, often in industries which are highly regulated and as large as we are. You often see what the finance industry would call pillars, what the defence industry would call primes. These sorts of organisations that are large scaled and provide not just a baseline for the industry, but also an access point for government to make sure that the efforts of the government in terms of consultations and so forth are effectively held with a group of large-scale providers. And so the market design that I think would be appropriate, and again, I'm not a specialist in market design, the Treasury are no doubt probably considering this at the moment. I do see a role for the small players, the local people that have that local touch. There is not a design that I think that would take that away. Where I see the market design changing is in the middle space, especially around the smaller not-for-profits who just won't be able to maintain viability. Not now. You've heard from many other people at the moment that these participants or providers are simply not viable, to the extent that you've been told by other presenters that they're on the edge of failure, large-scale failures. I don't dispute that at all. In fact, I know that it would be a very big challenge for organisations that are lacking in scale to be keeping up with the regulatory requirements to maintain quality, for example, but also how do you fund the organisation for the efficiencies that you naturally need to be sustainable? One of the examples there is that where you have a smaller organisation, let's say, for example, you're turning over $10 or $20 million. If you're investing 2% of your turnover in systems and efficiency and quality, which I'd say is probably the minimum you would, the amount that is generated off a 10 million turnover just isn't simply enough to maintain or build the efficiencies that you will need to keep up with the gap between the rate at which your revenue rises relative to your cost. And I think that's probably the point that I would and I have talked to most of the industry and at length about this idea of this idea of negative jaws. We have a position in the industry where costs are rising at a faster rate than revenues, or the price for which our services are charged. That negative gap is, at my best guess, somewhere between 2 and 3%, depending on the provider. If any other business was operating at a negative 2 to 3% differential each year on year, it becomes almost a mathematical certainty that you will not exist at a certain point. You will use up your cash reserves to fund your operating deficits, and you've heard from other people who've appeared before you that they're selling properties to fund those deficits. And that's very much a finite game. They've done their best, their hearts are in the right place, they've dedicated themselves to delivering quality supports and services, but unfortunately the maths is relatively simple. At a certain point in time, their costs will exceed their revenues and they will be unsustainable.
Thank you. You've had some concerns around like the funding, which you've just pointed out, but you've also had concerns around people that have not been treating the system with respect financially. Is that true?
That's fair to say, yes.
Yeah.
Yes.
Yeah.
I think, sorry.
No, I wasn't going to say anything. I was just going to say, could you sort of like speak to that and solutions that you could see of how
it's a very good point, Senator, because I think people use the word fraud very openly, and I don't like to use the word fraud as a blanket statement across a lot of different things. I think you could probably label some of it misuse or use that wasn't aligned to purpose of the scheme originally. We all have heard the anecdotes of different people using plans for different things, and that's been surprising over the years. That has been tightened over the last few years, though. I think more work can be done around the types of funding, and I certainly think community expectations for which the funding is allocated relative to the sorts of supports that it is used to purchase. And I think that's fair in reasons because the community that supported this fund did it on the basis that it was the right thing to do. It had great social licence. It's a flagship global platform and a global program that we should rightly be very, very proud of, and we should rightly be as protective of to ensure that it continues to exist generation on generation. To do that, I believe we should return it to the original purpose of the scheme. And I think any moves towards that return to original purpose is very helpful, including tightening fraud measures, tightening the types of activities that align with community expectations for supports, and making sure that the scheme is viable for generations to come so that the people who are coming into the system right now can rely on it in 10, 20 and 30 years from now.
Okay. I believe I've also had questions around like research and development within the sector as well that you've been trying to push and promote. Is that true?
Yes, we have our own. One of the benefits of scale we mentioned before is we have our own internal research department. So we have people with postgraduates and PhDs who that they've got a great saying that when you ask the chap what he does for a living, he says, "I read things so you don't have to." And so we gather all the available information, peer-reviewed work product. We present at conferences. So we are very much wanting to lead not just the thought leadership, but the application of actual peer-reviewed evidence-based therapies into practice and practical applications. It's why sometimes we've taken the hard decision to end certain therapies because there were certain things that we thought we couldn't justify on a peer-reviewed basis that actually added real technical value. And so those are the sorts of decisions that organisations like us and many others will need to make around what can we afford to fund, what is good practice, and how do we demonstrate good practice? One of the challenges that I've seen coming into the industry is the industry, I think, has work to do on describing and demonstrating what quality looks like. And I think moving forward in the scheme, I think that's something that both the organisations like NDIS and AFA can be very valuable, and organisations, the larger not-for-profits, can assist the government in understanding what quality looks like and then hopefully pricing for quality. I think one of the benefits of the bill before us is that I actually have more confidence in a ministerial pricing model or ministerial control than the agency one-size-fits-all. And I think that there's a danger in that we treat 1 hour of service the same in every location all the time. It's just not true. And I do think that there's an opportunity with that change in pricing dynamic to seek to solve some of the thin market problems by potentially going to commissioning and those sorts of things, where we know that an hour of service from an occupational therapist in Boulia is very, very different from an hour in Richmond in Melbourne, in suburban Melbourne. They are fundamentally different prices. They are different challenges. We should work with that price modelling to make sure that those people in Boulia have access to the same types of therapy that someone in Richmond and Melbourne does, but understand that that service needs to be viable. And I think this committee's also heard from the therapists as well, the OTs, the speechies, those guys. They need to be viable. And I think a dynamic pricing arrangement that's more more adaptable is better for the system and better for the scheme overall, to make sure that you have the range of providers that are qualified in delivering those fantastic services that are truly viable at the same time. By comparison or by analogy, holding pricing steady for 5, 6, 8 years demonstrates that provider is on a crash course to determining whether they stay in the industry or not. And I think you've heard testimony yourselves about the challenges with physios, OT, speechies, exiting the industry. And you've seen other service sectors within the scheme doing the same thing. Support coordination is another one. Support coordination, we are one of the largest providers of support coordination in the nation now. We are currently in discussion with 7 different groups, with them trying to exit the industry and exit support coordination entirely. It's unsustainably priced. It hasn't had a price increase for many, many years, while our actual increase, our prices, our staff wages, everything else has gone up. So something has to give on that. And I think dealing with a minister who's accountable rather than an agency that's relatively faceless gives the industry and the scheme the best chance for being sustainable long term.
Thanks, Mr Bell. Thank you, Chair.
Thank you, Senator Tyrrell. I will now give the call to Senator Steele-John.
Thank you. Thank you, Mr Bell. I want to take you to your submission. You say in your submission, and I will quote you directly, you say, quote, any significant change to the NDIS will include risks and unintended consequences. By working with the provider sector, government can quickly identify and manage risks as they arise. For example, an anticipated risk is for participants with psychosocial disabilities. In many cases, the social and community participation supports for these participants currently provide, you say, a level of regular contact and monitoring for their treatment and consistency with medication. Funding reductions may see regular contact reduce, and with this, the risk of a participant coming off their medication increases. In this example, the participant may place greater demands on other parts of the health system. For example, presenting to hospital and other social services, and in extreme cases, posing a safety risk to the community, end quote. Now, you say it's quite easy to mitigate risks such as this. How would you mitigate this one?
I'm not sure I said it was easy to mitigate risks.
Well, that's certainly the tenor and tone of your submission.
When we talk about the risks and the mitigation, what I'm referring to there is service redesign. I can give you an example that's practical. And I do take your point about demand and supply. We're talking about reducing supply for a demand. It is likely, and I've expressed this point to departments and others, that some of that demand will reappear in other areas of the system. I think that is well understood and has been expressed to you previously, but perhaps not at a 1-to-1 ratio, but it will reappear at some stages, whether it's social services or other different areas. So I do take your point on demand and supply and that demand being looking for somewhere else.
Just to be clear, Mr Bell, what I'm bringing you to, and again, this is your submission, you're saying in this submission that participants with psychosocial disabilities currently part of the benefit they get out of social and community participation supports they're funded for is that they get regular contact with other people, having beneficiary effects such as ensuring they are continuing to stay on their medication, for want of a better word, and that cuts in that support, cuts proposed by the government via this legislation, could see that human contact decrease, leading to risks such as them not taking their medication effectively as instructed, with the flow-through impact that they end up in hospital or relying on other social services or posing other risks to themselves or to the community. That's the risk that you've identified, and it's a risk you suggest can be mitigated. So my question to you is, how are you proposing that risk be mitigated? Not service design. How are you proposing it be mitigated in that specific example?
I think I would take you to service design as the mitigant. I'll give you an example, if I could, where a participant perhaps might be funded for, and this is very simplistic, but it's for demonstration purposes only, and to take me that please. Where a person may be funded for 10 hours per week, let's say, for example, at the moment, and that were to be cut to 6 hours. The way the economics and the practice would work is we would then look to redesign that service around capacity building, rather than servicing to ensure that particular boxes are ticked on tasks. We would look to capacity build individuals to make them better able to maintain their own medications, to maintain social contacts.
And that's an example, Mr. Bell, of how you would mitigate a risk in an example. I want you to tell me how you mitigate the risk in the literal example you've given us. So you've given us an example of a psychosocial participant who experiences social contact regularly because of social and community participation funding. You've identified that this legislation poses a risk to that person in the form of that funding being reduced, but you are suggesting that that risk can be mitigated for that participant in that example. Yes. So I'm asking you how you do in that specific example.
And Senator, I'm seeking to answer your question by the way we would approach and mitigate that risk is by capacity building, so that that person is learned and capable of medicating and taking medications on a less monitored basis where appropriate, and also making sure that they are available or they are directed to any other sources of social help where they need to, where their supports are unavailable, just like they would in the hours that we are not present with them as well.
But so capacity building is also going to be cut by 10%.
That may be correct, and this is why we will be redesigning the services to fit the available budgets. The point that I'm making there is that I think that it is imperative that the industry understands the dynamic and the restrictions and redesign services to make sure that the service levels are maintained as best we can and help identify these risks with the government and source the solutions to them. Okay,
so you're talking about design, you're talking about working with government. There seems to be quite a disconnect between what you've actually given us, the human example you've given us in your submission, and what you've just said to us, because surely if you've identified this risk as you have, you surely would attempt to prevent this situation occurring before the passage of the legislation. Why do the redesign once the participant is at risk?
We're not. I'm explaining to you how we would redesign services to change the design based on a funding requirement. The funding requirements are changing now. We're not waiting for the bill to redesign services.
But you're sitting here today advocating that the legislation pass, correct?
As amended following the Senate hearings?
Yes. So there's been a series of amendments made to the legislation already.
And any others that you would see fit to be seeking to make following these hearings as well.
Right, so your support of this legislation is based on amendments that you haven't seen?
Well, my support for the bill, Senator, is that I have faith and confidence in this committee, the ministers and the Australian Parliament to deliver a best balanced outcome for participants, to the community, to the taxpayers and participants, and balance those interests in the interests of the sustainability of the scheme long term.
So how are you suggesting the legislation be amended to manage this risk?
I'm saying we would change our business practice to manage this risk as best we can. My example
As best
is that
you can.
my example is given to you as to what how an industry would react to that change and how we would mitigate that risk and seek to mitigate that risks.
You seek to mitigate is not the same as successfully mitigate, though, is it, Mr. Bell?
I can't give you absolutes, I'm sorry, Senator, on any supports or mitigants. They just, unfortunately, don't exist.
So you can't guarantee that, subject to the passage of this legislation, you would be able to mitigate the risk you've identified to a participant who...
I couldn't guarantee you that I could mitigate every risk in our business on every day of the week either. It's the nature of the business that we operate in. We are incredibly focused on quality, on support. We are scaled. We are collectively as a group over 200 years of legacy and experience, dedication to continue, dedicated to be sustainable for decades to come as well. There are no guarantees. We work as best we can under all of the regulatory guidance, and all the regulatory frameworks that we do are compliant. We're registered, we're compliant, we're audited. There are no guarantees, unfortunately, but we absolutely think that the redesign of the services can help those situations. And in fact, we aren't waiting for the bill to do those activities because we've seen the reduction in plans already.
And that is precisely my point, Mr. Bell. You've identified for us a specific risk to a specific type of participant, a specific person that your entity supports. And yet you can't guarantee that should this legislation pass, you will be able to mitigate a serious risk to their health and safety. And yet you've come before us today without a specific set of legislative amendments that you would like to see pass that would guarantee that person's safety and the mitigation of the risk. You're just saying to us, well, you as an organisation trust the government to solve a problem.
Senator, I can't guarantee you before the bill. I can't guarantee you today that the cuts are taking place to plans as we speak. We are needing to redesign services now. So the bill doesn't impact on our desire to mitigate risk. I can't guarantee you today. I couldn't guarantee you in next week. But we're taking those actions at the moment.
You're not suggesting to me, Mr. Bell, are you, that the government's implementing this legislation?
Oh, by no means, no. In fact, I'm quite confident they are not. I'm quite confident that the agency themselves are implementing plan reductions. We see it daily and weekly. That's no secret. Many people have come before you and have told you that's taking place.
Yeah, and we are not conducting an inquiry, unfortunately. I'd love to, into the broader dynamic of agency cuts. We're looking at what this legislation could do, particularly a unilateral across-the-board 50% reduction in the very type of support you've identified as being necessary to the people your company works with to enable and ensure that they continue to take their medication regularly, keeping them and others safe. And so I've asked you repeatedly now to identify for us as a committee either the amendments we should propose to this legislation to mitigate the risk to those participants, or the ways in which you propose in that situation where the bill passes, you would mitigate those risks. And you have said you are unable to give us a guarantee that you can recommend them, you can mitigate those risks, and aren't able to identify the amendments that would enable you to do so.
But I take you back to my comment and response around the mitigant and the service redesign. Those services, the mitigants are in place. I can guarantee you we will mitigate risk, but I can't give you a guarantee that there's some scenario where there is zero risk. We mitigate risk every day. Training, quality, standards, scale, all of those things are mitigants to making sure that we can deliver the best quality of service possible. I can't give a guarantee of a risk-free environment.
Thank you very much, Chair. Appreciate it.
Thank you for your time today, Mr. Bell, and your evidence. The committee will report to the Senate on the 14th of August 2026 and has agreed that responses to any questions on notice should be provided by close of business Thursday, the 6th of August 2026, although I don't think you took any questions on notice, but nevertheless, thank you very much for your time and your evidence this morning. I now welcome representatives from MedTech Vic at Swinburne University of Technology, the University of Technology Sydney Human Technology Institute, and the University of Sydney Centre for Disability Research and Policy. I understand we have a number of witnesses appearing by video conference and some in the room. I understand that information on parliamentary privilege and the protection of and obligation of witnesses giving evidence to Senate committees has been provided to you, and I thank you for appearing before the committee today. For the Hansard record, I will ask each of you to state your full name and the capacity in which you appear today, and I will begin in the room with Professor McDonald.
Hi, my name is Professor Rachel McDonald, and I'm appearing as the Director of the MedTech Vic Hub, which is a research and development centre at the Swinburne University of Technology.
Thank you very much. Representatives from the University of Technology Sydney Human Technology Institute.
Yes, good morning. My name is Professor Edward Santo. I am Co-Director of the UTS Human Technology Institute.
And I am Sarah Sacher. I'm a Senior Policy Specialist at the Human Technology Institute at UTS.
Thank you both. University of Sydney Centre for Disability Research and Policy.
Good morning. My name is Associate Professor Shane Clifton. I'm the Director of the Centre for Disability Research and Policy at the University of Sydney.
And good morning. My name is Associate Professor Kim Bulkley. I'm with the Centre for Disability Research and Policy as well.
Thank you very much. I now invite you each to make a short opening statement, and at the conclusion of those remarks, I will ask members of the committee to ask questions. I'll again start in the room with Professor McDonald.
Thank you very much, Chair and Senators. Thank you very much for the opportunity to present today. As I said, my name is Rachel McDonald, Director of MedTech Vic. MedTech Vic works at the intersection of disability rehabilitation, assistive technology, engineering and research translation, and we work alongside people with disability, clinicians, researchers, industry and government. The central proposition in our submission is that the future of the NDIS will not be secured by making the scheme smaller in ambition. It will be secured by making the scheme better at building capability, independence and participation. MedTech Vic supports the need for sustainability, but sustainability cannot simply mean controlling what the scheme spends today. If we fail to invest in the supports, technology and environments that enable independence, function and participation, we do not remove need. We simply shift the cost onto families, hospitals and other government systems. This is particularly important when we talk about functional assessment. Function is not fixed. If we ignore this, we risk measuring the consequences of inadequate support and calling that a person's capacity. This is neither good assessment nor is it good economics. We support foundational supports, but people cannot be transitioned to services that do not yet exist. Rehabilitation, communication supports, assistive tech and appropriately skilled workforce need to be available, accessible and funded before people are expected to rely upon them. Most importantly, we work alongside people with disability with lived expertise, ideas and experience who should be partners, leaders and innovators in shaping the technologies and supports that affect their lives. At MedTech Vic, we see what happens when we bring these people together to solve real problems, whether this is complex wheelchair seating and postural management, safer mobility and access, or developing and evaluating new assistive technologies. And we have one consistent lesson, and that is that co-design is not a courtesy, it's a safeguard. People with disability should be partners and leaders in designing the supports and technologies that affect their lives. Our submission asks government to think differently about technology and innovation. Technology and supports are not simply cost to the scheme. Done well, they are the infrastructure for independence and participation. And Australia should be designing, testing, evaluating and manufacturing disability supports and technology here with people with disability and building Australian expertise and sovereign capability rather than simply importing solutions that are developed elsewhere. And this is becoming increasingly urgent with new AI, health technologies, etc. So we ask the committee to judge these reforms not only by how they reduce expenditure, but whether they build capacity and capability. whether they increase people's independence and participation, and whether they create access to the supports and technologies that people need to live the lives they choose. What we need now is the national leadership to connect the ecosystem to do this, and this is the opportunity in front of us and what securing the NDIS for future generations should mean. Thank you.
Thank you, Professor McDonald, for that opening statement. Either Professor Santo or Ms Seisha, would either or both of you like to provide an opening statement?
Thank you, Chair. I can provide a statement on behalf of our institute. Our submission focuses on the automated decision-making, or ADM, provisions in the NDIS bill. We recognise that ADM can reduce the cost of decision-making for taxpayers, and in some instances it can lead to better decisions for the community. However, there are numerous examples of ADM going wrong, causing catastrophic human and economic impacts. In my former role as Australia's Human Rights Commissioner, I saw firsthand how ADM in robo-debt caused enormous harm to Australians. So the government's ADM goals can be realised only if effective safeguards are provided for in law, in how decisions are made, and in the accountability and oversight mechanisms. The Robo-debt Royal Commission made clear that special caution is needed when automating decisions that engage people's most basic human rights. We've got to apply that caution to the NDIS because decisions there determine the support people with disability can access to ensure a dignified and meaningful life. In essence, this bill is facilitative. It enables ADM. The bill provides clear statutory permission for ADM to be used throughout the NDIS. However, the bill lacks many fundamental safeguards needed for ADM, especially for decisions that affect the lives of people with disability and their families. As our submission outlines in detail, we've got 5 main concerns. First, the bill hands responsibility to the Minister to specify which types of NDIS decision may be automated, but it's Parliament that should make that determination. Instead, by delegating to the Minister which types of decision are safe to automate, that brings a much lower level of democratic scrutiny. Second, we acknowledge that routine, non-evaluative decisions can be well suited to ADM, but the bill goes much further than that. It allows discretionary decisions to be automated. And as the Royal Commission into robo-debt made clear, automating discretion is much more dangerous and difficult. So any automation of discretion should be very carefully scrutinised and should come with additional accountability safeguards. But the bill provides almost none. Third, the explanatory memorandum claims that the bill doesn't reduce merits review for ADM. However, it removes the most important form of merits review, that is, internal review of automated decisions. The fact that the NDIA CEO may choose to substitute decisions at their absolute discretion is, of course, no substitute for genuine internal merits review. Fourth, the bill should require minimum standards for accountability for all automated decisions. And finally, we've more recently considered the issue of ministerial support determinations. We urge that where there has been an automated change to a person's plan based on one of those determinations, review should be made available also where it could affect the safety of the individual or where it could cause undue hardship to the individual or their family. Thank you, Chair.
Thank you very much. We'll ask Associate Professor Shane Clifton or Associate Professor Kim Buckley to provide an opening statement for the University of Sydney Centre for Disability Research and Policy.
Thank you, Chair and committee members, for the opportunity to speak today. I speak alongside my colleague Kim Buckley from the CDRP, and we start by noting that we support the need for NDIS reforms to ensure the scheme is sustainable, transparent, fair and effective. However, sustainability requires targeted policy, not blunt instruments, and we hold, I guess, 2 primary concerns. First, we're deeply concerned by proposed cuts to social and community participation. Community participation gets to the heart of the NDIS. The scheme is not meant to get us out of bed and leave us stuck in our homes, but to facilitate inclusion. Applying a blanket approach also disproportionately harms participants with intellectual disability, psychosocial disability, and autism. Financial savings are minimal, yet the risks are severe, compounded by a lack of appeal mechanisms. Community connection isn't a luxury, it's a vital protective factor. As the Disability Royal Commission highlighted, active participation in the community safeguards against violence, abuse, neglect and exploitation. Crucially, cutting these supports does not necessarily eliminate costs. Rather, it frequently shifts them. For participants in supported independent living, it risks pushing unfunded hours directly onto housing rosters. For those living at home, it often forces families and informal carers to step in and step back from the workforce to fill gaps, accelerating carer burnout and ultimately driving individuals into higher intensity, higher cost supports down the track. That's especially true for people with psychosocial disability and intellectual disability. Second, foundational supports are simply not yet ready. The vision of a broader ecosystem of localised, responsive supports available to all people with disability, not just those on the NDIS, is sound and important. It's one of the losses in recent years that must be rectified. Yet these supports just don't exist. Until foundational supports are fully funded, high quality and co-designed with people with disability, cutting individuals off from NDIS supports creates a dangerous vacuum. People who are ineligible for the scheme or whose packages are reduced will have nowhere to turn. So we urge the committee to ensure efforts to stabilise the scheme do not compromise participant safety or undermine inclusion. Thank you.
Thank you very much. I will pass the call to Senator Pocock.
Thank you, Chair. Thank you all very much for your time this morning and for your submissions. I wanted to start with UTS. Thank you for the work that you're doing in this area and your submission. You've described the breadth of these automation provisions as unprecedented in Australian law, and said that the bill allows the Minister to automate any decision made in the NDIS, including decisions that require discretion. The Robodebt Royal Commission recommendations have come up a number of times in this inquiry so far, and you said that the Royal Commission made warnings about the automation of discretion. I was wondering if you could give us an example of a discretionary decision that could be made by ADM following the passage of this bill, and what the risks would be of making that decision in an automated way.
Thank you, Senator. Subject to the Minister's determination, almost any major decision that affects individuals under the NDIS could be made in an automated way. And the point that we are particularly concerned about there is that every individual has their own needs. And we know that particularly with disability, that to reduce someone to their kind of diagnosis or their particular kind of impairments is not just dehumanising, it is also just a recipe for inaccuracy and for error. In other words, one person who may have a neurodiversity diagnosis may have a particular set of needs, and another person will have very different needs. And I think one of the ways in which the NDIS has been a beacon of light, not just within Australia but in other parts of the world, is that it is capable of making individualised decisions. If, by contrast, you give to a machine the task of exercising discretion, then what you're much more likely to do to make that possible is you basically treat people as categories or sort of subgroups. That is much more likely to mean that you're not fair and you don't provide for people's individual needs. So in addition to the Robodebt Royal Commission, you've had numerous oversight bodies, including my former position as Human Rights Commissioner, but also the Commonwealth Ombudsman, the New South Wales Ombudsman. They've all sounded the alarm about this sort of automation of discretion.
And so should the Senate be more concerned about individual errors or the possibility of producing harmful decisions at scale, given it's going to be the same tool used?
Look, I think that the latter concern is a really serious one. By treating people in categories and making decisions automatically, the risk that introduces is that you make a lot of errors very, very quickly. And we saw that with Robodebt. So what's the response to that? Let me be very clear. We are not saying that all forms of automation are inappropriate. There are some forms of automation, particularly if what you're really doing is a calculation. So as we say in our submission, if you've got some complex, calculation, you're adding up a series of numbers, don't trust a human like me to do that. Of course, that should be done in an automatic way. If you're determining whether someone is on a particular database, that's something that, again, is suitable for automation. But if what you're really trying to do is weigh up a number of factors, generally that is much harder to do by automation. So what I think really well-balanced governments do is that they say, okay, there are some types of decision that are appropriate for automation and they should be kind of prioritised. And then there are other decisions that need to be made by humans, or even parts of decisions that need to be made by humans. And that is what the bill fails to do now, but it should be amended to do.
One of the things I'm really concerned about is that the government, just like they say with the aged care integrated assessment tool, they say, well, humans will remain involved. And it seems to me, and you've made the point in your submission, that human involvement only provides meaningful oversight if the person has the authority and practical ability to depart from or override a computer-generated outcome. And so with this bill and with the powers that are being handed to the minister, what would genuine human oversight look like, and how does that compare with the model being contemplated in this bill as it is currently written?
Yeah, look, I might start answering that question and then hand over to my colleague. The first point I would make is that the explanatory memorandum emphasises the expectation that humans will still exercise oversight in various different ways over decision-making in the NDIS. And while that is somewhat heartening, it is not reflected in the bill itself. And so there are numerous ways in which the explanatory memorandum and the most recent addendum to this explanatory memorandum talks about additional accountability safeguards, but they're just simply not reflected in the bill itself. I might hand to my colleague to talk about some of the specific ones that we're interested in.
Yeah, so probably one of the key issues is that only the CEO can substitute incorrect decisions made by automated systems, and that's a non-delegable power. So essentially that means that at the staff level, they will not be able to exercise genuine discretion when a decision is made. And that's obviously where it's important, because if that discretion is not exercised at that first level, you are going to experience harm, and then you will have to go and seek review to get that redressed. And that's where the second problem comes in, which is there is, for the automated decisions under the bill, there is not that access to internal review. So ordinarily, when you have a decision made against that adversely affects you, you can go seek a review by a more senior officer in the department. That's what ordinarily happens. For automated decisions, this will not apply. And it's kind of worth making the point that automated decisions have the exact same impact as human-made decisions on people's human rights, and they have the exact same harms. So you need to ensure that the same standard applies to decisions, whether they're made automatically or whether they're made by a human being, and that's what we've recommended in our submission.
Thank you. One of the pieces of evidence that we heard yesterday was that when these provisions are combined with the expanded debt-raising powers in the bill, there may be scope for more debts to be raised through ADM, with limited rights to challenge those debts. And without suggesting that the scheme's identical, does this combination of automated decision-making, raising debts, very limited ability to actually challenge those decisions, reproduce some of the central risk factors exposed by robo-debt?
The short answer, Senator, is yes. The explanatory memorandum says that merits review is not reduced by this bill, and we disagree with that statement. And the reason for that is a little bit complicated, and that is that whenever an automated decision is made, the bill says that it is taken to be a decision of the CEO. And what that means is that there is no one who is at the same level as the CEO, there is no one more senior than the CEO, so there is no capacity to get internal review of an automated decision like the sorts of decision you're talking about. And it pains me to say this as a lawyer, but for just the practical reality is that most Australians will never be able to afford a lawyer to challenge a decision in a tribunal or a court. And so internal review, that's just a simple mechanism of being able to go to a more senior officer within the agency to have another look at your decision. That is so important. So if you take that away, the risks are incredibly high. Now, the government's response to this is that the CEO of the NDIA can step in and substitute a decision, but that is not merits review. That's a little bit like the system we have in our Migration Act, where the minister has what's sometimes referred to as godlike powers, and you can't compel the minister to even look at a visa decision, but they can if they choose to step in. And so I think it's really important. We think it's really important that you have just conventional merits review for automated decisions rather than reducing that review.
Thank you. Just finally, because I assume I'm coming up on time, looking at the Human Technology Institute's website, you describe the Institute as at the forefront of driving the regulatory, governance and technical change needed to allow the benefits of digital technologies to be delivered in a way that uplifts our communities and upholds human rights. This is obviously a huge question for the Parliament and something that we are grappling with. I was wondering if you could take the committee through the amendments you consider essential to this bill to actually ensure that we're doing that. We're using technology in a responsible way to speed up things that can be sped up and automated, but actually ensuring that we put humans at the centre and we maintain that oversight.
I'll be very brief. That's a big question, and I'd be happy for my colleagues and myself to expand on this in a private session or even with you or other senators. In short, it's the following. The first is any determination about automating a class of decisions, that should be made by our Parliament, not by a minister. Secondly, when a decision is made using automation, it must be accountable. That means that people must get, anyone affected by a decision that's made using automation should be given reasons and should be given a clear and accessible pathway to challenge that decision if they think it is incorrect or unfair. Thirdly, there needs to be particular attention paid to things that automation does not tend to do well. So that's why we've particularly focused on the concern about automation of discretion. And so government should be very wary about automating discretion, and when it does do so, it needs to put in place additional super-added protections. I'll leave off there, but our recommendation 7 kind of outlines in a bit more detail what we think is, the basic protections needed for ADM.
Thank you very much. Thank you, Chair.
Thank you. I'll give the call to Senator Steele-John.
Thanks very much, and thank you both for your evidence today. I'll go first to MedTech, if that's all right. You say in your submission that the NDIS Act must better recognise the role of assistive technology. Are there particular parts of the bill that you think could be improved with that goal in line?
Without having it in front of me, I can't say in terms of statute, but yes, there are certain things that I think should be there. One of them is that assistive technology should not be just seen as a procurement item. Assistive technology and emerging technologies, other technologies, are things that are wraparound and need wraparound supports for assistive tech. So that needs to be recognised, that this is not just a cost or procurement item, and also that that we don't just kind of put price limits or specific rules, because technology is a support like other supports, and it really does need to be flexible. So I think that flexibility needs to be in there. I also would really like to see some provision for emerging technologies. If we just kind of legislate for what's available now, and we know that what we have here in Australia is not sufficient. We don't have access to technologies available overseas, and we also don't produce many of our own technologies. So if we sort of legislate now for a very static technology, then we're actually missing the opportunity for people to participate and fulfil their best capacity longer term.
Thank you. Do you hold any concerns about the cuts to therapy supports proposed in the legislation, particularly in relation to the impact that it might have on people's ability to access safe and appropriate assistive tech?
Yes, I do. And it's, I guess I don't have an opinion in terms of actually kind of thinking about what therapies are needed, but what types of therapies and the qualifications or skills of the people who actually provide those therapies. One of the things that we've seen regularly is that people have accessed, if you like, therapy supports that have not been appropriate, have not had appropriate skill levels, etc. And the consequence of that is that people haven't got the amount or the type of technology. And technology can harm people, as we've just heard from the UTS submission. And so what we do have concerns about therapy being cut in areas specifically where we know this is really, really important to ensure that people are safe and have the best that they need.
Thank you. If I'll go now to the Human Technology Institute. You've said in your submission, you've given us a number of concerns around the bill and in your evidence this morning. Going to the government's explanatory memorandum related to this piece of legislation, they have said, quote, importantly, amendments in this part do not displace the important role of a human delegate or the rights participants have, including for review under this Act, end quote. In your understanding of the bill, is this an accurate statement?
Thank you, Senator. Our concern is really particularly focused on internal merits for review. And as I just said to Senator Pocock, that's the situation where you usually are getting sort of an informal review from either a more senior officer who made the original decision or someone at the same level. And because automated decisions are taken under the bill to be decisions of the CEO, that removes that very important type of merits review. And as I said, it's important because it's just something that ordinary Australians can ask for. You don't need a lawyer. You don't need to understand the kind of, complex workings of our court system or tribunal system. You can simply just ask someone more senior to review the decision. And by removing that, we feel that you're removing the chance for that review. Now, it's all the more important that what that could actually mean is that in practice, you're removing the possibility of any human reviewing the decision. Because if the original decision was made using automation, you've got no viable pathway to internal merits review. And your only hope is that the CEO, in their absolute discretion, may choose to come in and substitute a decision. Then your actual likelihood of a human reviewing that decision is very low indeed. And so we would urge that the government rectify that problem with the bill.
Thank you. I wonder, because that's a vital point, I wonder if you could you just step out the potential risks of what you've described to us, using a kind of a human example, a participant example, just because I know a lot of this is hard to comprehend for the public following the hearing. Would you be able to do that for us?
Sure. So let's say a person is being assessed for the support needs under their plan, and it's determined through an automated system that they no longer have access to, say, a particular kind of community support. That in turn can have serious implications for them. Perhaps in their case, they're reliant on that for their psychological stability and risk, having sort of episode if they don't have access to this particular support. They also feel like the way that the assessment was done might have been incorrect, or that all the factors relating to their individual circumstances weren't taken into account because the audited system is necessarily quite rigid and, has to classify people into particular categories and only looks at people in terms of like disembodied data about them, not as the whole person. So they want to seek a review. They have no access to internal review. They also might not even know that there's been something that's been dodgy with their assessment because they don't have that kind of insight about how the automated system is necessarily affecting them. They might try and seek review if they've got support around them and people who can navigate bureaucracy. They might try get that a CEO override. That is entirely up to the CEO, and remember that all review will be channeled through the CEO office. So realistically, many of these decisions that are unfair or causing harm will not be overridden at all. And then that person is suffering as a result, something that's directly impacted their human rights, and it's an unfair decision. And I would also say that that's the way that it affects individual people, but review is also really, really important for identifying systemic problems with a system. So, as we saw with Robodebt, it took years and years before we understood the cause of the harm affecting people, the automated system. And part of that is that there isn't, staff aren't able to raise and sort of identify and see and alert and go up the chain when they notice sort of patterns in mistakes that are being made. Those systemic issues aren't caught. And then you have real disaster that can impact, the entirety of the scheme in, a much broader way than just for the individual. And
can I just thank you for that? And just to make sure that we've understood very clearly. So from your case study you've just given us, or example, that is then why you conclude that to say, as the explanatory memorandum does, that the relevant amendments in the part of the bill that go to this issue do not displace the important role of a human delegate or the rights participant have for review. Like, on the basis of that case, that's why you're kind of disputing that. But can I just take you to specifically the last part of the government's claim, that these parts of the bill do not impact or displace the rights the participant have for review? You're saying that's just incorrect. They do impact the participants' rights of review.
Yeah, so the government recently released an addendum to the explanatory memorandum, and I can take you to page 2 of the addendum. It says, rights to merits review remain unchanged, unquote. And then it explains the CEO substitution, but it then goes on to say on the following page, on page 3, substitute action by the CEO is not an alternative to merits review. And so there is, those two propositions are almost impossible for us to reconcile, because if you are taking away merits review, you're offering this sort of CEO being able to intervene at their kind of absolute discretion, and then you're kind of saying, you know, this is not the same as merits review, but it is. But we're not diminishing merits review. I'm not sure how you square those two statements.
It's two fundamentally contradictory statements in your view, correct?
I'll reiterate what I said. I can't reconcile those two statements.
Yeah. Thank you very much. And just so that I've understood it correctly, it seems as though it is substituting the right of the participant to request review, or replacing the right of participant to request review with the ability of the CEO to review at their discretion. That's the shift that you've identified.
Just to clarify, we're talking about internal merits review.
Internal merits review.
Yeah, exactly. It's a review within the NDIA.
Yes.
And I'm not talking about external merits review by a tribunal or a court,
yes.
Or by a tribunal, I should say. But yes, if your statement applies to internal merits review, we agree.
Okay, thank you. Now, how do the provisions of this bill around automated decision-making compare to those in, say, other areas of federal legislation? Is it fair to say that they go further than other pieces of legislation, or are they comparable?
This is really one of the first instances that we've been able to identify where particularly discretionary decisions, in other words that require an evaluative judgment to be made, are explicitly authorised to be made using automation. And so we are concerned about that. Because that is a very difficult thing to do safely and well. And we are also concerned that primarily what the bill does is just that. It authorises discretion to be automated. What it doesn't do is set out in the legislation the safeguards that we would consider to be absolutely fundamental to be able to do that automation of discretion in a safe and effective way. I acknowledge that the explanatory memorandum offers some possible ways in which the government may choose to kind of, add some safety to the way in which automation of discretion is done, but those are not set out in the bill. And so even if the government at this specific moment absolutely intends to make good on those statements in the EM, they're not things that people with disability in Australia can hold the government to account to. And of course, governments kind of can change. An individual government can change its views on something, but also governments can change. And so an EM really does provide very limited protection.
Thank you. Now, I'm trying to understand whether what we're seeing in this bill is part of a broader pattern. And I wonder whether I could ask you to take on notice whether the NDIS, the bill with the title Getting the NDIS Back on Track, and it's the last kind of significant legislative package that we had from this government, whether that contained, in your view, elements or sections which expanded the role of automated decision making, or in any way kind of set us up for the concerns that you are seeing, or the direction of travel that we're seeing in this legislation. Would you be able to kind of take that on notice and come back to the committee?
Perhaps I can just quickly clarify with you, Senator. We can't speak on behalf of the government as to whether the NDIS bill's automation provisions represent kind of a whole of government policy. We note that the Attorney General is responsible for a bill that we anticipate coming soon that will be regulating automated decision making across government, but we don't know whether this NDIS bill kind of gives a flavour of what is to come.
No, sorry, I should have been more clear. We're talking about a piece of legislation that passed in 2024, and I'm just wondering whether you'd be willing to go back and just pass your eye over that and tell us whether its provisions around automated decision making or the review processes that you've mentioned have any kind of genesis within that legislation, to understand whether this is a kind of a broader, a longer-term piece of legislative work. Thank you very much for that. I've just got one additional question, Chair, and then I'll wrap up. Now, I take it from all of your submissions to this point that all of your organisations do not support the passage of the legislation in its current form. Is that correct?
As in its current form, it misses some really important things, and they include, actually having the foundational skills set up before people are left to the scheme, and I think also the functional decision making and the functional assessment, which my colleagues from CDRP are really expert in. And if I could just say one of the things that I was thinking of when my colleagues from HTI were talking, and around the whole kind of automated decision making process, this is not an easy group to start with. If you're starting automated decision making, you've got groups of people who are really different in their functional skills, and that's actually one of the beauties and one of the fantastic things about the NDIS as it is. And so we have the skills in Australia to be able to start to address this, but that needs to be addressed before we actually address really kind of take things away from people that will cause them harm.
Thank you. And the Human Technology Institute, is that your position as well?
We've only focused on the ADM provisions of the bill, and we would not support the bill going forward if those ADM provisions are unamended.
And the University of Sydney, is that your position as well, the Centre for Disability Research policy?
Yes, we would not support it going through, especially with the impact of changes to community participation and support.
And that would be partly based on, I know that your work focuses on employment, and you've done quite a bit of research in the disability inclusive workforce space. So is that opposition informed by what you feel might be a negative impact on disabled people's ability to participate in the workforce?
Oh, absolutely. I think it's much wider than that. It has a disproportionate impact on psychosocial disability, intellectual disability and other factors. But yes, I'm aware we're short of time.
Yeah. So basically disabled people may well lose their jobs because of this bill.
Yes. That's probably a slight simplification. So whether I can say a blanket yes to that question, I'm not sure, but it will have implications for workforce and for wider.
Thank you. Thanks, Chair.
Thank you. I will pass the call to Senator Tyrrell, who has a couple of questions to finish us off.
Thanks, Chair. I appreciate it. Professor McDonald, how do you think the Tech Advisory Group should consider the role of assistive technology as it contemplates a framework that supports consistent, fair and evidence-based access decisions to all prospective NDIS participants?
I don't actually understand what the terms of reference are for the TAG. I've looked at the website, so I don't know what I don't actually understand. You know, I've looked and I've seen who's on there, but I'm not sure. Actually, one of our colleagues on the call is on there, so he may be able to answer that. I actually think that it's really, really important that there is a very clear justification for assistive technology and the supports that are around assistive technology, and that includes emerging technology, which may not be classed as assistive technology at the moment. And so I'm talking about things like iPads on which people have communication devices that at the moment are denied people, and you know that's just a really sort of damaging thing, because it means that people then don't have access to communication because of a particular part of technology. So that should be part of the provision. I also think they really need to consider what sorts of assessments, be formal and informal, need to be addressed, and what considerations need to be taken into account for assistive technologies. And the really big one that we see and is really important is that the workforce needs to have sufficient skills, that the workforce both supporting people in their everyday lives and also the people who are doing the prescribing and the assessing and those sorts of things. Technology is not just a kind of, here you have a piece of technology. It's about training. It's about making sure that it's the right support for you at the right time, and that there are provisions built in for review and those sorts of things. So I'm aware we're short of time, so I'll finish there.
So what you're saying is that be protective of the workforce, but be aware that R&D is changing very quickly, and that the processes that support clients will be changing consistently.
Yes, but also that we actually need a workforce who is really properly trained. And what we're seeing is that we're seeing people who have no skills whatsoever in assistive technology opening up training companies, and that sort of thing should not be allowed to happen.
Perfect. Thank you, Professor McDonald. May I also ask a question of the Centre for Disability Research? I won't pick and choose. I'll let you decide amongst yourselves. How do you think a consistent, transparent and equitable approach to determining NDIS access would improve people's experience of the NDIS?
Do you want to take that on, Kim?
Thank you. Yes, so some of the questions that we have had in our minds about this with the amendments is around people having to be justifying some of the entry points, and this shift in looking at impairment more than functional needs. And so we have quite a bit of experience in the ICF, the International Classification of Functioning, which is a foundational principle, I guess, of the NDIS Act originally, but also in the UN Convention on the Rights of Persons with Disability. And so if you are elevating impairment and a focus on the health condition, which there is some suggestion in this amendment that that's the case, and I think also as alluded to by our colleagues around automated decision making, that you're looking at categories rather than individuals. That functional approach is really is essential from our point of view, and there is some question around how that's going to be applied now.
Okay. Thank you. Also, Professor McDonald, could you get your colleague to share the information that you thought they could give us on the previous question?
The question on CDRP, So I think CDRP are absolute experts in functional assessments. So I was passing to them to actually kind of, and so the idea around assessments being around function rather than impairment kind of probably answers some of that, and capability and capacity.
Okay, thank you. That must be my little problem. Thank you, Associate Professor Kim Bulkley. You've got big titles. Thank you, Chair.
Thank you, Senator Tyrrell, and thank you to all of the witnesses from this session for your evidence today, for appearing before the committee. For questions that have been taken on notice, the committee will report to the Senate on the 14th of August 2026 and has agreed that responses to questions on notice should be provided by close of business Thursday, the 6th of August 2026. The committee will now suspend for a short break and we will recommence at 10:30 a.m. Thank you. Good morning. I now welcome representatives from Catholic Health Australia. Thank you for appearing before the committee today. I understand that information on parliamentary privilege and the protection and obligations of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, please each state your full names and the capacity in which you appear today.
Dominic Butler, Policy Officer at Catholic Health Australia.
And Rebecca Cattermole, Chief Executive Officer of St John of God Accord.
Thank you. I will invite you to make a short opening statement, and at the conclusion of those remarks, I will invite members of the committee to ask questions. Over to you.
Thank you. Thank you, Chair and members of the committee, for the opportunity to appear today. I would like to begin by acknowledging the traditional custodians of the land of which we meet and pay my respects to elders past and present. My name is Rebecca Cattermole and I'm the Chief Executive Officer of St John of God Accord. We are a not-for-profit, for-purpose disability provider in Victoria. Accord is also a proud member of Catholic Health Australia and shares CHA's commitment to delivering high-quality, compassionate services that enable vulnerable people to live full and valued lives. I have worked in the disability sector for almost 20 years and I've seen significant reforms, including the introduction and evolution of the NDIS. We support the broad direction of these reforms. My focus today is how it can be implemented effectively, safely and sustainably. So there are 4 key messages that I'd like to share with the committee. My first message is that the reform is necessary, but implementation and sequencing matters. Replacement services must be funded, operational and accessible before existing supports are withdrawn. In our sector, unmet need rarely disappears. More often, it shifts to families, the health system, or forces providers into delivering unfunded supports. The risk is amplified by the cumulative impact of the scale and complexity of these reforms. Providers, participants and families are navigating simultaneous changes to service models, legislation, access, pricing, workforce, technology and compliance. Any one of these changes might be manageable. However, combined, it draws resources away from frontline services, places pressure on families and risks driving quality providers away from the market. My second point is that the legislation must work for people with complex circumstances, not just those whose needs fit neatly into an automated assessment framework. The test of good reform is not how it works for the average participant, but how it works for those who are most vulnerable around the fringes. For example, a person with intellectual disability unable to stay at home with their ageing parents, such a circumstance requires careful human judgment and flexibility. Automation improves efficiency, which is great, but human oversight is a critical safeguard we can't miss. My third point is that quality services costs money to deliver. A sustainable market of quality providers is not an end in itself, but it is the mechanism through which participants receive safe and high quality supports. Quality providers will invest in workforce capability and risk management frameworks and structures, etc., but all of this comes at a real cost. My final point here is that reforms should provide certainty and safeguards for participants and their families. The proposed decision-making arrangements warrant careful consideration because of their potential for unintended consequences. Decisions that remove or halve an entire support category may be administratively efficient, but it can have profound impacts on safety, independence and family sustainability. The community needs confidence that significant decisions will be transparent, evidence-based and subject to appropriate safeguards and opportunity for review, importantly. We believe that these reforms present an important opportunity to strengthen the NDIS. Our recommendations are intended to help protect both the scheme and its participants for future generations to come. Thank you, Chair.
Thank you. Is there anything you wish to add, Mr Butler?
Nothing to add from me, thank you.
Excellent. We'll go to questions. Senator Steele-John.
Thank you, Chair. Thanks very much. Now, you'll be very aware that it's quite common for NDIS participants who don't have significant funding for supports to end up in hospital, sometimes for literally months at a time. The bill, as it is currently written, will cut supports for participants and result in some 241,000 participants losing access to the scheme altogether. Do hospitals have the capacity to manage the surge in attendance that could result from this many participants losing support?
I think that's a good question, Senator, and I think particularly from a public hospital perspective, we know that there's a lot of capacity constraints at the moment. And we have to remember, as you rightly point out, that the NDIS doesn't operate in isolation, and there's a danger at a system level that participants can fall through the gaps and between programs as well. And CHA has done a lot of work recently on issues such as delayed discharge. We know this is such a pressing issue in the hospital sector across Australia. And that's where someone may be clinically ready to leave hospital but unable to do so because the disability supports there aren't available yet. That's why we think it's so important that no one is transitioned off the scheme before those alternative supports are in place, they're ready and they're accessible as well.
Yeah. It's correct, isn't it, that the legislation as is currently written does not include any such guarantee that participants will only be removed once alternatives are in place. That's correct, isn't it?
I believe so, yes.
Yeah. Could the increase in demand for hospital services result in longer wait times, in your view?
Quite possibly, yes. And going back to the point around delayed discharge, that is a pressing issue right now in Australia, and it's something that we need to be cognizant of whilst going through these reforms.
Yeah. Have you raised concerns about these potential flow-through impacts with the government? And if so, what was the response you received?
So we recently hosted a roundtable on delayed discharge, and it included representatives from across disability, from health, aged care, and different sectors. And this was the sort of flow-through point is a broader discussion that we've had, and I'm very much aware that it's on the government's agenda as well.
Ms. Cattermole, you said in your opening statement that while there are some elements of the overall, I think you phrased it as purpose or goal of the legislation that Catholic Health Australia could support, that sequencing and transition was critical to that. Is that a fair summation of what you shared with us?
Yeah, that's a fair summation. We support the intent of the legislation and the need for a reform. Absolutely, there's a need for reform to protect the viability and to safeguard participants, so we support that. I suppose the comment here is to make sure that we enable a sustainable market of quality providers, and the concern that the complexity and volume of current reform, when they all happen together, it draws resources away from service delivery, which places unintended consequence or risk on participants, either as a result of providers who are unable to lean in and deliver those services, or perhaps families who are needing to provide the supports as primary carers. The unmet need does not go away. It has to go somewhere.
And in terms of the patients within the systems that you manage, do you see a lot of patients within your systems that are NDIS participants but that have ended up in a hospital due to currently to a failure to receive the supports that they needed?
St John have got a cord. We are a division, the disability provider division of a very large organisation, St John have got healthcare. And within a cord, we provide support, disability supports, to approximately 1,000 participants on the NDIS scheme. And what we are seeing is that when there is changes in participants' NDIS plans, there is a direct impact and a flow-on effect either into other sectors and other streams. So, for example, the risk of a reliance on healthcare or on families.
Yeah, thank you. It's come as quite a clear message to the committee that there is broad concern in relation to this legislation and the impact that it may have on people. The Australian Catholic Bishops' Conference issued a statement in relation to the legislation about a month ago, I believe, flagging a number of concerns, including the automated decision making provisions, and cited the Pope's encyclical on the matter of artificial intelligence and automated decision-making. We've heard from a number of experts, disabled people, allied health experts, academics, speaking more or less with one voice, telling us in the current form the legislation shouldn't pass. You've spoken about the need for sequencing and transition. One of the most significant parts of this legislation in terms of people's flow-through need for healthcare is the removal of 50% of people's funding for social and community participation, as well as a across-the-board 10% cut to therapies. That's all going to take place in around 12 months' time post the passage of the legislation. In this context, do you believe that the bill in its current form should pass?
So we definitely support a version of this bill passing, but not as currently drafted. And I think from the moment when we wrote the submission, there's been some positive inroads in certain areas, but we would like to see further safeguards and oversight brought into the bill. And again, as Rebecca's already mentioned, we support the general direction of reform, and we agree that the NDIS should be put on a more sustainable footing. But I think the bill, as we currently read it, it gives legislative effect to, whilst it gives a legislative effect to many of the recommendations of the 2023 review, we would like to see further opportunities for, say, participant-level avenues of review. We believe that there's certain opportunities for parliamentary disallowance over delegated legislation, and there's opportunities for further oversight and scrutiny.
And the elements of the bill that say enable a minister here in Canberra to unilaterally cut by 50% the support hours that somebody with Down syndrome might rely on to do their grocery shopping, or that a blind Australian, as we heard yesterday, might require to be able to do something as simple as go to the gym or attend university. Would you oppose those elements of the bill as well?
So we recognise that delegated legislation, such as the instruments you're describing, are sometimes appropriate mechanisms for implementing changes to such a complex scheme as the NDIS. But our concern is that the bill confers certain powers that may affect participant rights, as you describe, and they might also impact provider obligations and border scheme administration. So we recommend that pricing determinations and their pricing documents, the transitional rules and key instruments governing everything from the transition to automated decision-making and the Section 34A instruments that you're describing, these should be open to, at a participant level, some sort of recourse, whether that be through the ART or a merits review stream. For certain powers as well, as we said, we'd like to see parliamentary disallowance, particularly around the pricing determinations in Section 45C.
It would make more sense to you, I would imagine, as an organisation, if pricing was handled by an entity like IHACPA.
Yes, correct. And that was one of our recommendations. That's something we recognised from the 2023 review as well. I think they identified that the NDIA has this dual purpose of both the payer for supports, but also the body that advises the minister on pricing. So we'd like to see that transferred potentially to IHACPA. We think a body with decades of experience in actuarial and price modelling, that would be quite a sensible move.
Yeah, thank you.
May I add a provider perspective also? We absolutely support a sustainable NDIS, which means that there are efficiency measures that needs to be found. But the provider perspective here on an operational day-to-day, what we see in our day-to-day services is importantly, we have to make sure that there's no unintended consequences. So, for example, you mentioned, Senator Steele, John, the potential reduction or the planned reduction for the community participation funding. For some participants, that is really problematic. I'm going to give you two brief examples. In a supported independent living setting, a SIL setting, which is a shared group home, a reduction of community participation funding could potentially risk transferring the responsibility to the SIL, the home provider, or the provider of the supports in that home, which would not be funded. And that risks potential tenancy viability concerns and risks in that space. And it also places pressure on the quality providers who are wanting to continue having that continuation of support obligation under our legislation. The other example I will give briefly is a person with a disability living at home with family members, and the family may be relying on community participation funding so that parents can continue working and be productive members of society. And another unintended consequence here, if community participation funding is halved, is that it may put pressure on families who may no longer be able to continue working in their current capacity. So these are the things that we just need to be really mindful of, but still supporting the general need for a sustainable NDIS.
Yes, I understand. Given that you are a SIL, and this will be my last question, Chair, given you are a SIL provider and you've just shared that with us, you've talked about the risks that could pose to the overall environment within a group home dynamic. Can you step those out for us a bit more? What could it practically mean if people aren't able to leave, if they basically have their ability to go outside their front door from that setting, cut in half? What could it mean for the person, but also for any workers working with them?
Yeah. As quality providers are really keen on supporting the fundamental rights of people with disability to live lives of dignity and have their human rights supported, the right to have voice and choice and control over their lives, just like any other member of society. And the potential unintended consequences, if not looked at carefully, is that reduction of funding may mean that people are unable to access their community and visit families and enjoy those human rights like the rest of the community.
Thank you. Thank you very much. Thanks, Chair.
Thank you. I have a couple of questions to finish this session. For you, Ms Cattermole, you, of course, provide support to lots of the disability community in Victoria. I'm wondering if you could talk briefly to how the current NDIS planning and access systems work. And one of the things that I'm particularly interested in is where the kind of inequities or inconsistencies exist. in terms of some of those decisions. So yesterday in the hearing, we had a really, I think, telling example of twins with very similar diagnosis, very same diagnosis, very similar capacity, who had received very, very different plans. And so I'm interested in your reflections on that and what you see in your work to that.
Yeah, that's a really great question. I absolutely support the intention here for clarity and sustainability. It's important that an opportunity is captured to safeguard against inequity. The people with disability often come with fluctuating support needs, multiple and interacting needs. And from an operational perspective, I can give you an example. We have consider 2 participants, and these are participants within our services. There's 2 participants with almost identical needs. One participant A, is living in one of our SIL homes, has no family support, and has a very comprehensive support NDIS plan that captures 24/7 support, including community participation, therapy supports, and support coordination and everything that is required to implement their services. Participant B, a different participant, exactly the same type of support needs. And I should have mentioned intellectual disability, autism, and Lennox-Gastaut, which is a severe form of epilepsy. So both of these participants have got these support needs. So participant B, on the other hand, lives at home with parents and some siblings and enjoys a combination of parental support and some in-home NDIS-funded supports. But the NDIS plan is less than a quarter of the size of participant A. Now, with very similar needs, but completely different funding requirements, that human-in-the-loop component is so important when it comes to assessment and putting together an assessment framework for funding decisions. And this is the highlight. I think this highlights, these 2 participants with identical needs, highlights the need for flexibility in that assessment space.
Thank you. Mr. Butler, your submission talks to the importance of responsible stewardship of the NDIS to ensure it upholds dignity and the common good. Could you talk to that a bit and why it's really important that we achieve that in this process to ensure that the NDIS can continue?
Yeah, I'm very happy to. I think these are really important principles and concepts. It's something that our members practice every day as Catholic organisations. It's very much linked into Catholic social teaching and practice. I mean, from our point of view, scheme sustainability and purpose are not opposing problems or opposing views. They can be achieved together. So we think that the scheme should be put on a more sustainable footing, but we want to see effective stewardship, as you describe. Stewardship for us means that we implement the scheme properly. We ensure that these changes will not affect those people, the most vulnerable in society at the margins. We ensure, for example, that the NDIS Commission is ready to take on this new role as mandatory registration expands. And we'd like to see an NDIS that is effective and suitable and supports people with disability to fully participate in community life, not just now, not just in 10 years, but in 50 years as well.
Thank you, and thank you both for your evidence today. I don't believe that any questions have been taken on notice, but just for your information, the committee will report to the Senate on the 14th of August 2026 and has agreed that responses to questions on notice should be provided by close of business Thursday the 6th of August. Thank you for your time.
Thank you.
I now welcome representatives from the Council for Intellectual Disability and invite you to the table. Good morning. Thank you for appearing before the committee today. I understand that information on parliamentary privilege and the protection of and obligations of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, please state your full name and the capacity in which you appear today.
My name's Heath Alexander Dickens. I'm the Chief Executive Officer for Council for Intellectual Disability. Trying to get this microphone right.
Yes, that's okay. You're doing a great job. I invite you to make a short opening statement, and at the conclusion of those remarks, I will invite members of the committee to ask questions.
Thank you. As I mentioned, I'm the CEO at Council for Intellectual Disability. CID is an organisation led by and for people with intellectual disability. We've been advocating for the rights of people with intellectual disability for 70 years. In that time, we've seen some really significant positive developments for people with intellectual disability. It was not that long ago that we were in an era of contain and manage through institutions. We then moved to a really strong recognition of human rights. And then as a nation, we supported this thing called the NDIS, which really offered a new era of aspiration for people with intellectual disability. Sorry, I'm having to do this on my computer this morning, so I do apologise.
That's okay. Take your time.
The value proposition of the NDIS for people with intellectual disabilities is essentially a chance to be who you can be. It's an opportunity to be part of the community, but most importantly, contribute to the community. To realise this aspiration, particularly in a period of reform, we need to consider what outcomes are derived from NDIS supports, not just the cost of providing those supports. By seeing them as just a cost, we're not seeing the whole picture. The intent of the scheme was to be an investment in the potential of people with disability and people with intellectual disability. And cost cutting isn't the only measure for a successful, sustainable scheme. We need to recognise what supports are used for and what do they provide, not just for the person receiving those supports, but society and the people providing the funding. And it's also worth noting that the efficacy of capacity building for people with intellectual disability is particularly pronounced. It can be the difference between someone being able to do some things for themselves, or many, or relying on paid supports for the rest of their life. I think we need to reframe the debate and the discussion around reform and get back to the base principles of the scheme. It is not just about keeping people alive and occupied. It's about helping people thrive and strive, I should say, to have a much bigger, more engaged life and contributing to their local communities. We recognise the need for reform. I think it's undeniable that there's huge cost pressures on the scheme, certainly from people with intellectual disabilities perspective. There are many, many supports that we still need to get right, but understanding what the principles are and align with the principles of the scheme.
Just to interrupt you very briefly, we have a photographer in the room. I just want to confirm that there are no concerns with that with either committee members or you? No? Okay. Please go ahead.
We're already hearing many stories about the pace of reform moving too fast. As I said, we are very supportive of the need for reform and to get how supports are used and what supports provide for people much better aligned with the principles of the scheme. But as I said, it's moving way too fast, and we're hearing many stories from people who are already having cuts to their plan and the bill hasn't even passed. The success of the reform activity that we're engaging in at the moment is really dependent on anticipating gaps and understanding what they are and working with the stakeholders to close those gaps. The gaps between state and Commonwealth funded services over many years has caused huge problems for everybody. I think we also need to reframe this crisis into one of opportunity. This is actually an opportunity to align state and Commonwealth service jurisdictions, to align that with the scheme and to achieve a level of, as I said, support and aspiration for people, not be seeing people with an intellectual disability as a cost or a drain on the system. People are ready and able to do so much more with their life if they're given the opportunity. But if we don't address that, we will continue to have a process and a system where people move, for instance, a young person will move straight from school, and if there are no supports, if there are no planning processes that support that transition into adult life, the current paradigm is to land in services that are high intensity supports like SIL and others. If we don't break that cycle as well, we will be having the same conversation in 5 years' time, 10 years' time. This year, we're going to have a whole range of young people go from school into a service system that is not set up to help them make that transition, nor does it aspire for them to be able to work, to be able to do the range of things that we all take for granted. So critical that we line all of those parts up to achieve that and achieve sustainability, not just through cost cutting. The importance of social and community participation is different for everyone. For some people, it can be the only path out of loneliness or isolation. For some people, it can be an opportunity to understand their community, make connections and do it in a safe way that can become sustainable over time. For a young person who is just making their move and transition into adult life, social and community participation can be a way for them to immerse in their communities, to understand what that looks like and to start forming their views about what things they may want to do in their life, not just a straight path into a high intensity environment. I realise I've probably spoken for a bit too long, so I might just stop there and allow questions.
Thank you, Mr Dickens. That was just the right amount of time. Thank you. I will pass the call to Senator Steele-John.
Thank you, Chair. Thank you, Mr Dickens. Let me start with that point you made to us around loneliness and the way in which community and social participation funding combats loneliness. Tell us a bit more about what that looks like.
Yeah, so for people with intellectual disability, isolation and loneliness is profound. It relies on an ability to interact either with your community or the people around you. Without an ability to do that through whether it's social and community participation. I think too the term social is a little bit misleading. I think we're probably getting caught up a little bit in terminology, I think. It doesn't necessarily convey what it can do for people, as I said before. So, but social life and social connection, relationships, intimacy is all something that's very much out of reach for most people with an intellectual disability. Because again, we don't aspire for that. We don't, as a society, we tend not to recognise that people with intellectual disability have all of the same needs and wants when it comes to connection, as relationships, intimacy. And it's probably why I'll keep talking about we need to go back a step and understand what the actual principle of the scheme represented for people with intellectual disability, and that is one of those things, is better connected life.
Yeah, absolutely. I think you're correct that this conversation sometimes gets lost in the labels that government bureaucracy places upon pools of funding. It's so important to take us back from that. Tell us what social and community participation funding enables in your experience in terms of the people that you represent, the tangible activities, the things that people are able to do with this funding.
Yeah, so it's been discussed, I think, at a number of previous sessions of this committee that it can be getting to the doctor, it can be getting out in the community, it can be doing your shopping, it can be support to do things safely. As I said before, though, it's also about making connections in the community. It also relates to a broader issue that, again, relates to sustainability of the scheme. If we are ever going to get to a place where we have a truly inclusive society, society needs to be interacting and engaging and working alongside people with intellectual disability. If people aren't able to be out in the community, the community is not going to have exposure to people with intellectual disability, and will be reliant on paid supports and support workers being an intermediary with the person with disability and the rest of the community, and moderating all of those interactions. That is not going to help society become more inclusive, and over time not be totally reliant on paid supports for people just to be able to be part of their community.
And in terms of somebody with an intellectual disability, tell us why it is so important for them to have a support worker available to help them go shopping or do any other activity within the community. How does that tangibly help for people that might not know?
Most immediately, it's safety for a lot of people to be able to safely navigate the community. As I said before, it's the experience of intellectual disability is different for everyone. It's not a one-size-fits-all. So for some people, it might be being able to do the things they need to do in their life, but be doing it safely and doing it with a support person. For other people, it may be more pointed. It may be, as I said, very clearly about getting to doctor's appointments or other things that are life-changing. But I guess the basic way to explain it, for most people, it's about safety, to be able to be in the community. Not always, but it's different for everyone, as I said.
So it's about safety, helps them be safe, and also because they're able to get out and about more, that kind of helps tackle a bit of the loneliness and isolation that people feel.
Well, it does, and it also takes pressure off other service systems. We recently interacted with somebody who has had their funding cut in this area. They were attending a group on a Friday, a social group with peers. They're no longer able to do that. That person is now more or less refusing to get out of bed, has hit a really significant level of depression and anxiety. That will be picked up elsewhere as well. So it's creating other issues that will get picked up, whether it's in the health system or other service jurisdictions. So it's not just about achieving that, it's also preventing negative outcomes. And I think all of us would agree that being connected socially is incredibly important for your mental health.
And for this person that you've described to us, so they've had their plan cut already. How much by?
They explained it to us. It was roughly around 50%.
Okay.
That was reported by them. We didn't verify that, of course.
Of course, but we're seeing that quite commonly. I've had lots of people share that with my office. And so now they no longer have the funding to employ the support worker or to enable a support worker to come with them to that group that they were participating in. So is there any alternative for them now?
No, not at the moment, no. From what we've seen.
So even if they wanted to kind of get it, even if they weren't so impacted by this, that they felt able to get out of bed and do their day, there's not really much for them beyond their doorstep now. No,
and they're in an accommodation service as well. So that then obviously has to be, the person needs to be supported on that day that they were previously going out as well. So there will be implications for the service provider as well. And we've heard from the government's own figures that they are looking to cut this precise area of funding by 50%. And that cut will mean the removal of about $13 billion from people and their support plan in that specific area over the next 4 years. And that cut will apply to participants who have already seen a reduction. So the participant you're talking about will have their social and community participation cut by a further 50%. What kind of impact do you think that will have on this person and the broader community? So on the person, it's dire. I just want to acknowledge before I go any further that there are occasions where some people do access these supports who may or may not need them, where there are other people who absolutely need it. I just want to be open about that. because there has been a lot of discussion around people receiving supports in their plan, but it is in the minority. It would be in the minority of people who receive supports that they may not need in this particular category for this particular person. It'd be catastrophic. And we heard earlier about unintended consequences. This is one of those that I've mentioned before. We moved away from an era of institutions. If this was to go left unchecked and people ended up being, to your question, ended up being at home most or all of the time, it's hard to argue that looks much different from the old days of institutions in terms of not being able to be in the community. And it is not the intent. That would not be the intent of the scheme. We are encouraged by the language and the comments around people with intellectual disability being at the core of the scheme and a priority of the scheme. But what we've now seen with this particular piece of legislation is that this unintended consequence of the person we're talking about and many other people who are in exactly the same situation. I also worry for young people who, to use an example, a young person who may have been 1 year into post-school. They may have been on their journey of exploring the community, forming a view about what they want their life to be, making headway in that, making progress in that. And then once these cuts come through in its entirety, it has the effect of that person then having to rein in their aspiration and rein in the opportunity and their ability to understand what they could potentially do. So I have a concern it blunts the aspiration of the scheme and the original intention of the scheme, which was that investment in people. So I only speak for people, in this context of this hearing about people with intellectual disability. It certainly blunts the aspiration for them if they're not able to do the things that they need to do to form that view and form a plan.
And given what we've heard is that this legislation, these cuts are not individualised. They're not focused on whether somebody may or may not have used their social and community participation supports. It doesn't matter whether you've used it all or you've never touched it. It'll go down by 50% at least. Given that kind of across the board ministerial cut that is enabled by this legislation, do you believe that the bill in its current form should pass?
Not without safeguards. There's been a lot of commentary through these hearings that it should further cuts. There should be predicated on whether it's other service jurisdictions or other safeguards being put in place. As it's being applied now, we couldn't support it without some assurances of safeguards that will make sure that people don't fall through the gaps that are forming quickly. And
you don't see that in the bill currently, those safeguards?
Not in regards to this specific thing. There are many things in the bill that I think are appropriate and I think should happen, and we've made progress, as we know. There's been some amendments already, but when it comes to this specific issue, that's problematic.
So in its current form, it shouldn't pass. It needs further work.
Yeah, it needs further work, yeah.
All right. Thank you. Thanks, Chair.
Thank you, Senator Steele-John. Mr Dickens, you said that there's a number of things in the bill that you do support. Could you talk me through what elements of the bill you think should be supported?
Yeah, I think broadly the thrust of putting some controls around some of the aspects that have been discussed are important. I think it's more about the recognition of that we had to do something. We did have to do something. The scheme was growing out of control. Like it was, and certainly from a person with intellectual disabilities perspective, we've not hit the mark on many things in terms of quality of life outcomes for people. The scheme promised so much, but we've, through a whole range of reasons, haven't been able to achieve those. So I think the answer to your question from our perspective is that the broad thrust of getting the scheme back to its original intention. However, it is concerning that what we've just been talking about immediately impacted people with intellectual disability, which we were under the impression, and certainly, as I said, supportive and encouraged by the language, that people with intellectual disability aren't necessarily the target of these cuts, but they are. They are now being affected by these cuts.
Disproportionately.
I would agree with that. I think that the impact or the experience of people with intellectual disability for people it impacts nearly every area of their life. So it's hard to understand that a cut like this wouldn't have very serious implications for people with intellectual disability. And if it is correct and true that people with intellectual disability are at the core of the scheme, I think we need to pause and understand, how did we get to this place? How did we have an unintended consequence like this for a group of people who were not ever the intention of these cuts?
What's your view on how important is protecting integrity in the scheme for people with intellectual disability?
Sorry, just to clarify what you mean by integrity?
Well, there's been lots of, discussion about, we've heard examples through these hearings about people taking advantage of people with disability in the scheme, providers, for example, providing services, charging for services that they have not provided, people having their plans rated. I'm just wondering if you have any reflections on that.
Yeah, very much so. I think registration is important. I understand that there are some aspects of the disability community who don't agree with that. Having managed many large services across the whole spectrum of NDIS supports, whether it's employment, accommodation or others, and so I'm very used to a very regulated environment. It was very concerning that people could be living in accommodation services that had no reporting requirements, no mandatory reporting requirements and no oversight. So there are aspects of the reform that I think are important, and I think in terms of the integrity of the scheme, I think there are critical sustainability measures, but also safeguarding measures. You could have a very adverse outcome occur in an accommodation setting that wasn't registered. No obligation to inform anyone. That cannot be good for anyone. So very supportive of those measures, and quite frustrated, I think it's fair to say, that our community has seen this behaviour occur, but then obviously it makes it an even harder pill to swallow when the same community now is seeing their plans cut. So it feels at times that because of the behaviour of others, when we just talk about what you raised, has led to people with intellectual disability now having their plans cut to help rectify the situation, which seems, and I do genuinely believe it's unintended, but it is real and it's occurring.
Thank you. Thank you very much for your evidence and for appearing before the committee today. The committee will report to the Senate on the 14th of August 2026 and has agreed that responses to questions on notice should be provided by close of business the Thursday the 6th of August. Thank you very much. We might just suspend briefly while we check that we've got our next witnesses online.
It's amazing.
Okay, welcome back. Good. It's still morning. Good morning. I now welcome representatives from the Health Services Union. Thank you for appearing before the committee today. I understand that information on parliamentary privilege and the protection and obligation of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, I will ask each of you to state your full name and the capacity in which you appear today. I will start with Ms Marshall.
Thank you, Chair. Kate Marshall, and I'm the National President of the Health Services Union.
Thank you. And then I believe we have Tony.
Yes, my name's Tony Dunn and I'm a house supervisor for an organisation in Victoria.
Thank you. And Joe? Do we have Joe on the line?
Sorry,
That's okay.
Unmute.
Hello.
Hi, I'm Jo Peterson and I'm a disability support worker for a Victorian SIL provider.
Thank you, Joe. And Mittul.
Hi, my name is Mittul and I'm a disability support worker and a SIL provider in New South Wales and also a union delegate. I raised the concern with that.
Great. Thank you very much for that. I will invite you to make a short opening statement, and at the conclusion of any remarks, I will invite members of the committee to ask questions. Ms Marshall, do you want to start off with an opening statement?
Yes, thank you, Chair. I'll be making the opening statement and then happy for the members to answer any questions or fill any gaps I may have missed along the way. So, Chair, Senators, thank you so much for the opportunity to appear today. I'm here, as I said, on behalf of the Health Services Union and our 120,000 members working across health, disability, aged care, community services. Included amongst those are thousands of disability support workers who deliver care and support to the NDIS participants every day in homes, communities, supported accommodation settings and disability services across both metropolitan, regional and rural Australia. As you're aware, I'm joined by frontline disability workers who can speak to the inquiry today directly about the practical realities of these reforms and the impact that they may have on participants, their families, workers and service deliveries. So the HSU supports efforts to improve the integrity, accountability and long-term sustainability of the NDIS. Our members want to see fraud, exploitation and poor quality providers removed from the scheme just as much as the participants and government does. And the overwhelming majority of workers in the disability sector are committed to delivering safe, dignified and person-centred support, and they understand that public confidence in the NDIS depends on strong safeguards and effective regulation. We therefore welcome measures that strengthen oversight, improve the transparency, increase penalties for wrongdoing. We also acknowledge reforms aimed at improving scheme integrity and accountability. However, we do not support reforms that seek to achieve sustainability by transferring risk elsewhere in the system. Cost pressures do not disappear when supports are reduced and people are excluded from the scheme. Very often they are shifted to participants and families, to disability workers, to EDs, to aged care facilities and other public services that are already under significant strain. Our members work across all these sectors and they see the consequence of service gaps every single day. Nor can we support reforms that continue to treat the disability workforce as peripheral to the future success of the NDIS. If there is one message I'd like the committee to take from our evidence today, it is this. You cannot secure the future of NDIS without securing the workforce that delivers it. This is not a new proposition. Over the last several years, successive reviews, royal commissions, parliamentary inquiries have reached remarkably similar conclusions. the Disability Royal Commission, the independent review of the NDIS and the NDIS Provider and Worker Registration Task Force, as well as the recent Joint Standing Committee inquiry into NDIS integrity, have all identified stronger workforce regulation, professional standards and worker accountability as critical reforms. The evidence base is extensive and the direction of travel is clear, yet despite these broad consciousness, the workforce remains largely absent from the core architecture of this bill. So the most significant omission that we see remains the absence of a national worker registration scheme. Every other major sector in Australia recognises the importance of registration, qualifications and professional accountability. So nurses are registered, allied health professionals are registered, teachers are, aged care is moving towards that position more strongly, yet disability support workers who often deliver really intimate personal care and support of some of the most vulnerable Australians remain outside that equivalent national framework. So we say that this is not just an industrial issue, it is about it is a safety measure because it ensures that minimum standard of practice. It is an integrity measure because it strengthens oversight and accountability. And it is a workforce measure because the professional recognition, clearer career pathways and consistent standards help attract and retain skilled workers in a sector that continues to experience significant workforce shortages and turnover. Without a professional and supported workforce, many of the objectives contained in this bill will be harder to achieve. The second issue is what happens to people who are excluded from this scheme. So the HSU remains deeply concerned that these reforms are proceeding while foundation supports are still being designed, negotiated and implemented. So we know that state and territory disability ministers have themselves warned that they have not agreed to provide like-for-like services for people who leave the NDIS, and at present significant questions remain about what services will in fact exist and who will deliver them, how will they be staffed and when will they be fully operational. So if a participant loses access to the NDIS, our questions are where exactly do they go? What services will assess them? What support will be available to them? Who will deliver that support and how quickly will that become available? So unfortunately this concern's not hypothetical. Participants do not cease to require support because an NDI plan is reduced or withdrawn. The costs and pressures simply appear elsewhere. As I said before, they end up in EDs, in hospital beds, because there's no safe pathway for them to go home. Or they rely on family or carers that may not have the adequate knowledge or skill base to be able to assist someone with a disability. So we say that that's not sustainability, it's just cost shifting. So until those foundation supports are funded, staffed and operating in practice, there should be no pathway that leaves people caught between systems and forced into crisis-driven interactions with hospitals, aged care facilities or emergency services. Thirdly, we are particularly concerned about the risk of unintended consequences with the supported independent living arrangements. Evidence presented to this inquiry demonstrates that for many participants requiring intensive support, critical daytime support is frequently funded through the social and community participation budgets rather than through SIL funding alone. In practice, those supports are integral to maintaining a safe 24-hour support arrangement.
Yep.
For those participants, community participation supports are not an optional extra. They are part of the funding architecture that allows continuous care to be delivered safely. If those budgets are reduced without appropriate safeguards, participants do not suddenly require less support. Instead, providers face unfunded care gaps, services become harder to sustain, workers can be placed in impossible situation where participants' needs exceed the resources available to meet them safely. So the consequences aren't just financial. They disrupt routines, reduce staffing, unmet support needs, increase risks to participants, and can contribute to higher levels of occupational violence and aggressions that are experienced by frontline workers. That's why we called for explicit protections to ensure that future commissioning or redesigning of SIL remains safe, sustainable and adequately funded 24-hour support arrangements. We are also concerned by provisions that permit automated decision-making. So the HSU recognises the need for efficiency in the scheme, of course, and given a scheme of this scale as well. However, technology can only assist decision makers and improve that administrative process. It shouldn't be allowed to stand alone and be a replacement for humans making that decision. Algorithms should never be the sole determinant of whether a person with a disability receives support, loses support, or has support reduced. It's too risky. These are complex human decisions with profound consequences, and they involve individual circumstances, functional impacts, health conditions, and support needs that can't always be reduced to a set of automated rules. So any adverse decision affecting participant support should be subject to meaningful human oversight, human clinical judgment. The lessons of previous automated government decision failures should not be ignored in this space. Finally, sorry, I'm almost finished. I just want to address whistleblower protections. So frontline workers are often the first people to identify fraud, abuse, neglect, financial misconduct, or unsafe practices. So in many respects, they are the eyes and the ears of this scheme. The integrity of the NDIS depends on workers like those appearing before you today feeling safe and able to come forward when they feel like something is wrong. We remain concerned that workers who seek advice from their unions may fall outside existing protected disclosure arrangements. The NDIA has acknowledged that disclosures made solely to a union may not, in fact, qualify as protected disclosures under the current framework. So that creates a chilling effect for workers seeking advice before reporting serious concerns. If we are serious about exposing misconduct, workers must be able to seek advice, representation and support without fear of retaliation. So strong whistleblower protections are not a barrier to accountability. They are one of the most effective accountability mechanisms available. Chair, the HSU believes that the NDIS can both be sustainable and fair. We support reform, we support stronger safeguards, we support action against fraud, we support greater transparency and accountability. But sustainability cannot simply mean spending less. It means a true professional workforce, safe participants, independent oversights, effective safeguards, and confidence that no person with a disability will be left without support because governments are still negotiating who should provide it. So after multiple reviews, inquiries, opportunities for reform, we say that this is the ample opportunity to recognise a workforce policy that is also an NDIS policy. Participant outcomes, service quality, safeguarding integrity, long-term financial sustainability, and are all ultimately delivered through workers. Any reform agenda that overlooks that reality risks repeating many mistakes that have challenged the scheme since its inception. So, in conclusion, we urge the committee to strengthen this legislation by embedding a national worker registration scheme, strengthening whistleblower protections, guaranteeing meaningful human oversight of adverse funding decisions, safeguarding SIL arrangements, and ensuring that no participant falls through the cracks before foundational supports are fully funded, staffed and operational. So these reforms will only succeed if they protect both the sustainability of the scheme and also the people who depend on it every day. Thank you, Chair.
Thank you very much. I will ask Senator Tyrrell to start with questions.
Thanks, Chair. Ms Marshall, thank you so much for recognising that the scheme is important and that the integrity of the scheme is important. But I'd be interested to hear from your perspective the importance of the integrity when it comes to the workers and the way that they interact with the scheme and with the clients, because there are providers out there that could be considered a little bit dodgy, and the workers are an integral part of the scheme. Could you please elaborate a little bit, and maybe Mitchell and Joe would like to chime in a little? And yeah.
Oh, sorry, please.
No, that's pretty much it. Yeah.
I'll start off, but as you said, I think it's important to hear from Tony, Joe and Mitchell on this question as well. So obviously, you know, we support, we know that there's going to be bad actors in this space, and we support the work that's already been done to try and remove the bad actors from that space, including the mandatory registration for the providers. However, we think that in order to keep those bad actors out, we think that a big part of that is, as I said before, the worker registration, which isn't just worker registration, mind you. It is the training, the professional development, the code of conduct, and that scheme of protections around that worker that help them identify the bad actors along the way as well. I might throw to our members to talk about how they see the interaction on the actual floor, and how, Mitchell, can I start with you?
Yeah, sure. So, look, as a disability support worker, I worked like 19 years with clients, and I have seen the big difference in really professional worker. I think the professionalism and registration promoting will be good for the the clients, service who using our disability services. So in terms of that, when you have a registered worker or registered the professional worker working on the floor, they're providing good quality of care and service, because I have seen it many times happen, because we working not just a client, because they have multiple conditions. So you're not dealing with one thing like just disability, because they have behavior, physical needs, the bowel care. Then we got medication, and some of them complex bowel care medication stuff, SPC catheter, and a lot of stuff we day to day, every day we deal with it. So when you have the registered professional worker like this recognized, so all the beds, sometimes people sometimes they just replace it with the casual or the agency staff. What happened is they're not a train, is suppose they're just replacing the people, they're coming in, and what is the problem falls in, the clients are suffering. And some of the time it's I have seen, if it's one client, then they can speak out and the thing. But the problem is sometimes many clients I work with, they're non-verbal. They can't raise a voice. So we are the one, the things behalf of them, the raising the concern. But sometimes it doesn't go over. When we're raising these things, they talk, these things stays in paper, and you hear it, this time it just goes outside. So if we putting the national level for the NDIS, registration, and basically you require this qualification, this is your part of this minimum requirement. And if, for example, if you have to have a minimum medication stuff, you need whatever the clients needs, put in category wise and have it that registration. So there you be getting the quality service provided, and we make value out of whatever the funding the clients getting, that make value out of money. And it's also we can keep the more people sustainable. At this moment, personally, we burning out. So we having work so many times untrained staff, and the problem is so many clients we work with providing supporting at the same times, and it's not feasible, and we burn out, and also staff get injured, and they have to take off, and they got family to look after. So it's quite often happens. This is the issue with take care of the client as well. And when you have this kind of people working in industries, they're not trained, and they have no knowledge of it. They're just coming in, feeling easy as they got this shift. But actual reality, they're just main people who are permanent staff there. They are trained. If they have more proper trained staff, and which is providing good quality of service, and which is ongoing, and you making out, then you can see difference in a client's life. Otherwise, you won't able to see the difference.
Thank you, Mitchell. Joe?
Just to add that I'm working in Victoria and we have a very similar, we have a worker registration process that has actually led to really sort of high quality recruitment, but also I work in one of the large providers who are very aware of NDIS compliance and ensuring that, you know, we are all fully trained to the latest requirements and very strict reporting requirements of any issues or incidents. If there is even a suggestion that there's been inappropriate or dodgy conduct, then a staff member is stood down and investigated. So we're all very aware that we have to hold ourselves to the highest standards, and if some people do get through, they are scrutinised thoroughly and removed from the sector. Does that answer the question?
I think so, yeah, thank you, Joe. Can I ask a sub, the measurements that the government is putting into play, will it help? Will they help?
Definitely will help if you put in, you know, the measurement, like, you know, like registration, like the professional registration, like measurement. So it's like, you know, all bed bugs out of this system, because what happened is, so like people, like, you know, when you make like, I have like make a complaint for these things, like, you know, when they're reacting badly, you know, when you make what they're doing, they're removing, they're going out of the organ, they resign and go, but they're going another organization. When you find out somehow they're working the same, so either someone in India, same other people will be suffering because of that sort of thing. So if you have like this kind of registration, like, you know, the measurement, and you know, the like we put it in, we protect the people, vulnerable people particularly.
Thanks, Chair.
Thank you very much, Senator Tyrrell. So does someone have something they just want to add?
Look, my name's Anthony Dunn, so thanks, Chairs and Senators, for the opportunity to speak today, and thank you, Kate, from the HSC, for your really in-depth submission today, which I fully support. I work in a regional area in Victoria. The number of issues that are currently presenting around unfunded care hours, professional respect and registration, burnout and safety and regional barriers are actually compressed in. I've written over 2,000 emails to the Victorian Government, Disability Minister and the Premier regarding issues that are facing people with high complex physical needs living in SIL group homes. One of the issues I'm finding is that under the current compression of the NDIS and this NDIS Futures Bill is focused around these functional capacity assessments for people who have lifelong disabilities. I'm currently working with a person that's 70 years of age who has quadriplegia, who is non-verbal, is non-ambulant and requires 24/7 support. Currently, we're being requested through her NDIS plan to get an independent medical assessment as to whether this individual's condition will improve. Now, that is just farcical. She's 70 years of age, she's going to decline. I've had to get her normal GP write a letter of reference to stipulate that this person's condition is not going to improve. Now, if the NDIS is going to be sustainable, we need to clear out all this red tape around these responsibilities of getting these medical reviews done. It is just a waste of money, and it needs to be focused on the person's clear functional capacity and the needs of the individuals. We're finding that there is so much burnout from high-level leadership and supervision of staff. At the moment, that is not funded through the SHADS award. It needs to be funded because we need to understand that if people aren't trained, supervised and adequately protected, that the people that we support are the primary reason why we're actually here today are the ones that are going to suffer.
Thank you, Tony. I'm going to pass the call to Senator Steele John to ask some questions.
Thank you very much, Chair. So we heard yesterday from the government that they haven't conducted any modelling on the potential job losses that will result from this bill, despite the fact that the cuts to social and community participation are going to be in the order of $13 billion, meaning that that money will no longer be going towards employing support workers. What are your concerns about the potential workforce impacts, including job losses from these changes?
Well, I'll answer that, Jordan. And as you know, I've written you a number of emails concerning my concerns around the NDIS. In regional and remote areas where I work, it is so difficult at present to actually get people, A, to be interested to work in this sector, and B, that have the empathy, support and compassion. We need training standards that are required for any individual that works in the NDIS, particularly with high complex physical people. By making it more and more difficult for people to be attracted and retained by these organisations, we're finding a real workforce churn where 3 out of 5 disability support employees are either considering leaving the sector or are already leaving. Now, that's not an issue, that is a crisis, and it needs to be addressed swiftly and curiously, because at the end of the day, they are the people that provide the support to many, many thousands of people with a high physical disability across our country.
Thank you. And Ms Marshall, would you like to add to that?
Yeah, Tony speaks incredibly well, and 100% see it. This is, as Tony said, a workforce crisis. So we want to professionalise the disability sector. It should be a career. It should be something that people aspire to do. It should be like working in nursing or working as an allied health professional. They carry and do very similar roles, and it is integral to our health system that disability support workers remain a crucial part of our health system. To do that, that's where we think that worker registration needs to come in. These workers need to have the appropriate training, professional development, as I said, code of conduct, have that support around them that not only helps supports them, but also professionalises the workforce and gives them a pathway to be able to continue their career in the disability sector for years to come. Consistency for a lot of participants is key. Having this turnover is not only hurting the workers and not knowing who they're going to be working with every day, but it's also hurting the participant. Who's showing up to help me today? Their anxiety levels that they must experience can go through the roof. Having that professionalism for us is just a very simple win-win.
Absolutely. I just want to take you deeper on that too, because it was a very prominent part of our questioning of the department yesterday. So we've got $13 billion being cut from SCCP funding. That's an across-the-board 50% cut that is unilaterally implemented by the Minister. It's not limited to 50%, it can go as high as 99.9% under a future Minister or a future government, but at the moment, that's what we've got, $13 billion. Now, every single one of those dollars, as you know, goes to employing a worker directly to do their job to support the disabled person. Do you think that this kind of cut, the scale of this cut, will result in job losses?
Yeah, can I just quickly add to that, Jordan, and go and take it back a step? What I think we all forget in this situation is at the moment, people that have high complex physical medical needs are currently being supported in their own home, in SIL group homes, by really well-trained, compassionate and supported skilled staff. It'll be a double-edged sword. If these people aren't supervised and adequately provided with support within their own group homes, this will cost way more than $13 billion in job cuts. This will actually effectively end up costing states and territories and federal governments more money to their health system, because these people will be clogging up beds in aged care facilities, they will be clogging up beds in A&E, because they will not have anywhere to live. Because if you keep cutting jobs in the disability sector, there won't be enough people to actually provide the support.
And Ms Marshall, does the HSU also have a concern that these cuts will cost jobs?
Listen, can you see me? I don't know what's happened to my camera.
I can't now. I can't see you.
I'll just keep talking, and something weird happened on our end. That's okay. Listen, on the face of it, yeah, I mean, there is a concern there, and I think there needs to be more. We need more information, and we need a deeper dive into that issue on what that actually means. Because at the end of the day, people's needs do not disappear. The disability does not go away. The cost is going to remain there. People are going to need that workforce. So any sort of cuts, yeah, it's concerning, and it is, and it could be. It is concerning that those cuts turn into workforce cuts, but I can't speak with any certainty with more information.
Okay. Now, the government said in its impact analysis that, quote, while reforms are significant and will be disruptive to providers, the latent demand for disability support workers in the NDIS and growth in other parts of the care and support economy means it is not expected that the resetting, and this is the word they use to describe the $13 billion cut they're making to SCCP budgets, will create significant employment shocks or for experienced support workers. Do you believe that sounds like a fair statement?
I don't think so, because, you know, like, since like COVID, we already, like, you know, the many people, I can say, like, we already sort of staff, and since ongoing regularly staff are working overtimes and burnout, and we compromising safety as well. So like so many staff has been injured at work, and this is like on and off, and then when coming back, they're like, you know, the injury doesn't go away, and emotionally break down staff. So if this is ongoing, like at this moment, we're already struggling, and if they're gonna cut these things, I think we're gonna struggle more in the future. So, and this is not attracting the industry, because people are like, because of the injury and like burnout things, so many like responsibility talking work and all. So people are like already leaving the industries. So we want to keep the people to stay in these industries longer, so we can have like sustainability of that. We can take care of the people with vulnerable people with disability. Otherwise, it's long term. This is not gonna be good for the people, because we're gonna lose the. We already like struggling at this moment. So I'm every single day without me having like all irregular staff I'm working with.
Could I just, it's Joe, and
yes,
I just
ahead.
want to add to your question, Senator, that I don't know that the skills are necessarily as transferable as the government might think. I think that the workforce that work in, for instance, we have a lot to do with day programs, and my employer actually runs day programs, and I have staff doing that. They're sort of 9 to 3. They're doing it because they've got children, commitments with their own children, etc. Whereas I work in a SIL facility that's 24 hours staffed, and I am required to do sleepovers, weekends, mornings, nights. I start at 6 a.m, I finish at 10 p.m. So I don't, just because there will be, so essentially if we look at it, if we remove all of the clients that I work with go to day programs, even though they range between 50 and 75 years old. If they're not at day programs, we will need to staff 24 hours a day the house and need to take them out to do things like shopping and daily living skills, etc. But I'm not sure that those people who are unemployed will be easily transferable to pick up those shifts, because the shifts won't be 9 till 3. The rosters will be altered to be 6 till 4, etc. So it's not as simple as I think they like to make out.
Yeah, and my concern is that a lot of this conversation is focused on, rightly, the impact on a disabled person of a 50% reduction in the support that they receive in the SCCP area. But a 50% reduction also means a 50% cut in the hours that a support worker can be funded to provide supports for. And I'm really worried that this will see people lose potentially half their paid wage overnight. Is that a concern for the union? You represent so many of these workers.
Can I just say something too, Jordan, that you're on the money there, because those CP hours, I know people think, oh, that's getting out and about and going to the community, see family, see your friends. But those CP hours are also used for allied health appointments, for people to go and see doctors, GPs, because we just can't, the supports of a SIL group home, there's certain periods of hours through those hours that we provide support that we don't actually have the capacity to provide the opportunity for people to meet, to go and see specialists, to travel to see specialists, because we look after a cohort of people who have ageing and high complex needs. So those support levels that are taken out, if those funding hours are taken away from a person, that is just going to cause more and more pressure upon the SIL providers to be able to provide that support, given that staff ratios in high complex homes where I work, we have 3 to 4 for participants with high physical needs, with epilepsy, with swallowing issues, with high dysplasia, all those sort of things, where we need to be supervising these people 24/7. We take that funding away and take those staff away who mightn't have a job. How do we then provide that support when we don't have the funding to do it and we don't have the time or constraints? That's the biggest issue. And just before, and Senators and Chair, thank you for me for attending today, but I just wanted to make one thing very clear, and I know Kate from the HSC and HACSU have actually been really supporting this methodology, is why aren't people like myself who are house supervisors, people like Joe and people or the other representatives, why aren't we being consulted around these changes? Because we are the people that provide the support. We are the most important cog in this whole NDIS. If we don't get it right, the NDIS don't get it right.
Thank you. And just a final question. I mean, your submission went into great detail and your testimony here today has been really informative. You say in your conclusion, quote, "We urge the committee to reject the current trajectory of unchecked ministerial power and clinical narrowing." With these concerns that you've shared in your submission and in your evidence today, we as a committee have got to take it on and decide whether we make a recommendation as to whether the bill should pass in its current form. Do you, as the union, believe that the bill should pass in its current form?
No, torpedo it, Jordan, torpedo it.
Sorry, Senator, my camera's decided to pack up. But no, we don't want the bill abandoned, but it needs to be improved. There are significant gaps that our submissions and what we spoke about today, particularly around the workforce, is huge. So no, the short answer to that question is no, not in its current form. It makes some good steps. It's a good start, but there's some improvements that can be made.
All right.
Yeah, I agree with that one, because this is like even like regular day by day we're just doing unfunded work, support the client and all. Like sometimes we don't doing the work for the client, but we don't get paid for it. So sometimes we have to do incident report or all sort of stuff taking client medication, drop off, pick it up. We sometimes working unfunded hours. So just to because when you're working with the vulnerable people, you're just doing it as in your own family, basically.
Okay, and Mr. Dunn, you said something in there, but it got a bit crossed with Miss Marshall's audio. Do you want to repeat?
Yeah, as I said, Jordan, I just think what we need to make sure is that we don't have unintended consequences on the people we look after. At the end of the day, I know politicians of all shapes and sizes and of all different persuasions have to make decisions around budgetary constraints for the country, but at the end of the day, we are making decisions for people that are highly vulnerable, they're complex, a lot of them are non-verbal, a lot of them don't have any family supports or advocacy, and at the end of the day, I'm really strongest of opinion, who gives a politician the right to make a decision on a person who does not have any advocacy whatsoever, has no ability to be able to consult other than the people that look after them? And I still said, as I said before, the most important cog in this whole NDIS is the support workforce. And I couldn't be more strong and focused about that.
Thank you. Thanks very much for your evidence.
Thank you. I have one very final question, and because we are coming up against the lunch break, my question is to Ms Marshall. I think it's really important for us to recognise throughout the course of this hearing that the scheme will continue to grow, and this bill is ultimately about slowing that growth. So in that context, are there ways the government can work with unions like yours to provide greater certainty about the size and the shape of the future workforce as we implement reform to the NDIS?
I think just reflecting back, I think it was what Tony said before, was around consultation. So there isn't a single advisory committee that a union sits on that is able to voice the opinions and views of our members, you know, like those are Tony, Middle and Joe here today. It'd be a fantastic opportunity to be able to form advisory committees where workforce can be front and centre, and our members' concerns, those actually on the ground doing the hard yards every day, are able to be heard. And I think it would be integral for the government to hear their views and what they see and experience on the ground. So that would be a step forward, I think, is having a consultation mechanism where we're able to have access to those decision makers to be able to influence what the final bill looks like.
Thank you very much, and I thank all of you for appearing before the committee today and for your evidence. It has been great to have the voices of workers as part of these committee proceedings. The committee will report to the Senate on the 14th of August 2026 and has agreed that responses to questions on notice should be provided by the close of business Thursday the 6th of August 2026. The committee will now suspend for a lunch break and recommence at 1:20 p.m. Thank you. Hello, good afternoon. The committee will now resume. This session is an opportunity for the committee to hear from members of the community about their lived experiences, and I remind the committee that this session is primarily a listening experience. My name is Senator Ellie Whittaker and I'm the chair of this committee. I'm joined in the room by Senator Steele John, and online we have Senators Antic and Senator Tyrrell. I would like, before we proceed, to remind witnesses that this is a public hearing and these are formal proceedings of the Senate, and the hearing should be conducted in an orderly and respectful manner. I would also like to remind witnesses not to disclose any personal or private information, such as your full name, date of birth or address, during the statement, as the audio of the hearing is being broadcast live. Please be aware that today we have representatives in the room from the NDIA who are able to help with any concerns raised during this session. And if you would like to speak to those representatives, you can speak to the Secretariat staff after your appearance. I welcome all of you to today's panel. We're joined by Sam, who I believe is online, Rosie, Claire, Kirsty, Andrew and Shannon, who are in the room, and Daryl, who is also online. Thank you for making the time to appear before the committee today. What we will do before we get into your statements is I'm going to ask each of you to state your name, your first name only, for the benefit of the Hansard script. It's a little bit strange because I'm going to say your name and then ask you to repeat it back, but it just helps the Hansard in knowing who is talking. So I'm going to start on my right in the room with you, Rosie.
Hello, my name is Rosie.
Thank you. Claire Louise.
Hello, my name is Claire.
Shannon.
Hello, my name is Shannon.
Kirsty.
Hi, my name is Kirsty.
Hi, my name is Andrew.
And Daryl?
Hi, my name is Daryl.
Thank you. I think Sam may have dropped off. Just double check. All right, hopefully Sam can jump back on at some point, and then we can hear from them if they do. So I will invite each of you to make a short statement. It would be very much appreciated if you could keep your statement to under 10 minutes so that we have enough time to hear from everybody, and we have a very, very heavy program today. So I will ask each of you to speak in turn and to provide your statement to us. Would anyone like to volunteer to go first? Shannon, excellent. I was hoping someone would put their hand up. I will pass to you.
Chair, Senators, thank you. Thank you for giving us the opportunity to speak today. I am Shannon, a mum, not a lobbyist, not a lawyer, but I am here today with my son to show him you have a voice. You matter. And if you believe in something, you fight and you don't stop. Disability has been a part of my children's lives since their birth. I've spent their whole lives loving them, protecting them, and fighting every system that was there, put there to help them. My daughter's nearly 15. She's profound, lifelong disability. She's about 120 kilos. She's nearly 5'9", with the functional understanding of a 1-year-old. She cannot be left alone, and she will never live independently. Thanks, James. No treatment will make her disability temporary, yet every planner makes our specialists prove the same permanent facts again. There's nothing ordinary or fair about that. Our home modifications were approved in 2020. They never happened. Planners changed, the process reset. In 2026, the agency is again asking us to prove it and prove a need that has already been accepted. She was about 45, 50 kilos then. She's now 120 kilos. She just got bigger and stronger while bureaucracy stood still. Our walls are patched and she's broken another 18 windows and it's not safe. I have been told that a QCAT order is irrelevant and just to medicate her. Those words land hard in a home that's already running on fear and exhaustion. My son entered the scheme in 2018 with Cantu syndrome. He also has an intellectual impairment and level 2 to 3 autism, which was diagnosed in 2020, which are presentations of his Cantu syndrome. But at our latest planning meeting, I was told he's on the scheme for autism. No one can explain who changed the recorded basis of his access and when it was changed or why it was changed. A person-centred scheme must see the whole person, not whichever disability or part of the person the agency chooses to recognise. And where is the safeguarding? Where's the accountability? I have seen registered providers ignore risk and leave vulnerable people exposed. Registration is not proof of quality, and registration does not mean protection. My family knows that firsthand. A matter involving an alleged serious violation by a registered provider is presently before the courts, so I cannot discuss the facts publicly. But what I can say, it took the NDIS Quality Safeguards Commission 10 months to make a decision, and the outcome was only a 2-year banning order in relation to the alleged conduct serious enough before the criminal courts, and the owner of the business never had to pay a cent back of that funding. There is an alleged breach of service agreements and violations. When alleged conduct reaches that level, families are entitled to ask whether registration, provider auditing, investigation and enforcement are fit for purpose. Frankly, the auditing process as it stands is a joke. A provider can pass an audit. It does not prove that the participant is safe in their hands. Paperwork doesn't protect a vulnerable person when the door closes and no one's watching. Australians break car windows to rescue dogs from heat. I've also seen disabled people left unattended in cars and vans. And too often, animals receive greater urgency and protection and compassion than disabled human beings. When families report abuse, the police say it's an NDIS matter. The NDIS says call the police. And then the NDIS Quality Safeguards Commission may or may not call you back, depending on how the person on the other end of the telephone is assessing that report. Where is the governance? Which body has the legal duty to take ownership of the report? Protect the participant immediately, preserve the evidence, investigate what happened and report back. At a town hall meeting, I told Bill Shorten that the number of times I have reported concerns involving families and registered providers, keeping participants out of sight, using restrictive practices and leaving people exposed in the hot sun with no water. These are matters I cannot and will not describe in a public forum. Some evidence is way too sensitive and I could identify profoundly vulnerable people, but I'm ready to provide that evidence safely through a protected process. I invite the Commission to sit down with me. I've documented well over 100 providers. 100 providers, registered providers. Somebody needs to get angry about this. They need to get angry about this. These people can't talk. Somebody should have said it's abuse, human rights. Enough's enough. It's enough. We all We all need enforceable protection against reprisals for participants, families and workers, advocates and whistleblowers who are prepared to step forward, speak out and provide evidence. Sorry.
It's okay. Take your time.
You've got this. You've got this.
If telling the truth makes a person less safe, then silence protects the abuser. There needs to be proper governance for support workers. We're understaffed, and I've been told repeatedly that I've hit the jackpot with support workers. I have, they're my unicorns. They do not babysit, they support. It's in the job title. They understand that their role is to build capacity, protect dignity, uphold autonomy, protect and communicate what it looks like for them, that person, my babies, my daughter. But families should not have to hit the jackpot. The safety and quality of person support should never depend on luck. This is not about condemning every support worker, but it's about recognising some workers move on from one provider to another and then another, while complaints and concerning patterns and poor practices disappear behind them. The existing national screening database records whether a worker has clearance or exclusion. It does not provide families with complete, usable, quality history that they need when they're deciding who may enter their home and support their profoundly vulnerable person. We need proper, comprehensive national worker data system, reporting platform, or an independent body which participants and families can verify screening status, qualifications, training, substantiated findings and banning orders and regulatory action. The system must contain procedural fairness. It must distinguish allegations from substantiated findings, but also stop serious patterns from disappearing every time a worker changes employers or providers. We need compulsory screening, a national minimum standards, mandatory core education and continuing professional development. If workers in aged care are commonly expected to hold a Certificate 3, why is there no equivalent national minimum foundation for disability support workers? The Disability Royal Commission handed down extensive recommendations, 222 of them, including a recommendation for a national disability support worker database with a minimum standards, compulsory screening and continuing professional development. Families are waiting to experience that protection in practice. Safety can not remain as a recommendation on paper. Delegates and planners also make life-impacting financial decisions that determine whether a person is safe or whether a family collapses. Yet there's too little visible accountability for delays, ignored evidence, altered records, and administrative failures or careless words. The NDIS promised people would thrive. Many families are just surviving. Some people are just simply existing. We are determined to keep our profoundly disabled children within their families and their communities, not segregated and hidden away. We are the first generation to keep our kids, our 1 percentiles. We are the first generation. We're still dealing with the archaic of they should be seen and not heard, that they're blights on the system, and the media, how they put it out about our kids, our families, that they're a cost and they're a burden. Yeah, let's just take them back to Kew Gardens. The last one shut in 2020. My daughter was 9. When she was 2, I was told by a doctor, relinquish her into the system because all she's going to do is cause you heartache and pain. That kid and that kid there behind me give me more than what I could ever give them. They're the best. They're the best kids. They're not perfect, but they're perfect for me. They're my babies. My daughter will never grow up. My son will grow up and he will have some kind of independence. But Meadow won't. She'll never grow up. She will never leave home. I will be changing nappies until I die. And I do it because I love her. But going back year after year, planner after planner, lifelong, significant and permanent. Level 3 non-verbal autism does not change. Profound intellectual impairment doesn't change. There's no treatment, there's no magic pill, there's no magic carpet, there's no magic wand. I've made my peace with it. I love her. I love him. They are who they need to be. They're both individuals and they do it in their own time and their own terms. But when you've got ignorant planners and uneducated planners sitting across from you, asking you, you have failed your daughter because you have failed to toilet train her. You don't think I tried? You don't think I tried? And when I reported what happened to our family to the planner, complex needs support branch planner, he said, and this was from a PBSP practitioner, the violation happened. He said, that's unfortunate. Where's the PBSP? At what price should I have paid for a piece of paper? These are my children. Their bodies do not belong to the NDIS. They do not belong to the system. They need to stop using them as collateral damage. They have rights. They do. They're my babies. I'm just going to wrap it up now. So sorry.
It's okay. You don't need to apologise.
We're determined to keep our profoundly disabled children within their families and the communities and not segregated and hidden away. But keeping profoundly disabled people at home cannot mean abandoning families to provide institutional levels of care without safe, competent, reliable support. What keeps me awake at night is dying. Who will protect my children when I'm gone? Who will wipe my daughter's bottom? Who will change her? Who will keep her safe? And who will fight the system for their basic rights? Ministers Butler and McAllister, you have children. Have you had to make plans who will care for them, your adult children, after you die? Have you had to decide where they'll live, who will protect them, who will fight for their basic rights when you are no longer here? We have no family. It's just us. We have to get a trust and a will and a board, and people don't know that. But I want everyone to know, disability does not discriminate. An Australian can go to work one morning and be disabled by the end of the day. It can happen to anyone at any time. It can. So do not give the system more power to reassess, fragment, automate, or cut people's lives without enforcing the safeguards. Require whole person decisions, respect permanent specialist APRA evidence, honour prior approvals, set binding deadlines, protect whistleblowers, proper register, educate, govern the workforce, make delegates, planners, providers and regulators accountable. I am. If I left the NDIS tomorrow with my kids, one system, I would have CPS, child safety, another system right up me. I can't get out of the system. I can't, I'm stuck because I happen to have 2 genetically rare kids. It's insane. Sustainability will not come from forcing families to prove and reprove the same permanent truth again and again and again. It will come from preventing abuse, acting on evidence, getting decisions right the first time, and treating disabled Australians as human beings with equal rights. I am resilient. I am. But I should not have had to become the beast that the system created. Just simply because I've got 2 disabled kids. I'm known as the pit bull. Please build an NDIS in which I do not have to live forever for my children to be safe. People don't know what it's like to be scared. And it sounds heinous. My daughter, our disabled, have an earlier death, a shorter life. They make us fight every year, for that short period of time. She'll be lucky to see 40. She's got tumours in her leg. We think she's got tumours in her brain, but we've got to get a new wheelchair because the wheelchair's broken. But we can't get her to the hospital without a bloody wheelchair. So, you know, same old. But the only governance that I can take out of this is she will have a shorter lifespan. But if she dies before me, and no parent ever wants their baby to die before them, at least I know she's safe and I'm willing to put up with that pain. My life is hard with my kids in it, but it's impossible to live without them. They didn't ask to be born. Dude, look at him. He is amazing. He has gone through hell by a trusted person, a registered provider. So I'm teaching my son, you get up and you fight. You will not be silenced. And you don't stop fighting. Yeah. Love you. Thank you.
Thank you. Kirsty, would you like to go next?
Sure. Sorry. No, you did great. Don't be sorry. You nailed it. Okay. Sorry, I'm just gonna...
It's okay. Can take a minute.
Oh, no, it's fine.
Yeah, would people like to take a short recess?
5 minutes, just so that everybody can reset.
Okay.
Emotionally.
Let's do that.
Yeah.
Yeah, I will now ask Kirsty to give a statement. Thank you.
Thank you, Chair, and members of the committee for the opportunity to appear here today. My name is Kirsty, and I'm a proud autistic woman, a working parent, and a carer to a teenager who is autistic, has ADHD, and an intellectual disability. All of these things intersect, yet he's only funded for one of them. I'd also like to begin by acknowledging disability and neurodivergent advocates, families, LGBTQIA+, and CALD, First Nations communities, and everyone working to advance human rights. And I also want to acknowledge my own privilege in being able to be here to speak today, because there are many people whose voices are never heard in rooms like this. I'd also like to note that I appear today at great personal risk because fear of agency retaliation is real and founded. But I'd like to tell you guys a story. So Fatima owns a small coffee cart. It's a successful small business that employs 2 casual staff, Jenny and Mark, who are both studying political science at university. The flexible work allows them to earn an income while completing their degrees. Fatima also has a 22-year-old son named Joseph, or Joe, who is autistic and has an intellectual disability. Every Tuesday, Joe's support worker Peter takes him to his GP appointment before supporting him to do his grocery shopping. They return home together, unpack the shopping, prepare dinner, organise Joe's washing, and lay out his clothes for the next day. On another day, Peter supports Joe to run a small stall at the local market. Joe helps to set up, serves customers, and has built genuine friendships with other stall holders. He's not being taken somewhere to fill in a few hours. He's a stall holder. He contributes. People know him, expect to see him, and notice when he's not there. That is what real community inclusion looks like. Joe has a valued role, genuine relationships, and a place where he belongs. It took time, consistency, and the right support to build. If Peter's support is cut, Joe doesn't just lose funded hours. He risks losing his role, his relationships, and his place in the community. While Peter supports Joe, Fatima is at work. Now imagine Joe's funding is cut and Peter's support is no longer funded. Fatima can no longer leave Joe safely with Peter on those days. Instead of running her business, she has to provide the support that Peter once did. The coffee cart can no longer operate as it used to, and if the cuts continue, she may have to close it altogether. So Jenny and Mark lose the jobs that supported them through university and may need study or other income support while searching for work. Fatima is no longer earning an income or paying tax as a small business owner. Instead, she may need the carer payment because she can no longer work while providing the support that Joe still needs. Peter loses work as well. Joe is not his only client whose funding's been reduced. When several participants have their plans cut, Peter no longer has the hours to maintain sustainable employment and may also need income support.
Christy, could we just jump in? There's news cameras in the room that are just about to start filming. Are you okay for that to occur?
Yeah, that's fine.
Is that?
Can I just confirm that I was going to wait until you finished. I didn't want to interrupt, but we do have a camera. Yes. If anyone is uncomfortable, you can absolutely say that you'd rather them not be here. That's absolutely fine. So I just want to make that really clear.
As long as he doesn't make any of us look fat, we're happy.
Love it. Cameras are notoriously not very good at that.
This guy's been quite good to me over the years.
Okay, great.
We want Oprah's filter or the Kardashian.
Yeah.
Hey, we want you to work your magic.
We will then proceed. Thank you.
Should I just keep going and ignore the little man?
Yeah,
Okay.
just pretend he's not there.
Little man.
Other?
Okay, so where was I? Right. Peter loses work as well. Joe's not his only client whose funding has been reduced. When several participants have their plans cut, Peter no longer has enough hours to maintain sustainable employment and he may also need income support. So that one funding cut for one person's plan has now potentially affected 4 people's employment. Before the cut, Joe was participating in his community, Fatima was running a business, Jenny and Mark were working while studying, and Peter was employed. And afterwards, 4 people may no longer be working or paying tax. Small business accounts for around 1/3 of Australia's GDP and employs more than 5 million Australians. When a parent like Fatima is forced to close a business because her son's supports have been cut, the impact extends far beyond one family. She loses her income, her staff lose their jobs, and the community loses a local business. If this is what we call sustainability, then I think we need to reconsider what that word means, because pushing people out of the workforce and closing small businesses is not sustainable. You can cut a person's NDIS plan with a simple stroke of the pen, but you can't cut the need that existed before you took the funding away. It still exists. This isn't just a disability issue. It's a workforce and productivity issue. Cutting disability supports doesn't save money. It shifts the cost elsewhere onto carers, businesses, the welfare system, health services, and the broader economy. What you might think is a saving just turned into a far greater cost. Fatima's story is hypothetical. My story isn't. My son is autistic, has ADHD and an intellectual disability. Like many NDIS participants, the funding in his plan does not adequately meet his support needs. I don't have the option of stable full-time or part-time employment with predictable hours, annual leave, sick leave, or superannuation. I rely on flexible contract work because it allows me to respond when my son needs me, attend appointments, advocate across multiple systems, and provide care when funded supports are unavailable. My son also had to leave mainstream school because his disability support needs were not being adequately met. That meant that I became even more responsible for coordinating his care, education, and daily support. The flexibility of contract work is not a lifestyle choice. It is a necessity created by gaps in both the disability and education systems. I love my work. I am qualified, experienced, and passionate about my work. Yet the inadequate supports available to my own son restrict my ability to participate in the workforce. And I know I'm not alone. Many parents of children and adults with disability are also carers. Some of them are highly skilled, really important people working across every sector of our economy, including nurses, paramedics, teachers, police officers, hospitality and retail workers, and public servants, some of whom probably work in this very building. Many have reduced their hours or even left the workforce altogether because they have become the support system of last resort. These are people who really want to work so they can provide for their families, but the simple fact is that if there's not enough funding to pay for supports, carers can't work. There's a whole workforce gone. We're also failing our teenagers with disability. These are the years when they should be finishing school. Some of them should be learning to drive if that's right for them, building their independence, developing their skills and working out what they want their adult lives to look like. Instead, too many are losing supports, being pushed out of education and becoming more isolated at the exact point their worlds should be getting bigger. Then they reach adulthood without the experience, opportunities or relationships that they were never given a chance to build. And the same systems that failed them act surprised when they're unemployed, living in poverty, experiencing crisis, or becoming involved with the justice system. These outcomes are not happening because they're disabled. They happen because we keep denying young people the support they need, pushing them out of education and into segregated settings. What kind of future are we offering young people if the only pathway we create for them is living at home on the DSP and attending a day program? That is not inclusion, that is not choice and control, and it's not good enough. The NDIS is not just about costs and numbers. We're talking about real people with real needs and real lives. This bill is being sold
as a way to make the NDIS sustainable. But when people can no longer work, businesses close, young people lose opportunities, and costs are pushed onto already underfunded and under-resourced hospitals, housing, welfare, and the justice system. That is not sustainability. It is simply deciding that disabled people and their families should carry the cost instead, and Australia will be living with the consequences for generations to come. Thank you.
Thank you, Kirsty, for that evidence today. Rosie, would you like to go next?
Thank you. Good afternoon, and thank you for inviting me to speak today. My name is Rosie. I'm a disability advocate, accessibility consultant, and a former community engagement coordinator at a disability representative organisation. I'm a proudly disabled person based in northwest Lutruwita, Tasmania. But like millions of disabled people across Australia, I'm not an NDIS participant myself. Today I'll be speaking from my experience translating and communicating these reforms for our community, documenting and responding to people's experiences as they unfolded, and witnessing the profound distress and real-world impacts that they've already had. One of the reasons I accepted the invitation to speak today is because I think this committee is being asked to consider these reforms as though that there's something that will happen in the future. From my perspective, that's simply not the case. Since late 2024, I've watched the rollout of large-scale eligibility reassessments, then the announcement of foundational supports and Thriving Kids, and now this bill. While other witnesses have spoken to the statistics, I want to speak to what it looked like from where I was sitting. I spent months being the person responding to hundreds of frightened people, trying to understand what was happening to them. Parents wrote paragraphs and paragraphs in the comments section about how terrified they were that they would lose the vital supports that their child relied on. I spoke with disabled people who felt like they were being asked to prove yet again that their disability existed. I watched people become so overwhelmed by uncertainty and in many cases express thoughts of suicide because they could not see a way forward. Again and again, families were told that the specialised supports that their children relied on were ultimately their responsibility to provide, and if they couldn't, then they should just give up their children. That's why the proposed parental responsibility provisions in this bill are so concerning to me. It's actually a continuation of a message families have been hearing from the NDIS for the last 18 months, but now it's embedding and deepening the harm through legislation. At the same time, in the lead up to the new bill, public conversations around the NDIS increasingly became focused on cost, sustainability and abuse of the scheme. Everyday disabled people were forced to navigate a media environment that increasingly portrayed them as a burden, at the same time as desperately trying to understand the complex reforms themselves, let alone trying to work to look after their family or experience any sense of joy in their life. I watched that change people's trust, not just trust in the NDIS, but trust that the broader community believed they deserved support in the first place. By the time the bill was introduced, the damage had already been done. The fear, the uncertainty, the loss of trust had become a reality many disabled people and their families were already living. We have already seen the distress and harm that occurs from people being removed from the scheme because it is already happening. What new levels of crisis is the government willing to accept when 240,000 more are removed without any alternative? Over the past 7 months, there have been multiple cases where disabled children have been killed by their parents. Whilst those cases continue investigation and cannot for certain be linked to reforms, when I heard the news, my first instinct wasn't shock. It was to wonder whether I had spoken to those families, whether I'd responded to one of their emails, whether I had seen one of their comments online. And it took everything in me to not go search for those names immediately. It was to feel that this would happen again, because I was hearing the sentiment almost every day. People, but particularly parents, sharing publicly that they didn't know how they could keep going if the cuts happened to them. I remember one person who shared that their partner had taken their own life because they could no longer cope with the complex systems that refused to provide the support their child needed. I still carry a sense of guilt. I wonder if I had made more videos explaining the reforms or answering more comments or advocating just a little bit harder, that I could have changed something. The government must recognise what prolonged fear, uncertainty, and a lack of support does to people. Who in the government will feel a sense of guilt? That is why I struggle when I hear claims from our Minister for the NDIS that these reforms won't have life and death consequences. They already have. Throughout this process, my role has been to translate government policy into plain language for disabled people and their families. Today, I've spent time trying to translate their experience back to you. In my view, the harms I've described are not issues that can be addressed through minor amendments. They stem from the underlying approach that this bill takes, and for that reason, this bill should be withdrawn. We cannot legislate our way out of a crisis by embedding the very practices that created it. Thank you.
Thank you, Rosie. Claire Louise, would you like to go next?
Thank you. Thank you, Chair, and thank you to the committee for your dedication in the committee and for allowing me to speak, and to my fellow advocates. The NDIS, it's often said, is a plane being assembled in mid-air. A cliche because it's true, but it does not go far enough. The assembly instructions arrived in every language but English. No one on board agrees on what we're actually building, and as the ground rushes up, we're all hoping like hell that it is a plane. The honest question is not whose budget carries the blame, it's simpler. Wouldn't it be better if we just actually fixed it? So let me show you part of the problem here. Support worker arrives to care for someone, and she's wearing a home detention ankle bracelet. When I reported it to the Department of Magical Thinking, otherwise known as Quality and Safeguards, you'd never guess what I was told, that she had a right to work. We screened the school canteen volunteer harder than we screened her. That's not an isolated failure. It is the system working exactly as it's built. And families and participants were never all told. There is a world of difference between registered and unregistered, not always, but and many didn't even know that such a thing existed, that there was a difference. Many GPs have argued with me till they're blue in the face that there isn't such a thing as a registered or unregistered. It's the NDIS, of course they'll have everything. There's no choice without informed consent, and no informed consent without the information. You cannot hand someone a decision, withhold the one fact it turns on, and call it autonomy. The peak bodies fought hard for the right to choose. I want to know who fought quite so hard for the right to know what they were choosing between. The assumption that someone must have checked has a name. It's called social licence. The protection we extend to a system we are told to trust. We would be furious to call a plumber and find out they're not actually qualified to unblock a toilet, yet we sent unscreened, untrained, sometimes dangerous people to do the most intimate care for the most vulnerable people in the country, and we called it their choice. The question is not whether the NDIS costs too much. It is how did we spend such an extraordinary fortune and still get it so wrong? Well, here's my answer. Somewhere along the way, we decided the human rights model and the medical model were opposites. Now, I don't mean the medicalised model like it used to be. We chose rights and stripped any sort of medicine or clinical out. But a person is not a body or a set of rights. A person's both. And it is not a human right to deny the needs of the disability that places a person on the NDIS in the first place. Strip the clinical reality out in the name of choice and you do not get freedom. You get diagnosed, undiagnosed diabetes for years, medication that suppresses a person's breathing until they can only whisper, pressure sores, avoidable admissions, lives quietly shortened. I've seen every one of those, not in the records of the past, but in people alive today. We built the system as though capacity were a switch on or off. It's not. It's a spectrum, and it differs from one decision to the next. We cannot let people who cannot weigh a decision carry the choices that shape their own safety and then call the risk that follows autonomy. That is not choice, it's abandonment, wearing the language of choice. What we need is capacity assessment fit for purpose, one that accounts for cognitive function as well as physical, not a box tick that waves the question through and hopes for the best. And we cannot penalise or stigmatise people for their disability by relabelling it as behaviour. I really do object to that. A person's disability is not misconduct. Distress from an unmet need is not defiance. File disability under behaviour and you punish the person for the very thing that put them on the scheme in the first place. And now we raise the penalties up to $16 million for a disability provider against roughly $1.5 million in aged care. Ask what that gap is really insuring against. It looks a great deal like the government's own incompetence. And it is written by governments that cannot meet their own standards. In my state's own Auditor General found the South Australian Government, a registered provider of course, non-compliant on billing and paying its own disability workers outside their award. But here is the part that should stop this committee cold. You cannot withhold the very information that makes safe care possible. If I FOI something from the NDIA and I have the participants' consent and it's not shared, and then say I go and spend $3,000 to get said medical documents and I discover things that really change things, there's a problem. The handover, the history, the risk, and then penalise the provider for the absence of the practice you made impossible. You cannot make good practice impossible and then fine its absence. Give providers what they need to risk manage, or do not pretend the failure is theirs. In my state, the government is the 4th largest disability provider, South Australia, by the way. Not by ambition, by default. It kept the most complex people itself because in 2017 it told the Productivity Commission the sector could not safely take care of them, then did nothing to build that capacity. On its own audited figures, its direct service costs about $136 million when they remembered to bill for it. A year to deliver against $133 million it bills the scheme. It was $236 million it cost, and they were only able to bill $133 million. And with a net loss of around $103 million to serve roughly 471 people. And that sits inside a disability program running at an audited net result, near negative $950 million a year. This is the level of government closest to the coalface, and even it cannot make the model work. Meanwhile, the people who actually do this work, where the safeguarding actually resides, are treated as though they wipe bottoms and chop carrots. We need trained, dedicated, committed staff. Instead, we build worker exploitation and a student visa culture of untrained labour into the very substrate of care. That workforce costs the country around $300 million a year in workers' compensation. I'm yet to see an NDIS plan that accounts for the weight of the participant and needing 2 support workers. On Safe Work Australia's own figures, healthcare and social assistance now carries the highest number of serious injury claims in the country. Nearly 30,000 a year, 1 in 5 nationally. Psychological injury is up 160% in a decade. Assaults have more than doubled since the turn of the century. And behind those numbers are women who are asked, the indignity support workers who are asked to use a she-we. And we send them in blind. We hide the information that keeps them safe and enables providers to do risk management. A young female support worker is sent alone into a home where a man is under a forensic order or has a history of sexual offending. Not all the time the provider or the support worker knows. And told nothing about what she's walking into. That's not privacy. That's a safety failure waiting to become a headline. And there is no training to recognise serious mental illness, no way to identify it, no idea what to do when it presents. Ask the mental health triage lines now swamped with NDIS calls. What happens when you put untrained staff in front of acute illness? So let me say this plainly to anyone who frames NDIS cuts as a saving. You have no right to call it a saving. When you are not removing the cost, you are only moving it. Cut a person's support and they do not obediently stop needing care. They surface in the emergency department, on the ambulance ramp, in the mental health unit, in the justice system, in child protection, in homelessness. And most of these are the state's cost. That is not fiscal responsibility. It's detonating the bill in someone else's budget and calling the crater a surplus. And there is no saving when the system manufactures the very cost it complains about. Poor care does not simply fail a person, it makes them more disabled. They cost more. Undiagnosed conditions, pressure sores, over-medication, infections, the slow harm of neglect, each one anew. Often permanent comorbidity laid on top of the original disability. Their needs grow, their funding grows, and then that growth is held up as proof they were high cost all along. You'll never cut your way out of rising costs that the scheme is causing. So name the fixes plainly. Run some sort of a medical model alongside the human rights model so we can acknowledge the needs. Not instead of it, but make handover mandatory. Make sure providers are able to do the risk management. Give providers the information they need to risk manage. Require that the person at the door is qualified, screened and known. We had this big to-do with all the childcare centres, but we don't have with non-verbal children in homes where there's not the supervision of a childcare centre. Write a capacity law worth the name and turn the accountability back into the agency and the commission that designed this. Not only onto the providers, the workers, the participants and the families holding it together at the edges. Because here is what should trouble this Parliament most. We have reviewed everyone, but the people responsible for the mess. A Royal Commission, a review, inquiries into providers, workers, participants, but no serious scrutiny of the architects. And nothing about us without us has quietly become nothing about us without some of us. Never all of us. Yes. The quietest people...
Thank you.
Thank you.
Thank you.
The quietest people, the ones without the capacity to advocate, vanish from the conversation entirely. To the support staff who work tirelessly and donate their own time, I see you. To the mums and dads and spouses who support unsupported, I see you. To the providers who sacrifice their livelihoods to fill the reality gap and subsidise the government, hang in there. You are my faith in humanity, all of you. And to the participants who live in fear, I see you too. And I will leave you with what I have come to believe after all of it: the systems are worse than the people. The institutions are crueler than the individuals who staff them. Cruelty is almost always systemic before it is individual. And what stands out across all of it is the gap between what people are capable of and what their structures allow, which means the work of fixing this is not done at the level of individual virtue, not the worker, not the family, not the provider doing their best. It is done at the level of structure and at the level of architecture. It is time for the system and the administrative triad to be held accountable for their incompetence and maladministration. And let me be clear, I do not ask for anything I do not already give. Canberra is a registered provider. I am audited, I am scrutinised, I am on the front line, and I pay with my body too. I have already stood in that queue. So to the Parliament that will demand competence, handover, accountability and humility from a broken sector, I say only what I have said before, by all means, but you first, mate.
Thank you, Claire Louise. Andrew, are you ready to go next?
Thank you, Madam Chair. Yes, I am. Dear members of the committee, I wanted to thank you for this opportunity to speak before you. I am aware that as an autistic person, I am able to speak where many non-speaking autistic people can't. I have three very serious issues which concern me about this bill, to the point where I believe it should at the very least be torn down to its foundations and be rebuilt from the ground up. I also wish to note, as with other participants, that as with my submission to the Royal Commission, I do have some concerns about potential retaliatory actions by the agency potentially. The first issue is how cuts to social and community participation funding place assistance dog handlers like myself at greater risk of harm simply for trying to participate in our communities. The second is how thriving kids risks returning disabled children to the very conditions which enabled the institutional child sexual abuse, bullying and attempted murder which I experienced throughout my Catholic education. The third is the striking historical parallels between the language now used about disabled people and the language which ultimately led to the genocide of hundreds of thousands of those of us with disabilities during the Holocaust, such as the similarities between social licence and sustainability versus useless eaters. First of all, I'd like to talk about assistance dogs. I have autism, ADHD, complex PTSD, and major depressive disorder. Because of this, I require an assistance dog to safely access my community. Her job is to detect panic attacks, overwhelm, help ground me, and provide pressure therapy. Sadly, over the past 2.5 years, I have experienced a litany of ableism, which, if it were racism, could probably be a Jordan Peele movie. At the beginning of 2023, my wife and I moved to a country town. It was supposed to be a tree change and a chance for me to build my independence. Instead, it became a nightmare. Local police later told me that just weeks before we arrived, someone had taken 4 fake assistance dogs into local businesses, terrorised staff and threatened violence. I was mistaken for that person and became a target for other people's anger. I worked with police on community education programs. I adopted protocols to try to bend over backwards for people. It was thrown in my face. People deliberately interfered with my assistance dog when she was working. People would make noises deliberately just to spook her. Some people even encouraged their children to interfere with her. My medical treatment was sabotaged. My NDIS supports were sabotaged. I was even told once that my disability and trauma were the result of my sin, while being told the whole thing was nonsense. Then, just 2 days after my father's funeral last year, which was 3 days after my birthday, my former psychologist weaponised my child abuse and those protocols against me. Apologies for that. That behaviour hasn't stayed in town. It followed me into the regional city where I now live and even into Canberra itself. People treat my assistance dog, my medical equipment, as a novelty. Others decide that if I can take my dog into a shop, they should be able to take theirs too. When I speak up, I'm gaslit, bullied, and on one occasion, I was even threatened with assault. And as just this last Monday evening showed, I can't even take my assistance dog out for an evening toilet walk without being harassed, threatened, or called a retard. This isn't just about funding, this is about public safety. My current plan doesn't even provide enough funding for me to safely leave my home with a support worker for 4 hours a week across an entire year. To be here today, I had to give up my regular day of safely participating in my own community so I could use the same support worker hours to attend this hearing. Think about that for a minute. To participate in a parliamentary inquiry about disability, I had to give up my opportunity to safely participate in my own community. If this government reduces that community and social participation funding any further, I effectively become a prisoner in my own home. So if the government intends to reduce that layer of protection where a support worker is the one layer of protection from harassment, violence, abuse, etc., then where are the public education campaigns that the government is funding on primetime TV about assistance dogs? Where are the penalties that deliberately interfering with an assistance dog handler in the same way we'd treat pushing a paraplegic out of their wheelchair? Some of the very people who've bullied me online have demanded to know why I need an assistance dog. Well, one of the reasons is because of what happened to me in the Catholic school system in Sydney, which leads me to my concerns about thriving kids. I attended Catholic primary school and high school in Broken Bay Diocese near Hornsby from 1984 to 1997. My primary school didn't even have a special ed teacher until I was in year 5. In environments like that, teachers can find it all too easy to take their frustrations out on disabled children, while the children very quickly learn who they can prey upon with impunity because there is no line in practice that they can't cross and because they know the victim will always be seen as the problem when they react. That was my childhood. In fact, my mother recalls one of my former primary school teachers later confiding in her at a mutual gathering of a mutual friend that as badly as the other students behaved towards me, my worst bullies were my teachers. By year 2, I was already being excluded and ostracised, only to have teachers berate me for being antisocial when I took a book to read. By year 6, I was being openly assaulted, sexually coerced, and sexually humiliated in the playground, while my teachers turned a blind eye to it and even blamed me for it. After the 3rd assault, my principal threatened that if it happened again, my parents would be called to the school to deal with me, not my assailants, me. My mother demanded a meeting with my teacher when she got wind of it. She still remembers my teacher in an act of constant belligerence amongst other things, stabbing an index figure down onto my file, which at that time was over 20 centimetres thick, contained over a century of professional experience, and saying, "And as for that, I don't believe a word of it. He's just immature." When I went to high school, the bullies who abused me there followed me to that high school and were joined by other bullies. The bullying and violence continued. In 1995, on my Year 10 school camp, I was repeatedly sexually assaulted, where I was pinned down while lewd acts were performed on me, while everyone else in the tent giggled. I was also propositioned for sex on the second night of the camp, with that same giggle that had come to mean anything but a joke. By year 11, my year coordinator was threatening me with violence at school assemblies, while classmates assaulted me and gave each other nicknames like brutal, because they thought it was funny. By year 12, it got so bad that in addition to the ableist catcalling that was happening out in the open, I literally had 2 classmates try to sneak up on me in the year 12 common room and try to lynch me with a plastic bag because they thought it was funny. And in fact, the only reason that they couldn't murder me, that they failed, was because they couldn't stifle their giggling as they tried to sneak up on me. You know, it's like that scene at the start of the Titanic where the old woman remembers every detail clear as day. I can remember the weather, I can remember everyone I spoke to, I can remember the sequence of events clear as day. But to this day, my brain will not let me see the face of my assailants. As an adult, I attended a private session of the Royal Commission into Institutional Response to Child Sexual Abuse. Chief Justice Peter McClellan told me that I had been offered that private session because the Royal Commission compared how the school handled that sexual assault in Year 10, that sexual abuse, to the Knox Grammar scandal. You call this thriving kids. I call it the very system that almost destroyed me. This isn't ancient history. It happened to me in my lifetime and yours. I still have the scars physically and psychologically. This is what happens when disabled children are expected to build systems that are never designed to neither funded nor equipped to support them, and when teachers are left without the resources they need. This is what happened when disabled children become the easiest children to blame, ignore, or sacrifice because they have been reduced to line items on a budget and labelled as burdens. I don't want to see another generation of disabled children endure the abuse, neglect and trauma that so many of us survived in our lifetimes. I've already lived through what happens when governments expect disabled children to fit broken systems instead of expecting broken systems to support disabled children. Finally, as someone who graduated the University of Newcastle with majors in both ancient and modern history, I cannot help but notice the striking parallels between the language now used about disabled people and the language which preceded the genocide of hundreds of thousands of people with disabilities during the Holocaust. When politicians and commentators talk about the social licence of the NDIS, and as recommended by the Redbridge Report, increasingly frame disabled people in terms of cost, burden, sustainability, rather than our humanity, I pay attention, because history has seen this before. Before disabled people became the first victims of the Holocaust, we were portrayed as useless eaters, human ballast, and life unworthy of life. Responsibility for our care was shifted onto our families. We became an economic problem to be solved rather than human beings deserving of dignity, rights, and protection. Those ideas became policy. They led to the forced sterilisation of around 400,000 disabled people from 1934 in what was arguably the first act of extermination of the Holocaust. They led to the starvation and exposure of thousands of disabled children in teaching hospitals in 1939. They led to Action T4 and the murder of approximately 300,000 disabled people. They led to the development of the gas chambers during Action T4, the very gas chambers that mass murdered millions of Jews, after it was decided that tying those of us with disabilities up naked in groups of 20 to 40 and blowing us up with dynamite was too messy. History didn't make me think that way. History simply gave me the language to describe what I had already lived through. People have already told this committee that disabled people will die if these reforms proceed. Others have told you that disabled people are contemplating suicide because they see no future under this system. If such actions were directed towards people on racial, ethnic or religious grounds, they would raise profound questions under Section 268.5 of the Australian Criminal Code Act of 1995, which concerns genocide. That should concern all of us. As an historian, I know where this kind of rhetoric can lead. And as a disabled Australian, I'm terrified of where it's leading us now. Frank Stevens, an American Down syndrome advocate, once observed that disabled people are the canaries in the eugenics coal mine, and he was right. Make no mistake, history has consistently shown that once society accepts that one group is too expensive, too burdensome, or are life unworthy of life, another minority is never far behind. If I were an able-bodied and neurotypical member of another minority in this country who could read the writing on the wall, I would be incredibly nervous right now. Far too many people have forgotten that never again means exactly that. It is not a slogan, it is not a warning. History is watching all of us in this nation right now. How will we be judged by it? Thank you.
Thank you, Andrew, for that statement. Yeah, we might just take another brief break and then just for a couple of minutes, and then I will go to Daryl, and I think Sam has joined us again, but we'll reconvene in a couple of minutes. Okay, thank you everyone for your patience while we work through this really important session and this really important evidence. I am now going to ask Daryl, who is online, to provide a statement. Please go ahead, Daryl.
Chair, Senators, thank you for the opportunity to appear before the committee. I'm a community neurorehabilitation clinician of over 35 years of practice across community, hospital, government and research settings. I work directly with people living with acquired brain injury, traumatic brain injury and other neurological conditions, including NDIS participants in my current practice. Some of the people I support I have known for many years, long enough to see not only the injury itself, but the trajectory of what sustains a person after that injury and what happens when those supports are removed. I want to make one central argument to the committee. In my submission, I had a number of areas that I covered, but this one is for people with acquired brain injury. Community participation supports are not simply a social amenity. They're often a form of cognitive infrastructure or a prosthetic. Let me explain. I guess following an acquired brain injury, functions associated with frontal lobe, prefrontal regions, and the brain, including planning, sequencing, initiation, problem solving, self-regulation, may be significantly affected. I guess traditional funding approaches treat these abilities as capacities that exist within the individual. In my clinical practice, I think that it is incomplete. For many people with brain injury, executive function is distributed across a network of relationships and supports, be it skilled practitioners, family members, community programs, structured routines, trusted environments. And I like to describe this as distributed executive cognition. And you see that often even in the workplace, where a worker may do something for you and remind you that you've left your car keys in your drawer and you've locked your drawer. Now, what I'd like to also say is they're not part of these reductions that they're planning on making. Community participation supports are not just removing a social engagement, they're removing the external structures that allows a person to function with impaired executive function, and they're able to remain safe and independent. I want to illustrate this with a composite example from my clinical experience. And I call this person Glenn, and there are thousands of Glens out there. Glenn lives with a significant frontal lobe impairment following a brain injury. After over many years, he developed a functional support network that compensated for these impairments. Community activities, consistent support workers, and family involvement, providing memory, planning, and continuity. When a key family member's support became unavailable due to dementia, the impact was not a small reduction in support, the entire system became unstable. Routines broke down, planning became difficult, community participation became inaccessible. I guess this is what happens when a compensatory system is weakened. The consequences are often disproportionate to the apparent size of that change. And as I read, a 50% reduction in community participation supports starting from October 1 is going to be creating exactly this type of disruption for many people with an acquired brain injury. The consequences will not disappear, they'll shift elsewhere into crisis services, emergency departments, mental health systems, criminal justice, to families, and ultimately it will come back to the NDIS through increased complexity and higher cost interventions. My request to the committee is specific. I ask that participants with acquired brain injury and other conditions affecting their executive function be exempted from these participation budget costs until a clinically informed framework has been developed to distinguish what is discretionary, what is a social support, and what are functionally necessary for the cognitive compensation. For a person who cannot walk, the NDIS funds and recognises the role of a wheelchair. For a person whose brain injury affects planning, initiation, self-regulation, the equivalent support is not visible, but it's no less essential. The infrastructure is invisible, but the disability is real. This bill, as drafted, risks dismantling the infrastructure without recognising what it provides. And I'm happy to take questions. Thank you.
Thank you very much, Daryl. Sam, are you on the line?
Yes, thank you, Senator.
Great, please go ahead.
Senators, thanks for the opportunity to speak today. My name is Sam Drummond. I'm a human rights law expert, writer and disability advocate. I'm privileged to chair the Justice and Equity Centre's NDIS Systemic Advocacy Working Group, made up of disability organisations from around Australia, and I host the Building Inclusion podcast on Australia's disability strategy, which is funded by the Department of Health. I'm also a person with a disability and a parent of a child who is an NDIS participant. I was diagnosed with my disability when I was about 18 months old. This was somewhat of a shock to my parents, whose experience with disability was limited and whose knowledge of, in particular, dwarfism was confined to outlandish fantasy portrayals like the Munchkins of Oz and the Oompa Loompas of Willy Wonka. They were told I'd need surgical intervention, but perhaps they didn't quite comprehend the ramifications, particularly mental health impacts, of deliberately breaking and realigning my young legs. I spent most of my childhood in regional Victoria in insecure housing with my single mum and my younger brother. Mum tried her best, but things weren't always easy. Had the NDIS existed then, my trajectory might have been significantly different. It's likely I would have required less surgical intervention, had greater supports within my household, education, and potential employment, and would be physically and mentally healthier as an adult. When my own daughter was diagnosed with the same condition I have, I felt proud that she was going to have the unique perspective of the world that disability offers. And I knew that we could provide easier pathways for her to living a fulfilling life, due in no small part to the NDIS. I'd watched Prime Minister Julia Gillard in Parliament say that the scheme's intent was for people with disability to exercise choice and control over their supports. It genuinely was nothing about us without us. However, the process of proving eligibility and then wading through the bureaucracy to get what should be fairly simple physical supports for my daughter has been nothing short of bewildering. Rather than choice and control, the scheme is consumed by a deficit model. We've spent eye-watering amounts on medical reports, often accompanied by a note that says, "Sorry that language is so confronting." My daughter's lifelong diagnosis is not a complex one, but the constant requirements to prove she is disabled enough has, for me, highlighted that inefficiencies in the system do exist. Those inefficiencies are not that there are too many people on the scheme or that we're asking for too much, but that disabled people are not being listened to. And now, with this bill, people with disability are told that we're going to have to prove again that we're disabled enough. This bill represents a backward step in the dignity, independence, and equality of disabled people. It is for this reason I say that this bill must not pass in its current form. There is no dignity in requiring a person to undergo all appropriate treatment without allowing them to make decisions about what treatment they want. There is no independence in giving whoever the minister of the day is the power to arbitrarily reduce supports within a plan. There is no equality in tightly restricted reassessments and automatic renewals, locking people into plans that are no longer appropriate for their needs. After the NDIS filled the cracks in inadequate state services, the states dismantled the systems that were then in place. those services simply don't exist anymore, and nobody's ready for a transition back. The Disability Royal Commission highlighted where we've failed and where we can ensure disabled people can live a life that they love. With this bill, we are ignoring those lessons and setting ourselves up to repeat the mistakes of the past. The proposals in this bill will do harm, and it will cost lives unless we are listened to. My daughter is the most wonderful human being. She is inquisitive, kind, artistic, and full of surprises. But her future and the future of hundreds of thousands of others is being put at risk by this bill. Last night, as my daughter fell asleep, she looked at me through drooping eyes filled with the endless possibilities of a child and said through a freshly lost tooth that her classmates made her feel proud at school that day. Each student in class had to finish the sentence, "It's okay to be." And this one classmate had said, "It's okay to be disabled." I strongly believe this bill, as it stands, lacks the wisdom and empathy of that child. Instead, it will entrench violence, abuse, neglect, and exploitation. So yes, let's return the NDIS to its original intent, the promise to allow people with disability to thrive through choice and control. It starts by listening to us. Thank you for the opportunity to speak. My only hope is that you will listen.
Thank you, Sam, and thank you to each of you, Sam, Rosie, Claire, Kirsty, Andrew, Shannon and Daryl, for sharing your stories with us, and also to Shannon's son, who's been joining us from the audience too. I know that it's not easy to share what you have shared with us today, but it's really important, and so thank you. I'm sure I speak on behalf of all of my colleagues, as well as others who were watching here, that it was really powerful evidence today. So thank you. Please take care and look after yourselves. I know it's been tough, so please do look after yourselves and seek support over the coming days if you need to.
Okay for it. Yeah. Hold on. And then if it's a blue moon, because we only just had a buck moon, and, you know, if I tie a note to a pigeon's leg and throw it in their direction.
I'm sure we could.
That's how I get.
We could.
I just want to make sure the coffee shop is still open.
I think the coffee shop is still open.
I hope
Thank you. We are going to take a very short suspension while we bring the next witnesses to the table. Thank you. I now welcome representatives from the National Ethnic Disability Alliance. Thank you for appearing before the committee today, and thank you for your patience. I know we're running a little bit behind schedule, so I appreciate you waiting for us. I understand that information on parliamentary privilege and the protection and obligations of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, I will ask you to state your full names and the capacity in which you appear today. Do we have Dr. Carvey on the line?
Yes, I'm here.
Great. Can you just state your name for your full name for the record and the capacity in which you appear today?
My full name is Sri Sankavi Sivasanka, and I'm representing the NDIS body today.
Thank you. And do we have Ms. Rebecca Dawson on the line?
Yes, so I'm Rebecca Dawson, and I'm here in my capacity as a policy officer for the National Ethnic Disability Alliance.
Thank you very much. I now invite you to make a short opening statement, and I will ask you to keep it short. You are able to provide to us a more extensive opening statement. We do have your submission. And following that statement, I will invite members of the committee to ask questions. Over to either of you.
Thank you, Senator, and the committee members for the opportunity to appear today. I'm here representing the National Ethnic Disability Alliance, or NDIS, Australia's peak body for people with disability from culturally and linguistically diverse, or CALD, backgrounds. As a disability representative organisation for CALD communities, we represent the lived experiences of the communities who face intersectional barriers, often related to language, culture, disability, ethnicity, and migration history. I want to be clear from the outset, NDIS supports a sustainable NDIS. We recognise the pressure on the scheme, and we are not here to argue against the reform. Our concern is narrower but serious. The bill assumes that participants can independently navigate a more complex system, understand new eligibility tests, recognise when they qualify for a plan review, find alternative supports if their funding changes, and challenge a decision if they disagree with it. For many people with disability, that's already a difficult assumption to live up to. For people from CALD backgrounds, those difficulties are compounded further. By language barriers, unfamiliarity with government systems, and limited access to advocacy and culturally responsive support. At the scale of that gap is already visible. CALD backgrounds experience disability at broadly similar rates to the rest of the Australian population. Yet CALD Australians make up only around 8.8% of NDIS participants nationally. That's not because the need is lower, it's because the barriers to entry are higher. Language, limited access to information, cultural stigma, and a lack of culturally responsive support all stand between eligible people and the scheme that's meant to serve them. NDIS is concerned this bill will deepen that gap rather than close it, particularly where it tightens reassessment pathways, narrows how support needs are recognised, and relies on participants to independently navigate more demanding processes to access or retain support. Our submission makes a recommendation, but they all come back to one overarching request, that this committee ensures no reform is implemented until it's genuinely accessible and culturally safe for CALD participants to navigate. That means people are left without support before real alternatives is in place. We don't think a sustainable NDIS and a fair NDIS are two different things. We are asking this committee to make sure this bill actually delivers both. Thank you.
Thank you very much. Senator Steele-John, I'll start with you.
Thank you very much. And Doctor, I can't see you. If you are online,
sorry,
your video.
Let me start my video again, sorry.
Yeah, thank you. There we go. Excellent. Got you now. Thank you very much. Thank you for your opening statement, Doctor. I'll take you first to the bill and its definition of functional capacity. Now, within this piece of legislation, the definition of functional capacity that has been written by the government doesn't allow for consideration of a person's circumstances, including linguistic and cultural circumstances. What are your concerns with the application of this definition to culturally and linguistically diverse communities?
Yep. As already mentioned, disability affects equally in the CALD backgrounds as it does for the general Australian population. However, the people under NDIS from a CALD background is only 8.8%. So it's already a disparity in that regards. And I think by changing the rules, the bill, and making things even more tighter, it's going to make it difficult for these individuals to seek help and even end up in a more solitude future for them as well.
Okay. Can I ask as well, the government has said that people who lose supports or access to the NDIS will be transitioned onto so-called foundational supports delivered via the states and territories. What are your concerns about the cultural safety and accessibility of foundational supports under the government's plan?
I think more concerning is the transitional period within that time as well. So it's important this information is communicated in the appropriate manner to the CALD backgrounds or communities, be it the language or in way in which we communicate them is also important. I'll also get Rebecca to add to it if she's available as well to this question.
Thank you, Dr. Rebecca speaking here. Especially with these foundational supports, there's already a lot of misinformation within the communities about what they will have access to, how they will access it, and how they will actually find these new supports once they are removed from what they currently have. So it's not just a case of those foundational supports being culturally safe once they are built. It's this whole process leading up to it is already not culturally safe for a lot of these communities, and that's what we're already hearing.
Thank you. We've heard also concerns about the computer automated decision-making processes that will be introduced and expanded under the legislation. To automate a computer decision-making process, you fundamentally at the kind of basic level need to have kind of solid data to input into that process. What is your view as an organisation of the quality of the data that the agency currently gathers and retains about NDIS participants who might be from culturally and linguistically diverse backgrounds?
Thank you, Rebecca. I'm Rebecca. I will respond to that one. We have been working both with the ABS and other government organisations in order to improve the data set for culturally, linguistically diverse people with disability. Unfortunately, the data is still very patchy, and we don't feel that it fully reflects what we hear is happening within our communities. So, as you said, to effectively automate a process or include our cohorts within that, there needs to be appropriate data which is missing, which does indicate to us that our cohorts will be left behind or missed purely because they are not seen in that data.
Thank you. In terms of the assessment processes that will be introduced or expanded under this legislation from functional capacity through to other processes, are you concerned that they may not be culturally safe for diverse communities, or otherwise fail to capture the expressed needs or views of diverse communities because they may have been developed without the appropriate representation of those kind of folks within the initial design process?
Absolutely. That is always a concern, and it is always something that we work towards improving in our space. One thing that we have noted is that the current assessment processes do not adequately capture those needs and unique idiosyncrasies and cultural nuances that follow many of our communities. And so we welcome the opportunity for these to be reviewed and potentially improved. One key issue that comes up from many communities time and time again is due to various reasons, stigma, shame, not wanting to be seen to complain, but the propensity to underplay the true functional impact of their disability. So I'm sure you can understand that if somebody, when they're asked, how does this impact you on a day-to-day basis, and they say, oh, it's not too bad, can't complain, they're going to get a much lesser plan than if they were actually open and upfront, which culturally is very difficult for some of them to do.
And can I ask you, given these concerns with the bill in its current form, do you believe that it should pass?
We believe that further consultation and work is required, and we have significant concerns about the ability to do the work that's needed in the timeframes that are set out.
Okay, thank you very much. That's all from me, Chair.
Thank you very much. Senator Tyrrell, do you have any questions you wish to ask? No, okay. Just checking if any other senators.
Just got one or two.
Yep, excellent. Senator Pocock.
Thanks, Chair. Thank you for your time and your submission. Your submission explains that for many people from culturally and linguistically diverse backgrounds, social and community participation supports provide access not just to activities, but to cultural identity, faith communities, language and informal support networks. What could be lost if SCCP funding is reduced by 50%?
Thank you, Rebecca, to answer that one again. You've mentioned it yourself in terms of accessing faith-based community supports that could include attending their mosque, their church, their place of worship. It could also include being included in community events within their own cultural community. In some spaces, it does mean no longer having access to specific food types that they need for their cultural expression, or they used to follow through with a number of their faith-based or their community and cultural-based practices. In a number of spaces, it does mean that a number of culturally, linguistically diverse participants do have support workers and support who are of the same culture and same language group, and having their support workers reduced does reduce their own social and ability to build capacity within their communities as well. We recently had a participant who, through their community participation funding, was able to engage in community-based arts programs that were specifically tailored to people from culturally and linguistically diverse backgrounds. Now, this particular person has limited verbal communication skills, experiences sensory overwhelm quite significantly, and without that community participation funding for their support worker to support them to attend those workshops, this particular person would not have been able to do so. The actual impact of those community workshops meant that this person has actually now discovered a new method of communicating and expressing themselves to their family and their friends and their community. And that is likely to be an ongoing part of their supports in the future, so long as that community participation funding to enable them to attend those is not cut.
Thank you very much, and thanks again for your time and your submission.
Thank you. I have one final question for you just before we wrap up. I understand that the NDIA has been testing and validating the approach to new framework planning with people from culturally and linguistically diverse backgrounds and those with limited English proficiency. Are you able to talk to that work and how, in your view, it's going?
So we also have been working quite closely within a number of those consultative processes to try and ensure that a culturally linguistically diverse lens is applied to much of this framework planning. We have been told that there is no intention for any of the information to be put into community languages, which is a concern of ours. First and foremost, it's not at all culturally safe to just make a decision not to put any of the changes or the reforms into any community language. So we do have concerns, given that precedent, that advice given and suggestions made will not necessarily be taken into consideration. We remain hopeful that they will.
Thank you. I'll just confirm that no other senators have questions for these witnesses. No? Okay. Thank you very much for the evidence you have provided today. The committee will report to the Senate on the 14th of August 2026 and has agreed that responses to questions on notice should be provided by close of business Thursday the 6th of August 2026. I now welcome representatives from MND Australia, MS Australia and Muscular Dystrophy Foundation Australia to come forward. thank you very much for appearing before the committee today. I understand that information on parliamentary privilege and the protection and obligation of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, I'm going to ask each of you to state your name and the capacity in which you appear today, and I'm going to start on my left.
Rowan Greenland, I'm the CEO of MS Australia.
Katie Snell, I'm the National Policy Manager at MS Australia.
Rachel Kerr, I have MS and am part of the Lived Experience Expert Panel.
Jo Whitehouse, Manager of Services at MND Victoria.
Claire Sullivan, CEO MND Australia. Diana Carter, Executive Director of Muscular Dystrophy Foundation Australia.
Rob Oakley, I'm the Secretary of Capital Region Muscular Dystrophy here in Canberra.
Thank you very much. I'm going to ask each organisation to make a very, very brief, please, opening statement. You are able to table, if you have a longer statement, then our preference would be that you table it, just because we are running behind schedule and we have some witnesses who have to leave to catch flights, etc. So I'm very conscious of that, and any statements you give us will be incorporated into Hansard, and I know lots of senators have questions for you. So on that basis, I will first ask MND Australia to provide a short opening statement.
Thank you. Senators, thank you for the opportunity to be here for this really important inquiry. MND Australia remains committed to the government's objective of ensuring the NDIS is sustainable for future generations. Oh, cool, excellent. We support stronger safeguards against fraud, greater protections on accountability, and measures to improve the scheme's integrity and efficiency. Our concern is that the savings don't come at the cost of delivering critical care. We're asking the committee to ensure that in pursuing these important reforms, the legislation does not unintentionally disadvantage Australians living with complex and rapidly progressing neurological conditions. We're also asking that the committee ensures that one of the most important reforms in recent times, the MND priority pathway, remains. Motor neuron disease is an insidious disease. It progresses rapidly, and people lose the ability to walk, to talk, to use their hands, to chew and swallow, and ultimately to breathe. There is no cure. The average time a person has from diagnosis is 27 months. Unlike many disabilities, the support needs of someone living with motor neuron disease change dramatically, often within weeks, sometimes within days. That's why the priority pathway is so important. Our message today is simple. The reform should preserve what is already working. Our submission covers 4 key areas that we believe the bill could, in the bill that could ultimately undermine the outcomes for people living with motor neuron disease. These areas are: assessments must recognise the trajectory of a disease, not simply the current functional capacity. The scheme must remain agile enough to respond as the disease progresses. Sustainability must not come at the expense of participant care, and technology should support clinical judgment, not replace it. For assessments to understand the disease trajectory, it cannot be a point-in-time assessment. It cannot be a functional capacity assessment. Closely linked to this is also the need to move away from diagnosis as a accepted basis for establishing eligibility. There are some conditions where diagnosis alone itself provides the evidence of disability, and motor neuron disease is one of these. The scheme needs to remain agile to respond to people's changes as well. Rapid reassessments for people living with MND mean greater efficiency and greater cost savings by providing the services that are needed at a point in time. The proposed changes limiting who can request assessments, together with extending the timeframe from 21 days to 90 days, are particularly concerning. People with MND cannot wait 3 months for a decision after their needs have significantly changed. We also have a number of concerns around the lack of, the legislation doesn't specify who a plan nominee can be, and we believe this needs to be plan managers and support coordinators, as well as a carer. We're also concerned by the provisions that allow plans to be suspended if a participant cannot be contacted. As MND progresses, people lose their ability to communicate, and so a plan should be, effort should be made to contact plan nominees, support coordinators and plan managers before any plan is suspended. We're very concerned that the reforms are looking for sustainability over people's care. We believe that every effort should be there to hold providers to account and to stop fraudulent activity. However, we're concerned by the provisions that enable funding for categories of supports to be reduced in the interests of the scheme's sustainability. Financial sustainability is essential, but the fundamental purpose of the scheme should remain, and it needs to be the primary consideration. Finally, technology should support clinical judgment, not replace it. We're very concerned about the plan to introduce automated decision making. We have seen how detrimental this has been in the Support at Home program to people's care, wellbeing, livelihoods and lives. We're seeking clarity that's absent in the exposure draft in the proposed legislation around the role of automated decision making in assessments and planning processes. In line with the recommendations of the Office of the Australian Information Commissioner, if automated decision making is to play any role in assessments and reassessments, there must be complete transparency around where it is used, strong human oversight, clear review mechanisms, and the ability for expert clinical judgment to override automated outcomes. Senators, I would like to conclude by returning to the priority pathway. We greatly appreciate the government's commitment to retaining this pathway. I want it clearly stated on behalf of the MND community, thank you. The priority pathway is working incredibly well. However, we seek reassurances that the elements that make it work so well will remain. Specifically, these are assessors, MND assessors to undertake the assessments. Assessors need to understand the nature of the condition of the people they're making decisions about. Funding continues to be approved within 30 days. Reassessments remain available and whenever clinically required. Reassessments can be requested and should be approved within 21 days. And the ongoing collaboration between the NDIA and our state MND associations continues. Thank you.
Thank you. MS Australia.
Thank you very much. I might say I really want to congratulate you for having a focus on neurological conditions. I chair the Neurological Alliance Australia, and in this country, neurological conditions are undercounted. They're under-recognised, they're underfunded, and in the case of the NDIS, they are far too often misunderstood. From MS Australia's perspective, our role is to fund research, undertake education, awareness and advocacy on behalf of the 37,700 Australians who live with MS, 1/3 of whom are on the NDIS. I'm really pleased that I'm joined today not only by our National Policy Manager, but also Rachel Kerr, who lives with MS. She's an NDIS participant and a member of our famed lived experience expert panel known as the LEAP, and she's travelled from Rockhampton to be with us today, and also her husband and carers here too in the audience, Shannon, so I'm really grateful that they've made the journey to provide evidence here. The evidence that we do give draws strongly on the experiences of our state and member organisations who are registered NDIS providers and deliver a range of supports and services to people living with MS and increasingly other neurological conditions, but also from our LEAP. And we have 50 people who live with MS or are carers who provide expert advice to inform our advocacy and policy work. We support reforms to improve NDIS integrity, address fraud and strengthen the scheme, but as many as I suspect virtually everyone you've heard from says, the scheme's sustainability must not come at the expense of people with disability. We are deeply concerned that many measures in the bill could reduce access to necessary supports, increase pressure on families and carers and undermine the rights, independence and wellbeing of people with disability, including people living with MS. The NDIS has been life-changing for many people with MS. However, in the survey work that we've done recently and ongoing engagement with people with MS, they tell us that it is increasingly difficult to navigate, especially since MS isn't always well understood by the NDIS. People are being repeatedly asked to prove, for example, that their chronic, progressive, incurable disease still exists. We are especially concerned that the reforms outlined in this bill put the emphasis on participants losing supports rather than improving how the NDIS operates the scheme, which we see as the major barrier to an improved and fiscally viable scheme. We also believe that any reforms to the NDIS should be driven by the lived experience of people with disability. Changes to planning, assessment, supports and decision-making should be done through co-design, trust and partnership with people with disability. Thank you for having us here today.
Thank you very much. We will now go to Muscular Dystrophy Foundation Australia.
Thank you for the invitation, and thank you, Jordan and others who have managed to enable this extension of 8 weeks to be able to come and present our thoughts. The submission that we put in, I expect that is tabled and that is read. So I heard you earlier say we need to be short and sweet, so I'm going to be short and sweet. Muscular dystrophy is across Australia. 41,000 people live with some form of neuromuscular condition, and there are over 100 conditions, and there is no cure. NDIS is not discretionary for these people, it is fundamental. Muscle degeneration is progressive, affecting mobility, breathing, swallowing, heart problems, and many other limiting issues. How can these sweeping and unprecedented cost-cutting measures be justified for our vulnerable community? Our community are telling us they're distressed at this amendment bill. The uncertainty is causing increased stress in their lives, and there is genuine fear that their supports are going to be whipped away from them. The NDIS paradigm shift for choice, control, equitable access and dignity seem to have been put on the side, and what we want are the standards in assessments, provider supports and therapies and accountability, but what we don't want are poorer health outcomes, reduced community participation, increased family stress and lower quality of life. We hope that committee has an opportunity to ensure that reforms do not unintentionally diminish the quality of life, health and independence of people living with muscular dystrophy. We ask that you listen to us. Muscular Dystrophy Foundation Australia is here to contribute to enable co-design for the future of NDIS. Thank you.
Thank you very much. We will first go to Senator Antic, who is on the phone, I believe.
Yeah, thank you, Chair. Can everyone hear me?
We can, yes.
Okay, great. Yeah, thank you. Thanks for the opportunity and the opportunity to put some questions to Muscular Dystrophy Foundation, if I can. And thank you for your submission. I noticed in your submission, though, you supported a standardised assessment tool in principle, but you raised some concerns about ICANN, and I was wondering what specific changes would be needed before Muscular Dystrophy Foundation could support its implementation.
That's a really good question and a level of detail that I'm personally not across. I do know that the main issue around assessments is that it has to be run by allied health practitioners and not be treated merely as an administrative process. The eligibility is an incredibly hard process to go through anyway, and I might pass to my colleague Rob here, who is with lived experience, and he may be able to share something about that.
Thank you. Yeah, look, I think if I can break it down, it's probably easiest to just give you an experience that I went through when I joined the NDIS. I've got muscular dystrophy. It's quite obvious I've got muscular dystrophy, and it's quite limiting. And I had, I'd had my diagnosis for a long time when I went to join the NDIS. And I remember the conversation I had with the young lady at the time who was basically interviewing me to decide whether I should be in the NDIS or not. And she said to me, can you walk upstairs? I said, well, look, I can if the building's on fire. I'll make an effort, but I would choose not to because I'm more than likely going to trip over and break my neck. I use a chair whenever I can, and that's the situation. Now, that might have been slightly tongue-in-cheek because I thought, well, that's a pretty silly question. But no, that was the basis on which she was going to recommend that I wasn't part of the NDIS, wasn't suitably disabled to be in the NDIS. That was the end of it. And it seemed to me that I was left to either accept that or challenge it, and challenge it I did. But in any design system that you have, someone with muscular dystrophy, it's a disease that can rob you of your self-esteem, your self-confidence, and your ability to walk into a room, just simply ability to walk into a room with people you don't know. It's a very difficult thing. So when confronted with this sort of assessment process and someone who may or may not be reading off a standard piece of paper, it's very difficult for people to actually debate that, if you like. They're more inclined to just withdraw and go, oh, geez, okay, maybe I'm not disabled enough, because that's something you get used to with muscular dystrophy. That's the sort of attitude that you run into all the time. So however you design that system, making it some sort of standard functional test like can you walk upstairs, it concerns me that really creates a problem.
Yeah, thank you. Can I just follow up with that, with are there any safeguards that you think that the Foundation thinks should accompany the use of any automated decision-making just to ensure that it's accountable and transparent?
Jordan earlier mentioned the automated decision making. I am a bit of a troglodyte, and I really am very concerned about the algorithms that are being imposed on us all the time. I'm just trying to see the parts of the submission where we had written about the automated decision making, and we have said that the safeguards should be clear public reporting mechanisms, independent oversight, and also a human reviewing it. I've lost the train of thought. I had another thought. I'll leave it there. Thank you.
Yeah, no, thank you. And just finally, looking at the bill in its totality, if you could recommend one amendment to the bill that would have the most impact for people with neuromuscular conditions, what would it be, and why would it be?
Gosh, you've blown me away with that question, because I have never been put on the stand to dream so big, because NDIS was a paradigm shift when it came in, and it really did change a lot of people's lives and did give choice, dignity and control in certain elements. I don't know, Rob, do you have something?
Well, I mean, yeah, I've always got a thought on everything. I think, I mean, this is the issue, isn't it? That it's really, we're all here and we can identify the problem and perhaps suggest the solution, but, that's respectfully your job to come up with the solution. But what I might, take it back to experience again is that, that as Di said, there's over 100 conditions that you would call neuromuscular/muscular dystrophy. So you could put those into 9 broad groups, and they're very, very different. They all occur on a spectrum, as I guess most of the conditions that we're representing here today do. And so you could have somebody that was born at the same time as me, diagnosed at the same time as me, and gone through the same period of time as I have, we'd be completely different. We'd have the same disease, the same issues, but the way it's affected us is completely different because that's the nature of the disease. So if there was an amendment in there, I would say I would like to see it designed to actually take that into account. That it's not, okay, you've had FSHD for 40 years, this is what you look like, because it just never works like that.
Okay, no, thank you for that. Thank you for those comments. Thank you, Chair.
Thank you very much, Senator Antic. I will now go to Senator Pocock.
Thank you all very much for your time this afternoon, being here and for your submissions. I want to start with MND Australia. In your submission, and you just talked about the priority pathway and the need for it to be protected in legislation. In your opinion, why is an administrative pathway insufficient, and what specific guarantees should be legislated to ensure that people with MND receive a plan and reassessments quickly enough to keep pace with their rapidly changing needs?
So what the pathway is doing at the moment is providing NDIS planners with access to people who understand the disease, so they're in contact and are trained by the MND state associations, that that applications are reviewed and approved in 30 days, and, sorry, it's 5 days, and the adequacy of the packages being approved fits the needs of the community. So that's what's working well at the moment, and we would like to see that locked in the legislation that's being reviewed at the moment. Joe Whitehouse is here from MND Victoria, NDIS registered provider, and very across this. Joe, you might have some more comments.
Yeah, look, thanks, Claire. I think one of the things which is really important to people with motor neurone disease is the rapid progression. And I think the assessment processes that are in place can be quite static. And the group of delegates that are working, there's 18 delegates within the agency who only work on plans for people with motor neurone disease. They really of the progressive, of the condition being so progressive. So we've stepped past that problem of having to go back for a review and reassessment constantly that we did before we had the pathway in place. So we've had that transition across through from not having it to having it, and it works really well. People with motor neurone disease are getting that direct support from a delegate from the agency as well. Phone numbers are exchanged, which is quite rare, and yeah, it's very person-centred. It's really making sure that that it's very responsive to people's needs, and having that element of forward thinking in relation to sort of understanding if somebody is having some voice change, they are probably going to need an eye gaze technology or something, so that's put into the plan so that they can access that within the next few months. So it's, does that answer your question? Yeah, that makes sense.
Well, your submission raises concerns about the timeframes for the NDIA to conduct plan reassessments, increasing from 21 days to 90 days. And it's not something I've heard others pick up on yet. Can you share what a delay of that length would mean for someone with rapidly progressing MND?
Absolutely, yeah. Look, the typical time frame from diagnosis to death is 27 months, but quite a percentage of about 30% only survive a year from diagnosis. So if you're waiting 30 days for an outcome of an assessment, that's kind of eating significantly into your life, your quality of life during that time as well. So yeah, it to some people might not sound like a long period of time, 3 months, but to somebody with motor neurone disease, it can have a significant impact on their ability to have the best quality of life for that period of time. Some of the examples also are, people might progress from needing a particular type of mobility aid to assist them in transfers. And that can happen over a couple of weeks, that they're changing from one type of device that they need to something else. So they need that very rapid ability for the plan to be able to be responsive to that and not to be having to go back to get things changed. And that, I think that's the element that we've really noticed has been fabulous about the pathway, is that we can have that responsiveness to meet the needs of people with MND, and for them to really lean into the choice and control that the NDIS, offers.
Thank you. One of the other changes the bill makes is prevent support coordinators and providers from requesting an unscheduled reassessment. And I know in your submission you argue that some people with MND have no family or informal network able to act for them, who could identify their rapidly changing needs and initiate a reassessment. What safeguard or amendment is required to make sure we don't leave people without people to advocate for them for that reassessment if the government wants to prevent support coordinators and providers from doing that?
Yeah, look, I think they need to have support coordinators or nominees added, obviously at the person's choice, that they're asking for that to be in there. Sometimes because of the rapid progression, the time frame that we need that ability to be able to make things happen quickly. So if there isn't something in the legislation to enable the right person to be contacted, to enable something to be moved or changed or addressed quickly, that is going to have a significant impact on the person. And I think, look, I think it should also be related to that person's choice about who do they want to have as the person to be contacted. Often with MND, when things are progressing, they're needing to be in contact with clinics and health people. It's massive. Lots of people say, God, this is so confusing. There's so many people that they are having to be in touch with. So to have somebody that can coordinate that and to sort of be that navigator with the NDIS is super important for people with MND. And we think it works. And I think if you surveyed people with MND, they would say that it works. And I guess that's one of the things that we're really trying to emphasise, is that we've worked really collaboratively with the NDIS and developed this pathway, developed these processes that are, really doing a great job. We don't want them to be unravelled.
Yeah. Thank you very much.
It's a good news story, and it's something that potentially could be rolled out to other. Yeah. It's almost the gold standard. The fact that people with MND can get a phone number of a delegate is, when we got that 2 years ago, that was like, oh my God, it sounds silly because it's.
Well, to me, that shouldn't sound unusual.
Yeah, it shouldn't, but it is, and it was revolutionary to have that contact, and the person with MND can contact their delegate. And that delegate contacts them every couple of months to check in. So it's kind of, I think that's something which I think, we would be really very distressed if that was kind of rolled back.
Well, thank you very much. I do have some other questions, but I'm going to hand over the call. Thank you, Chair.
Thank you very much. I appreciate that. Senator Pocock. Senator Steele-John.
Thank you so much, Chair. Thank you for the evidence that you've given today, and I'm really glad that we've been able to create this time so that your perspectives from your communities can be heard as part of this process. I want to begin with MND Australia. Under the legislation as currently written and under the timeline that government has given for the implementation of this legislation, from the 1st of January 2028, new eligibility criteria will apply to new applicants of the scheme. Existing applicants will then gradually be reassessed over a transition period. Central to both of these processes will be the construction of a new functional capacity assessment, functional capacity test. At the moment, there is no exemption or carve-out for MND. And I notice in your submission and in your statement how you've underlined for us so clearly how valuable this distinct process has been for your community. It's currently not enshrined in the legislation. So the state of play as we sit here is that is not part of the future of the NDIS if this legislation passes. What would it mean for your community having fought so long for a pathway where you speak to somebody who gets it, they understand the importance of time and timeliness when it comes to motor neuron disease? What would it mean for you to lose this dedicated pathway at this point?
For people living with motor neuron disease, to not have access to the NDIS would be devastating, beyond devastating. It would dramatically impact their lives. For what is proposed with the new legislation, without having the priority pathway, the funding support just wouldn't be provided in line with the progression of their disease. As Joe said, if the average time from diagnosis to death is only 27 months, but often we hear of cases where people pass away in less than 12 months, without the priority pathway, they will be receiving plans approved that don't fit their needs anymore and needing to be reapplying and reassessed, and that plan won't fit their needs anymore. It just won't work for this cohort of people. Joe, I'll ask you to give some more detail, but the outrage from the community will be, not even just the outrage, lives will suffer, people will suffer.
Yeah. It sounds like losing this pathway would actually do harm to people.
It would be catastrophic, yeah. And I think if you follow it through to its to an end conclusion, people would end up being back in hospital again, living their last days in hospital, and having not a great quality of life in a when they've got a condition like MND that is shocking, awful, terrible, but to add to that you can't get the key supports that will enable you to live your best life for those for your remaining days, I think would be pretty shocking to the community. And look, I guess too, we've had this pathway that works, and so then to roll it back, I think that it would be, this is not very probably a good language, but a bit of a kick in the guts to people that would potentially be taken away. And I guess too, the progression part is the critical thing too. It's the progression can happen so quickly, and that's where the assessment and the reassessment potentially not being given, or the assessment sort of being at that moment in time is not a great thing for people with motor neuron disease. And if we could also kind of think about or reference the aged care system, we know that the algorithms and the assessment process for people with MND in that space is not working, and it does align to some of the things that we're talking about here that we potentially could be rolled back, which will be, catastrophic.
Thank you. Miss Kerr, we've heard a lot of evidence about the risks posed to a disabled community by the government's proposed kind of 50% unilateral cut to social and community participation supports. From the work that you do and the knowledge of the community, what impact will that have on the people that you represent?
That will have a massive impact, not only for each, the broader group, but a lot of times those supports are combined. So we have people who might be gathering together and have one support worker providing some assistance where needed. That is disadvantaging all of those people. But also when we talk about efficiencies and financial responsibility, those numbers that already exist in plans didn't come out of nowhere. So all of that represents functional capacity assessments that have already happened, and occupational therapy is all of your reports, all of your NDA planning time to go into coming up with whatever number appears in these plans that is going to get an arbitrary 50% cut. And I've heard it said repeatedly that this funding, you know, a lot of people who I guess aren't in the space think of it as fun and outings, but it is helping people live their daily life. So without that, we are pushing the burden back to informal carers that are already carrying a heavy load. We know that our informal carers keep getting asked to do more and more, and NDIS inception was a lifeline for a lot of those people who were then able to have a career and continue working or whatever they wanted to do. Taking away those social and community participation or cutting it, it doesn't take away the need. Cutting the funding by 50% doesn't cut the need that people have by 50%. It just pushes the need elsewhere, whether that is into the hospital systems or into already struggling volunteer programs. Yeah, the need is still there.
Yeah. Does it feel a bit... Do you think it will feel quite unfair?
Absolutely.
To people?
A lot of this amendment feels unfair to the end user and participant. Obviously, no one has the specific numbers, but I firmly believe that the vast majority of participants are not committing the many, many millions of dollars worth of fraud that we're trying to rein in. They are participants with disabilities who are trying to live their best potential life and live their own life. So I have been diagnosed with MS for 20 years, so I've lived pre-NDIS. I was using a wheelchair quite regularly. I was 17 when I was diagnosed. I bought my first walking stick at 18, wheelie walker a year or two later. And then with NDIS, I was able to seek out allied health. So I could go and see a physio, I could go and see an ex-phys. From that, I've gotten to a point where I'm back to walking again. But MS is a progressive condition, regardless of how good I look today or how well I'm currently tracking. And we can be really grateful for treatments that have come such a long way in helping people live better lives. The fact remains MS will always be a fluctuating progressive condition. So it does. It feels really unfair that the people who are trying to live the best life they can are bearing the burden. But also when we talk about those time frames, you know, even a 21-day time frame, it is a long time. When something's wrong and you don't have the supports that you need to live, or you're getting told to just head to the hospital every day because you no longer have support hours in an overstretched system, which is an example I've got from someone I've been helping recently. 21 days is a huge amount of time. 90 days, and that's if the timelines stick. So the current 21-day timeline, generally you get an email around day 28 that goes, oops, sorry, we're a bit late, and then we'll get to it. So when we're not meeting the current goal, or in my anecdotal experience, we're not meeting current goals, and that's costing people's benefit, because again, that the need is still there. So then the person who needs care has got an informal carer who might need to take time off work to provide that support, or we're asking their children to step up and give,
Yeah, absolutely. Look, I'm pressed for time, so I only have one more question. So what I'll do is I'll ask a question for all of you, but if you could tack on to it for our clarity, whether what your position is on whether the bill should pass in its current form. That would be very useful. But my question to you, the kind of central question I want to get from you is in relation to being required to undergo specialist treatments to prove that a disability is permanent. So the proposal in the legislation is that the government will be able to require you to undergo additional specialist appropriate treatment, as the government decides to define it, before you can access the scheme. For all of your conditions that you represent today, I know there is a great frustration in having to continually demonstrate again and again either the reality of experience or that you have tried other pathways, or So I'd like your view on what it could mean to be asked, or your concerns about how that requirement could be applied to your communities, and also your position on whether the bill should proceed in its current form. I'll start with the Muscular Dystrophy Foundation.
It would be humiliating. I've done all the tests, I've got my diagnosis. It's a degenerative disease for which there's no cure. It's ridiculous to suggest that somehow or other I'm trying to defraud somebody by pretending to have a disease. And what would I be doing here today? Like, it would be humiliating and embarrassing for all those involved. Could I just quickly add a point too about the timelines? And I'd endorse everything my colleagues have said here today.
I'm just going to have to interrupt. I'm very sorry. We do have witnesses due to appear who have to get on planes. So I don't want to cut anyone off, but if you could just be really short, I would appreciate it. Thank you.
In terms of the 21 to 90 days, one of the things our charity does is help people who are trying to get equipment through the NDIS. And 90 days is a pipe dream in a lot of cases. It might not be quite as crucial as some of the other things here, but for instance, a cough assist machine for a young man or young lady who wakes up in the morning with drowning in their own phlegm. It's an important piece of work, and it might take 6 months. If we didn't have the capacity to be able to loan them that equipment in that time, what happens to them? They get pneumonia, they get lung infections, they're weakened, and it's a downhill slide from there. So it's not just for that essential equipment and those really extreme conditions. It's across the board.
And your position on the bill?
Sorry, pardon?
And your position on the bill? Should it pass its current form?
No.
Thank you. NDIS training.
For a condition like motor neuron disease, asking people with motor neuron disease to prove it's permanent actually makes the government look ill-informed and quite silly. The diagnosis is life-limiting. There is no cure, and the progression of the disease doesn't relent. There is no pause or remission or break. It is a permanent condition based on the diagnosis. That is what it is. So for our people, it's quite a silly thing for the government to be asking them to prove. And our position on the bill is no, it should not be passed in its current form. Absolutely.
Thank you. And finally, MS.
Yeah, we think it would be completely inappropriate to ask people about treatments. For people with MS, everybody has an individual response to treatments. People have access to disease-modifying therapies, but there's a range of them. Different ones work for different people. Some choose not to take them. Some people have access to stem cell treatment. Some people travel overseas for it. But we believe that people with disability have the right to choose the treatment that they think works for them, and we don't think that that's a government decision. We also would have great concerns about the ability of the NDIA to interpret that. They currently show that they do not respect reports from health professionals. They disagree with them. They don't understand how to read them. So we don't know how they could possibly understand or implement these. And I know that that part of legislation refers to, that they will look at research reports, but we don't, there's no indication of what those reports would be, who would provide them. They don't come to disability representative organisations for information on diseases and disabilities, so we can't see that they will do that going forward. So, no, we don't. And we don't support the bill in the current format.
Thank you. Thank you all.
Thank you very much for appearing before the committee today. We very much appreciate it. The committee will report to the Senate. I've lost my script, but I think it's on the 14th of... August 2026. I've said it enough times. Here we go. And any questions on notice should be provided by close of business Thursday, the 6th of August. Thank you very much for your patience and for appearing today. I now welcome representatives from Amparo Advocacy, who I believe are online. No, in the room. Excellent. I will ask you to come to the table. Thank you for appearing today. In the interests of time, I am going to just read you my next little bit. I understand that information on parliamentary privilege and the protection and obligations of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, please each state your full name and the capacity in which you appear today. I do also understand that we have an interpreter here in the room, do we?
Online.
Online. Okay, excellent. So just for those watching. Okay, I will begin with you, Ms Boyd, if you'd like to state your full name and the capacity in which you appear.
Thank you, Chair. Ange Boyd, Senior Systemic Advocate for Amparo Advocacy.
Thank you. Ms Cruz.
Hello. Grace Cruz, member of the Committee from the Amparo Advocacy Management and Inclusive Leadership Network.
Thank you. Ms Molina.
I'm Francie Molina, a member from the committee and also for Inclusion and Leadership Network. Thank you for your time.
Thank you for your time. What I propose that we do, Ms Boyd, would you be happy if we accept your statement as tabled and proceed to Ms Cruz and Ms Molina? Is that okay?
That's okay, Chair.
I'm conscious that we do want to ask you some questions, so thank you. Perhaps Ms Molina, would you like to go first?
Angie, we start in the beginning and...
If you do your opening statement. But do we have...
we had the interpreter service now.
Do we have them online?
Thank you.
Just confirm. No, we don't? Okay, well, perhaps... Do we need the interpreter for both witnesses?
We do.
In this case, perhaps Ms Boyd, do you want to start us off and we will get the interpreter?
Thank you.
Thank you.
Thank you, Chair. Thank you, Chair and members of the committee for the opportunity to appear today. I acknowledge the traditional custodians of the land on which we meet and pay my respects to elders past and present. Amparo Advocacy is a non-profit community organisation which defends, upholds and promotes the human rights of people from culturally and linguistically diverse backgrounds with disability. Amparo Advocacy is governed by a voluntary management committee, the majority of whom are people from culturally and linguistically diverse backgrounds with disability. The organisation receives funding from both Queensland and Commonwealth governments to do our work. I'm joined today by Francie Molina and Grace Cruz, who will speak on their own experience. Before I go further, I want to be clear that when we refer to people from culturally and linguistically diverse backgrounds, this includes people from refugee backgrounds. We do not treat these as separate groups. Where we refer specifically to refugee experience, it's because of trauma, forced displacement and settlement experience, which can create particular barriers of their own. And in the NDIS context, when we say refugee, we mean people who meet the scheme's residency requirements, Australian citizenship, permanent residency, or protected special category visa status. Amparo Advocacy supports a sustainable, safe and trustworthy NDIS, and we support measures to strengthen its integrity. Our position is clear. As currently drafted, this bill should not proceed in its current form without amendments and binding safeguards, as it does not adequately consider the specific needs of people from culturally and linguistically diverse backgrounds with disability, and it will further disadvantage them. Our central concern is this: the bill applies the same administrative rules to everyone, but people do not have the same ability to understand English language communication, respond to unfamiliar calls, use digital systems, have confidence in engaging with government, access to treatment, obtain reports, use review processes or evidence and advocacy. The inequality is already visible. In the year to March 2026, 66% of called applicants met the NDIS access requirements, compared to 83% of people who are non-called. Amparo Advocacy is seeking a whole person assessment, accessible contact, reassessment and review, realistic consideration of family and mainstream supports, individual protection from blanket funding reductions, and transparent automated processes with meaningful human oversight. These are not requests for special treatment. They are what equal access requires. I will now hand it over to Grace, who will speak about whole person assessment, community and community participation. That is if the interpreter is now online.
The interpreter is online, so please go ahead.
Thank you.
Thank you, Chair and members of the committee, for the opportunity.
Do you want to speak?
In Spanish. In Spanish? Okay. Gracias, gracias miembros del comité por la oportunidad. Primero quisiera dar reconocimiento a los custodios tradicionales de la tierra en la que estamos ahora, y dar mis respetos a los elders past and present. Sorry for speaking.
No, it's okay. It might be worth just clarifying with the interpreter. How would you like to do this? Would you like to have the whole statement read and then you interpret? No, I think the preference is if perhaps the witnesses can speak and then pause, and then the interpreter can interpret that section. Is that okay?
Yes. Thank you, Chair.
Thank you.
Is that okay with the...
Thank you. Good afternoon.
Hello.
Yes, good afternoon. So it was my understanding that these opening statements were going to be read in English, but I'm happy to do either way.
Okay. Do you have a copy of the opening statements?
I should. It's downloading as we speak.
Okay.
I mean, I'm not sure if they were written in English, and it might be.
I have them written in English.
So perhaps if you can dispense of me and just read them in English, and Angie, if you can, or if you would prefer to do that, I can just assist with the Q&A following the statements, and if that's the most useful way to do it.
Is that okay?
Yeah.
Yes.
I would like he do the introductional statement that Angie said, because some of the things, probably for my level of English, it would be right that actually understand full information that Angie just said to you, Chair. Is you are okay with?
That's okay.
Thank you very much.
Yeah. Okay, let's go to you first, Ms. Cruz.
Por favor, puedes interpretar lo que Angie dijo, la primera página que se te envió, para que me puedas decir en español qué fue lo que ella dijo. Gracias.
Sí, perdón, estoy abriendo el documento. I'm just accessing the document now.
Okay, we will commence with Ms. Cruz and then we will come back to Ms. Molina. So please, over to you.
Okay. Thank you, Chair and members of the committee, for the opportunity. First of all, I acknowledge the traditional custodians of the land on which we met today, and I pay my respects to elders past and present. My name is Grace Cruz, and I'm a member of Amparo Advocacy's Management Committee and Inclusive Leadership Network, I'm proudly Australian and also a person with disability from a culturally and linguistically diverse background. In 2022, I was diagnosed with multiple sclerosis. Multiple sclerosis affects everyone differently. My symptoms can vary from day to day. What I can do during a brief assessment may vary different from what I can do safely, reliably, and consistently in daily life. Some symptoms are not visible. I experience fatigue, pain, spasms, and loss of sensation in my legs, which can make walking difficult. Watching me complete one task in a quiet room may not show the effort involved, how long I can continue, or what happens afterwards. That is why an assessment must consider the whole person. It must look at all of the person's disabilities and needs together, and at how they function over time in real-life situations, not only what they can do at the one moment. For people from culturally and linguistically diverse backgrounds, it must also consider language, communication, culture, trauma, family circumstances, and the support actually available. I do not have family support in Australia. The community I have built here is extremely important to me. It gives me connection, belonging, and people I can trust. It supports my independence and mental health. But community cannot replace the disability support I need to live home, travel, and participate safely. That is why I'm deeply concerned about the announced 50% reduction in relevant social and community participation funding. It has been difficult to rebuild a sense of community since acquiring my disability. Activities that support my mental health, including my participation with Amparo advocacy, could be severely affected. I could lose contact with the community that has become my support network in Australia. This could leave me more isolated, vulnerable, and affect my independence, confidence, and mental health. I asked the committee to ensure that NDIS assessment recognize fluctuating and less visible disability, and that community participation funding remains based on each person's disability-related needs. The NDIS must see the whole person, understand our differences, and support the activities that foster independence. Thank you.
Thank you, Ms. Cruz. Ms. Molina.
A knowledge of traditional custodian in the land on which we meet today and pay my respect to elders and past. My name is Francis Paula Molina, and I'm here as also NDIS participant and woman from cultural and linguistic diverse background, living with disability, visible and invisible, after a work incident. I also want to let you know what has been my struggle since I have been navigating the system as a person from core background, and share how people living with disability for core background experience the system. And I want to talk about what this bill means if it is approved. Accessible, contact, and fair review. I want to explain what can happen when the communication is not accessible and a participant is not genuinely involved in decision about their plan. In my own case, an NDIS planner tried to call me several times while I wasn't attending a medical appointment and I couldn't answer. When returned the calls, I received no response. However, the review continued without properly conversation with me. One of my disabilities was removed from my plan without any discussion, that decision with me. This places me in important support for me, physical and mental health. The problem was never solvent. The services for psychological and physical therapies was drastically reduced. No one contacted me to request any future evidence. And when I tried to reach out, I got no response. As a result, I am not received the proper care I need, and this has greatly affected me. From coal background, people from coal background and experience calls and unfamiliar language and different culture understanding can make even hard to understand what is happening and changes a decision when it is wrong. An interpreter must do more than the speech the same general language. They must be able to communicate in the way the person understands, taking account of difference in dialect, culture, and meaning. A participant should not be disadvantaged because they miss a call, they could not answer, or because information was not provided in an accessible way. Because support is reduced, removed, or suspended, the NDIS should be required to make accessible attempts to contact the participant. Use an appropriate interpreter where needed. Need to check the participant wherever they are comfortable with a phone call or a video call, or it will be preferred a face-to-face meeting. As I think this time, this situation is special, it should be really relevant that he be face-to-face to support me today. So contact my participants' records, advocate or nominated, considering all relevant evidence and give the participant a real opportunity to respond. A review process can only be fair when participant is genuinely involved. Their safeguards will be prevent avoid mistakes, improving trust, and lead to unfair decisions. The another one point I want also today support is assumption about what families can provide. I am also concerned about assumptions concerning families. Amparo Advocacy works with families caring for children with significant and complex disabilities, sometimes without extended family support and well navigation, language barriers, trauma, and unfamiliar systems. Intense disability relative needs should not describe as ordinary parenting. We all understand the children's needs, the family circumstance, and wherever they carry arrangement is sustainable. When children's disability relevant support needs are not adequately met, this is affecting our field across a whole family. Parents might experience significant stress, exhaustion, and impact on their physical and mental well-being. This can be also affect the children's safe environment and quality of life. Decision on this bill should not assume that family can provide without understanding the children's actually disability relative needs, the family circumstance, their culture context, their available support networks, and wherever the caring arrangement is sustainable. Supporting children with families also means recognizing and support the family who care for them. The properly respond is to consider the whole family and situation and provide the disability relative support network for children to participate, develop their skills, and life with dignity. Before making change that affects the life of thousands of people, I believe we must ask an important question. What kind of Australia do we want to build? Do we want to Australia where thousands of people living with disability become more isolated and lose their connections to their families, communities, and essential services, or not living with their best life? Or do we want to be part of creating an Australia where every person has the opportunity to belong, that their human rights have health, equality, and contribute the life with dignity? Your decision made through this bill will be rape for below individuals' NDIS plans. They will affect every part of the life and how we exercise rights and grow in communities and families. The legacy of this reform should not be measured by financial saving or administrative effectiveness. It should also be measured by wherever people with disability remain safe, connecting, including, and able to exercise their rights. This commitment and Parliament had an important opportunity to help and share the legacy. And respectful ask, how would you like your legacy to be remembered? To be part of protecting dignity, quality, and genuine participation? Also, the future generation can look back and see the Australia choose inclusion rather than the isolation. Every person, every family, every community is matter. Thank you so much for this.
Thank you for those statements and for sharing your experiences with us. I'm going to ask Senator Steele John to ask questions.
Thank you. Thank you so much for your opening statements and for your evidence here today. Now, the bill introduces a kind of a concept or a requirement, I should say, for a new definition of functional capacity that doesn't allow for the consideration of somebody's circumstances, including linguistic and cultural circumstances. What are your concerns in relation to the application of this definition to culturally and linguistically diverse communities?
The question is...
And then I'll let the shall I let the interpreter?
Yes, please, thank you.
La propuesta de ley presenta un concepto nuevo o una redefinición del concepto de capacidad funcional que no toma en cuenta las circunstancias individuales de la persona, incluyendo sus diferencias culturales. ¿Cuáles son sus preocupaciones en relación a cómo esto impactaría en particular a personas de circunstancias culturales diversas?
Para mí sería terriblemente catastrófico porque al no tener en cuenta todo lo que envuelve ser una persona de core background living con disabilidad, no se le podrá ofrecer los servicios necesarios para apoyarlos y poder darles calidad de vida, inclusión, que es uno de los valores de Australia, y apoyarlos.
So for me, this would be a catastrophic. This would have catastrophic consequences because by not taking into account the particular circumstances of a person of cold background with a disability, you cannot possibly offer them the adequate services, support services they need, and this would not be equality and inclusiveness, the equality and inclusivity that are the values of Australia. Continúa, por favor.
Las personas que vienen de core background tienen nosotros trabajamos con personas refugiadas que realmente no solamente tienen algunas necesidades con disabilidad, sino muchos de ellos vienen con traumas y todas estas cosas son necesarias revisarlas y entender su cultura para poder apoyarlos de la mejor manera posible.
And so us people from cold backgrounds include refugees who are not only need to address issues of disability, but also on occasion traumas. And all of this needs to be carefully taken into account when you understand what support services they actually need.
Thank you. From an organisational perspective, and I'm happy for Ms. Boyd or Ms. Bruce to answer this. Given the concerns that you've outlined today, do you support the passage of the legislation in its current form?
No.
Y desde el punto de vista organizacional, y cualquiera de ustedes me puede responder, ¿ustedes estarían de acuerdo con que este proyecto de ley sea aprobado tal como fue presentado?
Amparo Advocacy doesn't support the bill in its current form. The bill should, in our opinion, should be paused and amended because the safeguards that are not in place, particularly for people from culturally and linguistically diverse backgrounds with disability. We feel that the significant amendments need to be made around the areas of the whole person assessment, contact review, about the community and participation, which would put the lives of people with disability from culturally and linguistically diverse backgrounds at huge risk.
Thank you. We're very pushed for time, so I can't ask another question, but maybe one of my colleagues will for you, Ms. Cruz.
I'm happy for you to ask a question of Ms. Cruz if you'd like to before we wrap up.
Just very briefly. In relation to the legislation, the government has said that people who lose access to the NDIS will be supported through something called foundational supports outside of the scheme. Do you have concerns about the cultural safety and accessibility of these non-NDIS supports under the government's plan?
Según el gobierno, aquellas personas que bajo los cambios en la legislación de la NDIS, aquellas personas que pierdan acceso a los servicios del NDIS, según el gobierno, van a recibir apoyo a través de otros mecanismos llamados apoyos fundacionales. ¿Qué preocupaciones tendría usted en particular en relación a la seguridad cultural y a la accesibilidad de estos servicios a través de mecanismos alternativos al NDIS?
Well, at the moment, I think is the language barrier. It's always a problem, and I can see, you can notice in this moment. I can understand the question, but I need help to understand fully the significance, the meaning, and I understand people who from cultural backgrounds could have this barrier. So yes, it's a really concern for me, the language barrier first, and also the meaning in all the terminology NDIS got. Sometimes to navigate across the system is very difficult for us as a member of NDIS, a participant. So yes, thank you.
Thank you. Thank you.
Thank you very much for your evidence today. The committee will report to the Senate on the 14th of August 2026 and has agreed that responses to questions on notice should be provided by close of business Thursday, the 6th of August 2026. Thank you very much for your time and for appearing today. I now welcome representatives from Mental Illness Fellowship Australia and the National Mental Health Consumer Alliance to come forward to the table.
Good afternoon and
Thank you.
thank you for your time.
Thank you.
Thank you very much.
Thank you for appearing before the committee today. I understand that we have Mr. James Maskey joining us in person from Mental Illness Fellowship Australia, Ms. Priscilla Bryce, Chief Executive Officer of National Mental Health Consumer Alliance, and Ms. Jen Nixon, National Policy and Research Manager, both appearing via video. I understand that information on parliamentary privilege and the protection and obligation of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, please state your full names and the capacity in which you appeal today, and I will begin in the room.
Thank you, Chair. My name is James Maskey, and I'm honoured to be the CEO of the Mental Illness Fellowship of Australia. That's MIFA for short, MIFA. And we are a national federation connecting lived experience, community service delivery and policy expertise across 1,600 staff and supporting around 12,000 Australians with psychosocial disabilities around the country.
Thank you very much. Ms Bryce.
Good afternoon. My name is Priscilla Bryce and I am the CEO of the National Mental Health Consumer Alliance, which is the peak advocacy body for mental health consumers, including people with psychosocial disability.
Thank you. Ms Nixon.
Good afternoon. My name is Jennifer Nixon and I'm here as the National Policy and Research Manager with the National Mental Health Consumer Alliance. Thank you.
Thank you very much. I will now invite each of you to make a short opening statement, following which we will ask questions. I'll start again in the room, Mr Muskie.
Thank you, Chair, and thank you, Senators. Look, from the outset, I would like to thank you. I acknowledge that you have worked through the break and you've been speedily catching up so that I can catch my flight back to Brisbane, and I deeply appreciate it. It is my daughter's birthday this weekend, so I thank you wholeheartedly.
Very important for you to get home.
Thank you. I will be direct from the outset. We cannot support this bill passing in its current form. I will say that clearly and unequivocally. We do appreciate the government's intent to put the scheme on sustainable footing and to restore public confidence, but that must never come at the expense of the people who rely on it to live safely and with dignity in their own communities. Tightening NDIS eligibility and slashing the social and community participation budget by half will not stay contained in a spreadsheet. It will be carried by the people who these supports are lost, by the families who absorb what is no longer funded, and by a health system that will meet this need anyway, only much later and at a greater cost. This is not good social or economic policy for this bill to pass in its current form. This committee's interim report surfaced real gaps and made strong recommendations to improve this bill, but real harm remains unaddressed. The 50% cut to the community participation funding still starts later this year, with no impact assessment required beforehand and no guarantee that it is safe for the people who rely on it most. The result is plain. People with psychosocial disability will pay the price for a reform that this country is not ready to make. Community participation support is not a lifestyle extra. The Disability Royal Commission found that violence, abuse, neglect and exploitation are less likely to happen to people who are seen, known and connected. Take away these supports that keep someone visible and you take away their protection. One of our member organisations delivering NDIS services told me directly this week a man they support hadn't left his house in months. A support worker kept visiting, talking with him through the door until one day he opened it. Months later, he stepped outside and eventually he walked into their office himself. Now, this is what that line item in a budget actually is. It's medication checked. It's a fridge with food in it. It's a bill paid on time. Someone who noticed before a challenge or a crisis becomes an emergency. So community and participation supports exist for a reason, and we urge this committee to exercise its leadership to recommend to government that these supports be preserved and not used to balance a budget. This bill is also not happening in a vacuum. At the same time, state, territory and Commonwealth governments negotiate the next National Mental Health and Suicide Prevention Agreement. At this same time, 500,000 people and a further 900,000 family members, kin and carers are already missing out on the psychosocial supports that they need to stay well and live in their communities outside of the NDIS. Now, if we tighten NDIS eligibility and slash funded supports, well, that number is only going to grow well beyond 1.5 million Australians. Every single one of them is a person, not a data point, a person, not a dollar sign. Senators, this bill as it stands is a budget restoration exercise that, as I've said, will not achieve that. It will instead shift the cost elsewhere, at the expense of real people, their rights and the lives that they lead. This is not the Australia that we should be building in 2026. We can and must do better, and this Parliament has the opportunity before it to do better. We're not here to obstruct reform. We're here to advocate on behalf of those that this bill would have the most consequence upon. Thank you very much, and I'm happy to accept questions.
Thank you, Mr Muskie. What I'm going to propose we do, if it's okay with representatives from National Mental Health Consumer Alliance, so we can make sure you get home for your daughter's birthday, is that we might first ask questions of Mr Muskie so that he can leave on time, and then we will move to opening statement and then questions from National Mental Health Consumer Alliance. So I'll pass the Senator Still. John.
Thank you very much, Chair, and thank you, Mr Muskie, for both risking your flight home for such an important occasion to give evidence, and also for the clarity and courage that you've shown in your statement here today. There's been a lot of talk about the need to raise revenue, and witnesses have shared with us that they feel like those vital, essential supports that enable you to get outside have been put on the chopping block. So that the government can raise a couple of bucks for the budget. Do you think that many of the people you represent would rather see the government, I don't know, tax the mining industry effectively, or maybe make gas exporters pay their fair share of tax, or maybe buy one or two fewer submarines from Donald Trump than cut these vital supports?
Senator, thank you for the question, and I thank you for your leadership in this space and the leadership that you continue to play in Parliamentary Friends of Mental Health as well as co-convener. To answer your question, the people that we support, the 12,000 Australians that our members across the country support, the people who identify with our Finding North community at MIFA, they do not want to see social and community participation funding cut. It would be drastic and catastrophic upon their lives. There are other ways to do this. As you've rightly mentioned, there are many tools available to this Parliament. Cutting supports at the cost of real people should not be one of those on the table.
Thank you. Going to the legislation, one of the changes made to the access pathway is the requirement for people to undergo additional specified treatments to prove that their disability is permanent. How could this power, in your view, be applied to people with psychosocial disabilities, and what are your concerns with that?
Senator, I have a real concern with this. The people that our network support have episodic and fluctuating mental health challenges. And I believe you're referring to the permanence test that this bill outlines. Yes.
Yep.
If somebody with a psychosocial disability sits in front of an assessor, they may present functional in that assessment. And in another moment, they may be significantly impacted by their psychosocial disability. So if government plans to pass this particular part of this bill for permanence tests, it is our strong recommendation that it is done with the subject matter expertise of those who understand psychosocial disability best and the episodic and fluctuating nature of psychosocial disability.
Do you share concerns that have been put to us by other witnesses that requiring somebody to undergo additional specialist treatments in order to continue to receive, in many cases, life-sustaining support, risks removing from people with psychosocial disabilities their practical right to choose the medical or psychological treatments that may work best for them?
Yes, Senator, I do. Choice and control is paramount to anybody with a disability. For psychosocial disability, it is no different. I am deeply concerned that this bill may overreach and may limit somebody's choice and control over the provider that they identify with and choose to seek support from.
Social and community participation, which is on the chopping block under this legislation to be cut by 50%. We have heard that these are the support work hours that often pay for the people that may check whether somebody is still taking their medication, or enable them to participate in a community activity that helps them fight the isolation or the depression they may experience. Do you think that this cut in this particular area of funding could force many participants into mental health crisis?
Yes, Senator, I do. I share this concern deeply. Our health system across the country is already overburdened and at complete capacity. There are already 500,000 people missing out on psychosocial supports outside of the NDIS. Cuts to social and community participation funding may well indeed escalate this challenge further. It may exacerbate underlying problems in community, and it may cause people to slip through the cracks and not seek the support that they need. The cuts of 50% are catastrophic, as I've mentioned. And I have heard commentary from the government and from others concerned with this bill that that particular budget line, well, it's underutilised. It won't have a drastic impact. Well, I can tell you very clearly with confidence and with evidence that for the psychosocial disability community, this is a very utilised budget item. In fact, one of our member organisations in Victoria, the work they do for NDIS, 96% of the funding for their services and their supports that they provide come from this exact budget line. We're talking about very real cuts that have drastic impacts to very real people, and I am deeply concerned.
And just finally, so I can let you go, do you believe that if this legislation goes through and these cuts are implicated, do you think there is a risk to the physical and mental health safety of psychosocial participants?
Very clearly, Senator, yes, I do. And I think that is actually a brilliant place to leave that particular question. I am very clear. I have very real concerns. This bill should not pass in its current form. Further work is required, and that is something that we say resolutely and very clearly.
Thank you. Thank you so much. Thanks.
Thank you, Senator.
Thank you, Senator Steele-John. If you have time, I understand Senator Tyrrell has a question, so I will pass to Senator Tyrrell.
Thank you, Chair.
Thanks, Chair. Thank you so much for being here today, and happy birthday to your daughter. Why do you think it's important that the NDIS continues to exist for future generations of people with a disability?
Thank you for the question, Senator. This has been a remarkable scheme that has had so many drastically positive improvements on people's well-being. It must continue so that people who are diagnosed with psychosocial disability and their family, kin and carers can continue to receive the supports that they need. And these supports, I will say clearly, are life-saving and life-changing and life-restoring. It will help people stay well, connected and recovered in their communities rather than escalating them into hospital and acute care. This is a life-changing scheme. It must remain, it must be funded, and cuts cannot come at the expense of real people who live real lives in community. Thank you, Senator.
Thank you.
Thank you very much, Ms Damaski. Happy birthday to your daughter.
Thank you.
It's in the Hansard now, so you can show her.
I will. Thank you,
How
Senator.
old is she turning?
She's turning 6.
What's her name?
Nora.
Happy birthday, Nora, from all of us. So if you can sit and listen for as long as you would like and chip in for as long as you like with our other witnesses, but feel free to leave when you need to. I will now ask the National Mental Health Consumer Alliance to provide an opening statement, and thank you very much for your patience this afternoon.
Thank you, Chair, and members of the committee, for inviting us to appear at this hearing, and we acknowledge the traditional custodians of the lands we're all joining you from today. The Alliance is the national peak body for mental health consumers, including people with psychosocial disability, and it is led entirely by people with a lived experience of mental health challenges. Through a federation of state and territory consumer peak bodies, we bring forward the voices and experiences of mental health consumers from communities across Australia directly into national policy discussions. At the outset, I want to be clear. The Alliance supports a sustainable NDIS. We recognise the government's responsibility to ensure the scheme remains viable for future generations. However, sustainability cannot be achieved by weakening rights, restricting access, or shifting responsibility onto people with disability, their families, and already overstretched service systems. When people with psychosocial disability lose supports, their needs do not disappear. The cost of support is simply transferred elsewhere to emergency departments, acute mental health services, homelessness services, carers and families. Reducing access to the NDIS for people with psychosocial disability does not remove costs. It simply shifts them. Our concerns remain about the requirement for people to undertake all appropriate treatment before their functional needs can be considered permanent, despite the amendments specifically excluding restrictive practices. We have two key points to make here. First, there is no nationally agreed definition of chemical restraint across the country, nor is there any national legislation covering chemical restraint in the mental health sector. Without an agreed definition, no national data about chemical restraint can be collected, and so mental health institutions are not being held to account. This means consumers continue to experience medication being administered against their wishes under the false justification that it is being provided for therapeutic purposes. Not having a nationally agreed definition creates a risk of inconsistent interpretation and decision-making. Second, we are particularly concerned that intensive psychiatric interventions, such as electroconvulsive therapy or ECT, could potentially be viewed as evidence of appropriate treatment that a person should pursue before they can access disability supports. ECT is a publicly available treatment funded through Medicare and recognised in some jurisdictions as a treatment option for certain mental health challenges. ECT also causes harm to many people, such as memory loss. The legislation should make it clear that access to the NDIS cannot be contingent on a person accepting a particular medical intervention. Stronger safeguards are needed around the interpretation of the terms appropriate treatment and chemical restraint. Finally, the bill assumes that alternative supports exist outside the NDIS for people with psychosocial disability who lose access to the NDIS. In many cases, they do not. We know from the government's unmet needs report that around 500,000 people with psychosocial disability do not receive supports because these supports do not exist. We understand that reform is necessary to ensure the NDIS remains both financially sustainable while continuing to support people with disability. However, reform must not come at the expense of choice, dignity, personal autonomy, and access to the services and supports that people living with psychosocial disability rely on to participate in their communities and live a good life. We urge the committee to ensure that any reforms preserve the rights-based foundations of the NDIS and protect the autonomy and support needs of people with psychosocial disability. Thank you, and we look forward to answering your questions.
Thank you very much, Ms Bryce, and I will start with Senator Steele-John.
Thank you very much for your evidence, Ms Bryce. Can I just take you to the concerns you just shared about electro shock therapy and your interpretation of the legislation in relation to whether it could be something that is required of a participant. Let me reframe that because it's a slightly complicated way of saying. Just to clarify, from your reading of the legislation, is it possible that a government, this government or a future government, may require a participant to undertake electroshock therapy before being eligible for the NDIS?
Thank you for the question, Senator. Yes, that is absolutely our reading of it, that it is possible the government would require a person to undertake ECT, or for that matter, other types of treatments that they don't wish to, simply so that they would be eligible. I'll also pass to my colleague, Jennifer Nixon, who is here too, in case she wants to add anything.
Thanks, Priscilla, and thanks, Senator. That is correct, and we have sought some additional information from the Justice Equity Centre as well, and they agreed with our thoughts that indeed may happen given how the legislation is currently drafted.
Okay. And are there other forms of treatment that you are concerned that the current legislation as written would allow a future government to make mandatory for those seeking access to the scheme who have psychosocial disability?
Yes, Senator, there are some interventional pharmaceuticals that would also pass the current legislation. I can provide their names on notice.
Okay. And for those that may not be familiar, what are the conditions currently for which electroshock therapy is recommended?
Okay. People are provided with ECT for persistent and long-term depression. And some people are provided it either voluntarily, or you can also be provided or given it involuntarily. But usually, yeah, so for long-term mental illness and psychosocial disability would usually deliver from that.
And in situations where somebody is not under one of the legal structures that then result in somebody undertaking a treatment that they don't consent to, because that is a whole area of Australian law that is, deeply problematic, but not specific to the NDIS. So in those situations where somebody may voluntarily be considering such a treatment, what are the kinds of things that they usually weigh up when considering if that course of action is right for them?
Usually the severe impacts of ECT, which can include short-term to long-term and enduring memory loss. That's the main concern with ECT.
And it's my understanding that those impacts are sometimes weighed by somebody considering the treatment, and they decide that that is a risk they're willing to take. That's correct. Some people voluntarily decide to undergo the treatment.
That is correct, Senator. But we would like to state that that's often on the advice of a clinical provider.
Absolutely, and that's exactly where I was going. So at the moment, it's a thing that you can decide to do if you feel it's right for you after having the advice of your trusted clinician or a professional. What you're saying to us, though, is something very different, which is the law as written could enable a government to require a participant with with what they consider to be a long-term psychosocial disability, anxiety or depression, for example, to demonstrate that they have undergone ECT before accessing the scheme.
That is correct, Senator. It is our understanding that if someone has long-term mental illness or mental health challenges that indicate for treatment with ECT under the way the current legislation is written, that could be one of the things they need to do before they get deemed permanent.
Okay. Thank you. That is deeply, deeply concerning to me, and I think it will be to a lot of people watching this. In terms of the definition of functional capacity introduced in the legislation, the bill will enable the requirement of participants or prospective participants to have to demonstrate a substantially reduced functional capacity in order to gain or retain access to the scheme. What are your concerns about how this concept of a functional capacity test that is explicitly legislated so that it cannot consider environment, social circumstances, barriers in the community that they may live in? What are your concerns about how that may impact psychosocial participants?
Do you want me to go first, Jen?
Sure.
I think if the way that functional capacity is our understanding of how it's described, it means that, sorry, I've just lost my train of thought. It's gone.
That's it. You can take it on.
I'll jump in.
On no, you can also take it on notice.
You could take it on notice, but
please go ahead, Ms. Nixon.
I guess the biggest issue we have also with the functional capacity test is the, as James Maskey just explained, we have psychosocial disability. People can fluctuate between having very high functional needs to having moderate functional needs. It just depends on where they are at the time, not including things like geography or financial or where you live. Really, really big problems, especially for people in regional and remote areas who may not have access to any other supports. So if they're not taken into account, then that can actually cause, we're quite concerned about that.
Okay, thank you.
Can I just add to that? In addition to what Jen's just said, it also depends what circumstances that person is in as to their functional capacity. So somebody might have exactly the same diagnosis, but it might look very different on a person without a job or without a home to a person in, say, a highly paid role who is quite secure in their life, has access to everything they need generally. Functional capacity doesn't just go up and down because of mental health challenges, but also life circumstances, which then affects or exacerbates mental health challenges.
Thank you. And can I just conclude by asking you, given the concerns that you have raised today, do you support the bill passing in its current form?
Absolutely not, Senator.
We don't support the bill passing in its current form.
Thank you. Thank you very much. I really appreciate your evidence today.
Thank you, Senator Steele-John, and thank you for appearing today. I just have a couple of brief questions. Just on the topic of all appropriate treatment and the concerns you've raised with ECT, my understanding of the bill is that there is a carve-out in the access definition that allows rules to be made to specifically exclude certain treatments from the all available treatments test. If it were the case, and I think the Minister has said this, but if it were the case that ECT would be an example of a treatment to be excluded, what are your views on that?
It would still leave. I was just going to say it would still leave other treatments, such as chemical restraint. So it would be fantastic to have ECT removed in that way. Mm-hmm. But ideally, we would have a much longer list than just ECT when it comes to treatments for people with mental health challenges, which would include all forms of what we would call chemical restraint.
Mm-hmm. And then I guess the other question goes to consent and how that is taken into consideration. in that all appropriate treatments consideration. And so what are your views on consent and how that should be considered?
I think it's up to the person who, I'll pass to Jen in a moment. I think it's up to the person who is taking the treatment as to whether or not they take it. It's bodily autonomy. Each of us should get to choose what treatment looks like for us because we know our minds and our bodies best.
Thanks.
And I'll just add to that, if I may. The other part of informed consent, of course, is to know the information that is actually going to help you make that decision. And we know that at the moment, Australia-wide, decisions are being made based purely on clinical evidence and clinical discussion. There is no lived experience information that's readily available to people to be able to assess whether it's what they want to do based on the impacts. It's mainly a clinical decision, so that impacts on consent.
Thank you. I think Senator Tyrrell has one question to finish off this session. So
I'll
to
just
you,
have
Senator
one
Tyrrell.
additional clarifier after Senator.
Okay, I'll come to you first, Senator Steele-John, and then to
Well,
Senator Tyrrell.
thank you. Thank you both. I just want to follow up on the line of questioning from the chair. Because I've read, and I'm sure you've read too, the ability in the bill to craft such a rule to list things like electroshock therapy as excluded treatments. And I can almost hear, after the strength and clarity of your evidence, government advisors hurriedly sending off text messages explaining that to journalists throughout Australia. My concern, and the concern of many other witnesses, however, is that though a minister may make a rule such as this under the Act, it is within the power of that minister or any other future minister to write a new rule that could remove electroshock therapy from any such excluded list and put it back as something that people could be required to undertake. Do you think that this level of uncertainty around whether a government could require of its citizens that they undertake such a treatment is an appropriate thing for this community to have to live with day to day?
No, Senator, not at all. And I think that's one of the most concerning things with this bill as well, is that so many things are going to be based on a list that's being made that hasn't been made as yet. And so, yeah, it doesn't weigh my concerns at all.
Thank you. And do you share my reading of the legislation that although a rule could be written, a subsequent rule could override that rule and so on? That's in line with the advice you've been given?
Yes, indeed, Senator.
Thank you. Thanks, Chair.
Senator Tyrrell.
Mr. Matthew, before you just
We don't have Mr. Maskey in the room any longer, Senator Tyrrell, so just the National Mental Health Consumer Alliance. Apologies.
What future?
You're just cutting out for us in the room. I'm not sure whether it's the same for the witnesses, but perhaps do you want to give that another go?
Can't hear you.
What?
No, we can't hear you, Senator Tyrrell. That's okay. We might ask Senator Tyrrell to put that question on notice. It might be a connection issue in Tasmania, sadly. Well, thank you very much for your evidence today and also for your patience as we have been running behind time. The committee will report to the Senate on the 14th of August 2026 and has agreed to take that responses to questions on notice should be provided by close of business Thursday the 6th of August 2026. I understand we have representatives from Down Syndrome Australia Consortium, Inclusion Australia and National Disability Services joining us online. Just confirming that they are online. Excellent. Thank you for appearing before the committee today, and I particularly want to thank you for doing so on what I know was very short notice last night. We had a gap in the program and we wanted to give you an opportunity to provide evidence, so thank you. I understand that information on parliamentary privilege and the protection and obligation of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, I will ask you to each state your full name and the capacity in which you appear today. I will begin with Down Syndrome Australia Consortium.
Thank you, Chair. My name is Darryl Steff. I'm the CEO of Down Syndrome Australia, representing the Down Syndrome Australia Consortium.
Thank you, Mr. Steff. Inclusion Australia.
Thank you, Chair. My name's Maeve Kennedy. I'm the CEO of Inclusion Australia. We represent people with an intellectual disability and their families.
Thank you, Ms. Kennedy. And National Disability Services.
Thanks, Chair. Michael Brusco, CEO of National Disability Services.
And thanks, Chair. Karen Stace, Director of Policy and Advocacy, National Disability Services.
Thank you very much to all of you. I will invite you each to make a short opening statement, and at the conclusion of those statements, I will invite members of the committee to ask questions. Again, I will begin with Down Syndrome Australia Consortium. Mr. Steff.
I might actually pass to Ms. Kennedy, if that's okay.
Sure,
You've got a
absolutely.
statement. Yeah, thank you.
Yep. Ms. Kennedy, please go ahead.
Thank you, Chair. Thank you for the opportunity to appear today. Inclusion Australia is appearing.
Ms. Kennedy,
Down.
my apologies. I'm just going to remind other witnesses and other senators on the line to just mute. We're just getting a little bit of feedback. Yeah. So I want to make sure we can hear Ms. Kennedy. I think that's better. Please go ahead.
Testing now.
That's better. Go ahead.
Beautiful. Thanks very much. Inclusion Australia appears jointly with Down Syndrome Australia and National Disability Services today.
Sorry,
Ms. Kennedy. I'm sorry. We've still got feedback. I'm just going to check for a moment and see whether there's anything the Secretariat can do on our end. I'm not sure if you have colleagues or someone around you, Ms. Kennedy. Yeah.
It may be background at my end. I apologise.
It is.
It's very difficult for us to hear you. Perhaps could we go to someone from National Disability Services to kick off, perhaps, and then in the meantime, perhaps Ms. Kennedy can either find a quieter space or ask her colleagues to keep the noise down. I know that's challenging in an open workspace. So I'll go to National Disability Services first. Thank you.
Oh dear.
Is that you, Maeve?
No, that's us.
No, go ahead, Mr. Brusco.
Sorry. Okay, sorry. This is...
no, that's okay. It's all good.
Very clunky, Chair.
That's all right. We'll keep on keeping on.
I will. I'll open up the statement. So first of all, I want to thank you and thank you for the opportunity to appear today. We really appreciate you fitting us in. We are appearing jointly on behalf of Inclusion Australia, Down Syndrome Australia Consortium and National Disability Services because organisations representing people with disability, families and providers have reached the same conclusion. We support the government's objective of a sustainable NDIS and we welcome the improvements that have been made to this bill through consultation amendment and the revised explanatory memorandum. Importantly, the government has made clear that these reforms are not intended to undermine essential supports, participant safety and employment outcomes. Those improvements are important. We remain concerned that they do not resolve the central implementation challenge. The bill relies on broad ministerial powers and future support determinations to shape what supports can and cannot be funded. While the government has provided important assurances about how those powers will be used, we remain concerned that foreseeable unintended consequences could arise unless Parliament also legislates the practical safeguards needed to implement them safely. We are here today because we want to ensure the government's intent is realised. Our shared experience tells us that participant safeguards cannot be left to chance. I'll now hand to Daryl from Down Syndrome Australia Consortium.
Thank you, Michael. As we've outlined, we support reforms that ensure that there is a sustainable NDIS, but we do not support broad ministerial powers that reduce or cap funding at levels below what has been deemed reasonable and necessary. So if Parliament is to proceed with this approach, it's essential that it is accompanied by robust implementation safeguards. Otherwise, what we will see is unintended consequences, many of which are unfortunately foreseeable. Broad determinations cannot adequately reflect the complexity of how people with disability actually use their supports. For many people with disability, outcomes such as 24/7 supports, employment, independence and safety rely on a combination of supports, which will include social, civic and community participation supports, and those supports all working together. When one part of that package changes, the impact is rarely confined to a single support. It can therefore affect a person's ability to work, maintain those essential support routines and to live safely, not to mention the impact that it may also have on informal supports. Implementation has to recognise that those interconnections if the government's intended outcomes to be achieved. We do believe that the government understands these issues. The question is how the right outcome is delivered in practice. That's why, if in the event these powers are to remain, our recommendations represent the absolute minimum protections that need to be in place to make this approach safe in practice. I'll now hand back to Michael to outline those measures.
Thanks, Daryl. Our organisations believe 4 additional measures are required. First, participants who rely on continuous or 24-hour supports should be exempted from future support determinations because we believe this is the only way in which to guarantee their safety. Second, all supports that enable people to obtain, maintain and succeed in employment should be included within the carve-out for employment supports. Third, where implementation will create serious safeguarding risks, there must be a formal escalation pathway so issues can be identified early and addressed quickly. And finally, the transition to the new planning framework should correct existing planning anomalies for participants with complex needs so risks are not compounded. These are practical and essential safeguards designed to ensure the reforms deliver the outcomes intended by government, while at the same time protecting participants whose support needs are the most complex. Thank you.
Thank you very much, Ms. Prusco. I will see now whether we can go back to Ms. Kennedy.
Hello. My apologies.
That's okay.
Michael has
go for it. That's much better.
Thank you. Michael has covered what we were going to share. We developed our statement together, so I will leave it there, Chair, for now.
Okay, excellent. Thank you. We will move to questions, and I'll first go to Senator Steele-John.
Thank you so much. So let me just kind of draw you out a little bit on the proposed protections that you are advocating for here. So first of all, I just want to be clear on the cohort that you are describing for us. So you are suggesting that participants who receive 24/7 supports are carved out from ministerial support determinations. So for those participants, any ministerial support determination made would not apply. Is that right?
I'm happy to jump in first. Yes, Senator, that is correct. What we're saying is, we've seen the government in their explanatory memorandum, including the wording that they say people with 24/7 supports and critical supports are not intended to be affected. What we're saying is that it's unclear if this legislation goes ahead what that mechanism will be. we do think it needs to be an explicit carve-out, people who need 24/7 supports. And that's mainly due to the complexities of the interactions of supports that I explained in the opening statement.
Yep. Okay. And to be clear, when you say to us 24/7 supports, are you talking about people who receive and require the support of a support worker or workers, like all day and all night, or are you referring to 24/7 supports as it is defined by the government and the agency, which is a duration of support worker hours greater than 8 hours, I believe it is at the moment?
Yeah, it's the latter, Senator. A duration of support work hours of greater than 8, some form of overnight support as well, and that high intensity types of supports that are required.
Okay, so they would be exempt from the ministerial support determinations, and that would mean that the 50% cut to social and community participation, for example, or the 10% cut to capacity building, or any other cut made via a support determination, or a determination in relation to pricing or maximum expenditure for a type of support wouldn't apply. Is that what you are proposing?
That's right, Senator, and you correctly picked up on the fact that this is not just the support determinations in relation to SECP and capacity building. We anticipate they would also imply in the event that caps to funding or ratios, etc., were implemented.
Okay, thank you. I think you've given us a really clear picture of what you are proposing to us. Can you just explain in as a kind of accessible way as possible the risks to the participants that you represent as organisations of the legislation in its current form without the changes that you're proposing? I might go to Ms. Kennedy and then work from there.
Thank you, Senator. So to take, for example, just one area, the support determination and the social, community and civic participation funding reductions, for people with an intellectual disability, who we are all here to talk about, SCCP supports are much more than social activities. They're very important preventative supports that help people stay safe, healthy, independent, connected to their community, and for many, as Michael said, able to work. So these supports are what many people need to, for example, be prompted to take medication, prepare meals, attend medical appointments, develop routines, build relationships, travel safely, and maintain their informal support networks. They often prevent crises and reduce the need for more intensive supports later. They're fundamental for people living ordinary lives in their communities. So cuts to social and community participation will lead to greater isolation. We know from the Disability Royal Commission that isolation is a very unsafe condition for people to live in, that access to community is vital for safety. There are really significant risks when people don't have access to support workers, when there are not eyes on people. So some of the earlier evidence that you heard today as well is about safety being visibility. The more people are in someone's life, the more people who know somebody, the more safeguards there are. If something does happen, the more people who will pick that up. So not only are we reducing those aspects, but the proposed legislation will actually take away the funding that contributes to some of those active supports, leading to conditions like people not getting preventive health care, conditions worsening, not making healthy choices with eating. You know, a lot of people, conditions will get worse, which will lead to flow-on costs for other healthcare systems. And as the other witnesses have said today, also really significant impacts for family members as well.
Okay, thank you. And for people with Down syndrome, for example, there would be additional risks, Mr. Steff, to that community specifically?
I think a lot of similar risks, Senator, but I think just to expand on a couple of things that Maeve touched on there, I think around the some of the supports that might sound relatively routine, like assisting someone to go shopping. Now, that shopping might be, that assistance might be the assistance that helps them make healthy choices about what they're buying, that then prevents other broader health issues that impact their disability.
Yeah.
And I think the other thing to touch on there is, or to emphasise that was mentioned, is the importance of the employment supports. And we do note the amendment that was put up, and thank the Greens for their work in that around employment supports. We're keen to emphasise that needs to be all supports that enable people to obtain, maintain and succeed in employment. As you're aware, people use employment supports very differently, and we need to make sure that they are all included in that carve-out so that people are not impacted by these cuts.
Absolutely. Okay, so you've made for us a very compelling case for the amendment that you are proposing and the risks if it isn't actioned. Have you had any success in your conversations with the government around these amendments?
Look, I think, as we mentioned in the opening statement, we welcome some of the changes that we've seen and have been mentioned in the explanatory memorandum, but we don't feel that they go far enough at the moment. And particularly if we were to talk about the escalation pathway, we see that good safeguarding needs to be proactive. It needs to identify the risks early, coordinate the right response and prevent people from falling into crisis. And therefore, the wording that has been included in the explanatory memorandum, we don't feel goes far enough to define what that safeguarding and escalation process needs to be. And we are asking for a two-pronged approach, essentially, a systemic preemptive pathway that, and we'd like to see that the NDIA have a clear legal responsibility to escalate concerns when support arrangements could become unsafe, not simply respond after serious harm has occurred. And then we think there also needs to be an individual mechanism where, there are people whose supports have been impacted and they are now currently at risk of harm. But I'm not sure if Karen, you want to add anything else to that, or Maeve?
Yeah, I might add, if that's okay, and then obviously defer to Maeve. I think we've been encouraged by the discussions that we've had with government. We believe that they understand the issue and the significance of the issue. We think that we're both wanting the same outcome. However, we remain convinced, and our collective experience tells us, that for people with 24/7 support needs, the only way to ensure that they continue, that their supports are continuous, that there's no impact on their 24/7 support needs, that they're not left with gaps in their supports, is that they do not have the support determinations, and particularly the support community participation reductions apply to them. We think that's the only way to do that safely. I guess what I would add is that Maeve and Daryl have done a really fantastic job about talking about the impacts on the groups that they represent. What we see particularly from our members and what we hear is that for people who require 24/7, where they receive that in a supported independent living environment, for example, those supports are quite complex. They're made up in different ways. Often those environments are, they're shared households. So what happens for one person really impacts everybody else that they're sharing their household with. So the example where the 24-hour support that people are requiring might be made up of 16 hours of support that's funded in the home, but that other 8 hours is made up through those community participation supports. So if they're cut by 50%, that leaves a gap. And in our experience, and what our members tell us, is that providers are often picking up or are concerned about needing to pick up that gap in an unfunded way. We also hear reports, building on what Maeve and Daryl are talking about, is, where those where support needs are not met, where health conditions are not supported, where people aren't supported for that preventative health care or even more significant issues, that we anticipate that those individuals may end up actually in the hospital system and in our other systems. And we think that, you know, in terms of sustainability of the NDIS and good outcomes, preventing that and acting really proactively, you know, is a really, really important way of continuing and contributing to sustainability as well.
Okay, thank you. Look, we are a little bit pushed for time, and I would very much welcome you to provide us with any additional information you would like to around these amendments that you are proposing, noting, of course, that there's a deadline for that that feedback. Just finally, we've heard evidence about the new proposed functional capacity assessment. We took evidence yesterday from a range of allied health professionals who shared with us their concerns. It seems that this functional capacity as legislated, this assessment as legislated, will explicitly not take into account your broader circumstances, your environmental circumstances, the context in which you live, in a way that no functional capacity assessment to this point yet yet in use has kind of done. Are you concerned about what the implementation of this functional capacity assessment could mean for the groups that you represent?
Senator Maeve speaking from Inclusion Australia. Yes, broadly is the short answer. The long answer is it is another part of the bill that we just do not have enough information about implementation yet. And while there are assurances that this won't have that there's no intention to cause negative consequences to people, we are worried about that. We would encourage the use of validated tools, including the World Health Organization, ICF, which really does see environmental considerations and contextual considerations as an inherent part and not able to be separated out.
Okay, thank you. And I'm assuming that if these amendments, we're considering a piece of legislation right now that doesn't have these amendments included, and so your position would be that the bill in its current form shouldn't proceed, correct?
Correct, that's our position.
Is that the same for DSA and NDS?
Same for us, Senator. Like we support reasonable reform to improve the NDIS, but these current legislation does not come with appropriate safeguards, so no, in its current form we do not support it.
Same for NDS.
Thank you very much, and once again for your clarity and advocacy in this space. Appreciate it. Thank you. Thanks, Chair.
Thank you, Senator Steele-John, and thank you to all of you for appearing today. We have reached the end of our hearing time, so I will let you know that the committee will report to the Senate on the 14th of August 2026 and has agreed that responses to questions on notice, of which I believe there was one, should be provided by close of business Thursday the 6th of August 2026. That concludes today's hearing. Thank you to all the witnesses who appeared today, to the committee staff who worked very late last night trying to secure witnesses, so thank you. And thank you to Hansard and Broadcasting for their assistance. The committee now stands adjourned.